But after taking leave from Justice Uday Kumar, my lord, and mentioning a matter of Justice What's Justice Proceedings, Dismissal, my lord, a review application, my lord, in the Jalpaiguri bench,
When I sit singly, this will appear.
Principal bench, my transfer to principal bench, my lord. Matter.
When I sit singly, it will take be
No,
taken
no, division bench matter.
with justice.
With Dismissal, my lord. Proceedings Dismissal, yes, my lord.
Justice yes.
Daily division. I mentioned earlier, my lord.
Justice Proceedings বিষয়ের সঙ্গে আরেকটা ম্যাটার আছে.
Yes, sir.
We are not getting a time, common time.
Yes, I feel, my lord.
Whenever we get time, we'll fix
Yes,
this.
yes, my lord.
Yes.
Mentioning for non-prosecution.
Please.
My lord, I am mentioning for inclusion of an appeal for admission, your lordship, of 2025, rejecting my from an order rejecting
Admission,
my
we
claim.
don't have determination now. Admission hearing goes to Justice Show mention.
For inclusion, my lord, matrimonial appeal prepared by the husband, my lord.
Hearing.
My lord.
Yes.
Yes,
Yes.
my lord, I am mentioning one matter. Matter was appearing under the heading to be mentioned in code number 16 for mediation. Today is not appeared.
My lord, I want to mention FAT 279.
Yes, next.
My lord, I want to mention FAT
You-
279 for inclusion in
louder.
the list. FAT
What
FAT
matter?
279.
Yes.
FAT 279 2025 inclusion in the list, my lord.
The application for restoration.
Application.
For restoration.
Hand over restoration application. All the applications, please hand over without mentioning.
May I have the
Applications hand over without mentioning. The others, please wait. Yes.
The title execution matter will be it will be executed on 25th August, and if it is not heard before your lordship,
What is the appeal against?
the stay order, the suit number is stay suit.
Eviction suit. First appeal, you don't have regular determination, ma'am. You have to mention before code number 16. Yes.
My lord, may I have your lordship's kind leave to file an appeal without certified copy?
Yes.
My lord, I am praying leave, my lord, to move an urgent mandamus appeal, my lord, without certified
Land matter.
land matter. My lord, my lord, 18th is the day for eviction.
Without certified copy, leave is granted.
My lord, on day after tomorrow, my lord.
Period day after tomorrow.
My lord,
Leave
my lord,
granted.
take
Day
leave.
after tomorrow. Yes.
My lord,
Yes. Yes.
For inclusion for final hearing,
What matter?
for land matter.
Yes.
My lord, hearing for group 8 matters.
Group 8, I don't have determination. We don't have determination.
Group 8,
Please.
group 8, my lord.
Group 8 আমার আছে নাকি? Group 8 we don't have. We have group 1. Group 8 আছে আমাদের?
Group 8,
Group 8 কবে থেকে হলো?
essential commodities.
আচ্ছা এটা আছে। Sorry, please hand over.
Our
You are getting confused.
and
Those-
answer is
The determinations are changing so
hearing.
frequently. Yes.
Matsuit are a hearing matter.
Matsuit, yes.
I'm having your lordship's kind leave to mention an appeal for inclusion, your lordship.
What appeal?
Your lordship for specific performance of an agreement, and we had filed an
That's a regular first appeal. You don't have determination.
post miscellaneous appeal tender, your lordship.
We don't have determination in regular matters. Yes.
My lord, inclusion in the list.
Please take the microphone.
My lord, inclusion in the list.
What is the matter?
Guardianship.
For what? Hearing or
No, my lord, just application.
application?
Yes.
Hand over.
Lordship, may I be permitted to mention it's a group 1 appeal, land appeal.
Yes. Mention.
Lordship, there was a direction passed by the Honorable Division Bench of Justice Boshak. Lordship, directing the matter to appear after a fortnight. Lordship, that time frame is
Yes, we'll
Oh.
put it on the list. Yes.
Lordship, grateful, my lord.
Seeking leave to file the mandamus appeal matter land acquisition matter without certified copy and let it be listed more.
Day after tomorrow? Yes. Leave is granted. 8 day after tomorrow.
The application will be seen.
Yes. What was the nature of the contempt?
Lordship,
You are the
direct-
petitioner.
yes.
What was the
Their
nature of the
occasion-
what was the nature of the contempt?
Contempt is a-
আচ্ছা 1 minute, please wait 1 minute. এই যিনি অনলাইন মেনশনিং করছেন তারটা শুনে নি ওনাকে yes ma'am, you are mentioning something online. Yes.
My lord, I want to mention FAT 279 for inclusion in the list. And as I am staying in Delhi, if you can please provide me the date of 21st, because 21st I will
What
be
is
in
the
Calcutta.
what
I
is the
want
matter
to-
against? Is it a matrimonial matter?
This is a matter that has been rejected by District Consumer Forum. That was the case with Tata Capital Housing Finance Service
No.
Deficiency case.
Commission consumer forum, we don't have usual determination.
Consumer Forum rejected the case with merit.
You have to you have to
After-
mention before justice the code number 16. That bench has the determination. We don't have
Under
determination.
My lord, I under Article 226, I had come to High Court.
Under Article 226, that we don't have consumer forum appeal determination. Please move before the appropriate bench. We don't have determination. We don't take up these matters, right? Call on the list. Yes. Yeah. What is the alleged?
Earlier occasion, your lordship, please to
What
direct.
is the order under contempt?
Yes,
What
my
It
lord.
is, order is
Can I
a,
explain, my lord?
Yes.
My lord, they have suffered a decree. Your lordship has granted, my lord, the conditional order of stay. They have not paid the, my lord,
lord-
occupational charge. In the meantime, my lord, they have transferred the decreed
No,
property to a
it's
third
not
party.
trans.
It's your contempt application.
No, my lord, your lordship has shown
Suo
moto.
moto contempt. My lord, kindly,
Oh, they had handed over to somebody else.
Yes, my lord.
no, my lord, kindly permit to submit that. My lord, earlier occasion, your lordship permitted to file a affidavit for the deposited for the additional documents. The petitioner rely upon. But my lord, that we are submitting that documents, my lord,
Great. Keep those with you.
and
Submitting documents with regard to what?
as
The
per
contempt application.
is your lordship earlier occasion leave to grant affidavit to produce for the documents, my lord. Additional documents, my lord.
Yes. So you're filing that.
Yes,
It's a
and
show cause
show cause
with documents.
documents, my
Have you
lord.
given copies to them?
Yes, already it is a served, my lord, as per the affidavit, that tenancy bill and the agreement, sale agreement, as they executed between the then owner and that present owner. That page number, kindly see that page number 28, my lord. Kindly see page number 28, the rent bill, my lord, as issued by the then owner and present
How
say,
does it make a difference?
and now I am submitting that as per the deed executed between the present owner and that father of the defendant, my lord.
We cannot go into the merits of the appeal.
My lord,
We had passed, you had challenged an eviction decree. We had granted conditional stay upon you paying some amount
yes,
so that they cannot evict you.
yes,
Now to bypass this process, you have
I do not-
transferred the property to somebody else
yes,
without paying a single penny.
my lord,
Why should
I
this
do
not be constituted as contempt to
Yes,
bypass the order of the
that's
court?
why, my lord, kindly allow me that my client do not bypassing your order, my lord, just surrender the northern portion. As per
Northern
the,
portion is not a part of the decretal property.
not a part of the digital property, my lord. It is that as per the
The eviction decree was not passed in respect of the northern portion.
not portion, because that deed already executed.
Before our order.
Yes, your order and learned court orders, my lord.
Before that, it was transferred.
Yes, that decree, that sale agreement passed between that defendant and that Pitam Gupta.
Who is Pritam Gupta?
Pitam Gupta is that current owner, my lord. As kindly peruse that page number.
Decree agreement for sale does not create a
Agreement
title.
for not it is sale agreement, sale deed, my lord. Kindly see that.
It was executed by their predecessor
Yes,
in favor of a third party.
yes, and now is the
That
present
portion
owner.
you have surrendered.
Yes,
Yes, what do you say?
My lord,
kindly
this
see
is
my
our
lord.
rejoinder.
And they are actually
take
claiming
your
that third
defense,
party. It is
please.
not third party.
Yes, my lord. If your lordship kindly comes to the page 11 once. My lord, this is in reply to my lord scan 4. Scan 4 I have filed for vacating stay. Page number 11, paragraph 6. Fourth line from the top. And thus, sorry, fourth line in the paragraph 6. Thus, he has forced to surrender the suit room of the said premises to the present landlord, that is Pritam Gupta, on 21 to 2025. That is after passing of the order of stay.
What about this your sale deed to Pritam Gupta?
My lords, that is where the dispute is. My lords, admittedly, a portion of the property has been sold to Pritam Gupta. That is northern portion of the property. He is admittedly a tenant in the northern portion of the property. Now this decretal property is the southern portion of the property. The property is demarcated.
They say
And-
they have surrendered only the northern portion.
Northern portion.
Malas, that is why Malas, the decretal property is Malas, the southern portion. They have
So they have
said
not transferred the decretal property.
Malas, they have
This
said
is a
so.
wrong statement.
Malas,
They say they have surrendered the northern portion, which is not the decretal property.
Malas, in their surrender, Malas, because they are explaining it, it is the southern portion of the northern portion. That is what their explanation is.
So show us that. Even if it is the southern portion of the northern portion, there are two aspects of the matter. One is the entire property. There is a northern portion. There is a southern portion. If they surrender the southern portion of the northern property, that means it's a part of the northern property, which
Yes,
is not the subject matter.
Malas, they are explaining it to me, but Malas, they have said this room. That is why, Malas, your lordship has initiated the contempt, and they have
That is-
submitted that before this.
No, we initiated the contempt. Initiation of contempt was prima facie. They did not take a stand. They did not appear. Therefore, we had to issue a rule. Now they have explained, given a show cause, saying that they have transferred a portion which was already transferred by you to a third party. One, secondly, that is not a part of the suit property. You are also saying southern portion of the property is a part of the suit property.
Malas,
To satisfy us from their sale deed that they have transferred a portion of the suit property. Let us compare that with the decree, the schedule description.
and Malas, if your lordship kindly see your lordship's order passed in 16.
Our order was that was at an ad hoc basis. Now you have to. This is the final hearing of the rule.
Yes,
So you satisfy us from their deed that it does tally with this suit property.
Malas, they have submitted before this court that we have
We are not
transferred.
interested in the submission. They have annexed the deed. So let us see from the transfer which portion they have
Malas,
surrendered.
admittedly, they are the Malas tenant in the northern portion, obviously. Malas, if they say that they have not transferred the
Let us
decretal
see the
property,
decretal property. Let us see from the decree
Yes.
what is the decretal property. Schedule is all that one room, veranda, one privy on the first floor on the southern portion of the premises number 35B.
yes,
They say they have surrendered, not this room you have not surrendered. Should we appoint a special officer to
Please,
check
we also pray for
in this
application, my lord.
Yes, you take a proper instruction. If
Yes,
they
sir.
have not surrendered this one room veranda and one privy on the first floor of the southern portion, they're not guilty of contempt. I will discharge the rule.
Malas, if your lordship Malas kindly comes to their Malas, our rejoinder, Malas,
No, what is their stand? They
Yes,
are
ma'am.
saying they have not surrendered this. They have surrendered northern portion which you have already transferred to someone else. So
Yes.
your allegation is wrong.
Malas, this is not my allegation. The suit initiated because of that. They are northern portion, Malas, they are occupying southern portion of the premises. That is why Malas, we filed a suit for eviction.
Root is for eviction of them from the southern portion.
Yes.
Northern portion they have surrendered or not, we are not interested. That does not frustrate the our stay order at all. Our order is entirely centered around the southern portion, which is the subject matter. We cannot go beyond that. So they are not guilty of contempt. You have unnecessarily embroiled them in litigation. Why shouldn't costs be imposed on your client?
Malas, very well. Malas, if your
This
lordship,
person is a legal aid. He is appearing with legal aid,
no,
and it's evident from the representation also.
Malas,
They don't have proper legal representation. You are hauling up this person unnecessarily through us.
Malas, if your lordship kindly comes to your lordship's order passed in 16/6/2025 once. Paragraph 2, last portion.
Yes.
This is passed in presence of both the parties.
It says the appellant, instead of complying with the said order, has handed over possession of the suit property in favor of a third party. That is a wrong notion based on your application,
Malas,
which they have dispelled now.
Malas, my application is only vacating the stay. Malas, they have come with an or rejoinder saying
We are
that
not on your vacating application, sir. We are now on the rule which you have issued to them. If they have not transferred the property, the suit property, or surrendered the suit property, you are still in possession of the suit property.
Yes,
Still in possession
Yes,
of the suit property.
we actually
Then
received
You are
that.
not guilty of contempt. You will discharge the rule and impose costs on you.
Malas,
They are
for filing
harassing
the
the
contempt
poor
application.
people.
Malas, I
That cost will be adjusted from the occupation
Malas,
charges.
if your lord, Malas, I have not filed a contempt application. This is suo motu contempt
So motu
because of
contempt,
their
but that
submission.
impression, sir, unless you gave us an impression that they have transferred, there was no occasion for us to issue a rule of
Malas,
contempt.
because they have said they have transferred the suit room in their Malas rejoinder. That is why, Malas. Then, my lord, if your lordship kindly.
Let us see. Alleged contempt 6 to delay contempt. This is in contempt. Let us see the first order of 16.6.
Yes, my lord, this is the first order. by which
Affidavit
the
is filed
contempt-
by them. Yes.
Yes,
Yes, from your affidavit itself, it was apparent.
that is.
We have
my lord.
recorded in your 16.6 order. You had filed an affidavit there. You had stated that you were compelled due to money. You had to transfer the a portion of the suit property.
Yes, my lord.
This was from an affidavit of theirs.
Yes, my lord.
Let us. What is that affidavit?
My lord, that is in relation to, my lord, that is in
In
opposition
your
to.
vacating.
Yes, my lord, vacating.
Let us
Can
just see
for.
that. So then you are the architect of
Milord,
your own.
initially.
You are the architect of your. You are the architect of your own
Milord,
mishaps.
confusion regarding that surrender.
You created the confusion, and you have now.
Milord, that's why I cleared that confusion, Milord, that
We'll drop the contempt. We'll drop the rule, but we'll vacate the stay because you have not paid. You have not paid, admittedly.
is your lordship can appoint any special officer to ascertain
You are beyond that stage.
My lord,
Drop the charge. But it was the charge was based on your own affidavit. And now it's. I'm sorry. We should not have threatened you with costs.
my lord, just one thing, my lord, then my lord clearly specifies that they have said that they have not transferred.
Otherwise, we
property,
cannot drop the
because
charge.
it will be now, there will be, that will be inexecutable, because if they have transferred.
Yes.
Someone else.
Otherwise,
That
we
is
have
why
to.
they have said so.
Otherwise, this will be an order 21 rule 101 scenario by
Yes,
that
my
one.
lord. That is why.
Now, if this statement is wrong,
Yes, ma'am.
kindly.
then nobody, even if you're on legal aid, nobody can sell you, and they'll pay for you in the jail.
Yes.
Therefore, there is no question of legal aid there.
I am repeatedly submit. We do not surrender that degraded.
Your client is
property.
behind you.
Yes.
Please ask him clearly whether he is still in possession of the suit property. The sub portion, the one in respect of which the decree was passed. And tell him not to pretend innocence. I mean, we are fed up of these actings. Just ask him whether he has transferred or not transferred the suit property. He might not have come unshaven just to show that he is not guilty.
He is in the possession, Milord.
Still in his possession.
Yes, and he is accept the summon, Milord, also.
No, we are not bothered with that. You have stated on oath, we'll take
Yes,
that.
yes, Milord, and
The rule was issued. The rule was issued on the basis of an affidavit affirmed by the respondent, stroke judgment debtor, where it was mentioned that the respondent in the appeal had surrendered the possession of the suit property in favor of a third party due to monetary requirements. Full next para. Today, the alleged contender files a show cause affidavit annexing relevant documents, to which a rejoinder is filed by the appellant, which are both kept on record. Full it transpires upon hearing learned counsel for the respondent, as well as upon going through the materials annexed to the show cause affidavit, that the northern portion of the self-same property had previously been transferred by the
father of the respondent.
যেখানে রেসপন্ডেন্ট বলে গেলাম সবকটা অ্যাপেলেন্ট হবে অ্যাকচুয়ালি সব রেসপন্ডেন্ট গুলো অ্যাপেলেন্ট করবে by the predecessor of the ever respondent হবে respondent in favor of a third party, and that only the said northern portion of the property, comma, which is not a part of the decretal property, comma, has since been surrendered by the appellant. Push up next para. It is further submitted on behalf of the alleged contemner that due to miscommunication between client and the learned advocate for the alleged contemner, comma, the said erroneous statement was made in the original affidavit, comma, which prompted this court to issue a suo motu rule of contempt, comma, since it transpired from such averments that in order to deliberately bypass the order of this court, comma, the transfer had been effected in respect of the decretal property, despite the appellant having not complied with the direction to pay occupation charges. Next para. Upon hearing learned counsel for the parties, however, we accept the version of the alleged contemner that there was a miscommunication, and also concede to the fact that due to the appellant having come to this court through legal aid services, there might be some deficiency in the services provided in that regard to the appellant. Full stop, next para. Since, at the end of the day, the alleged contemner has not transferred the suit property or surrendered the same in respect of any third party, but claims to be still in possession of the same, we are of the opinion that the rule ought not to be kept pending further. Full stop. Hence, CRC 13 of 2025 is discharged. Full stop. Further personal appearance of the alleged contemner is dispensed with. Full stop. Next para. What is the vacating application? Can 4.
Can 4.
Can 4 of 2025 is now taken up for hearing. Full stop. It transpires that we had granted stay of the eviction decree in respect of which the appeal has been filed on condition of payment of occupation charges by the appellant. Full stop. Since the appellant has failed to pay the same, can 4 of 2025 is allowed, thereby vacating the what was the date of the order? You have not even made that amendment in your prayer.
No, definitely.
Thereby vacating the order dated February 11, 2025, whereby stay of the connected execution case has been granted. Full stop. The respondent stroke decree holder is now at liberty to proceed with the title execution case, bearing number 52 of 2023, arising out of title suit number 35651 of 2014, pending before the learned judge, pending before the learned judge, pending before the City Civil Court at Calcutta. Full stop. If so proceeded with, the City Civil Court shall dispose of the execution case as expeditiously as the business of the said court permits. Paper book directions were given in this matter.
Yes, already. I don't know whether they have taken any steps or not.
Legal aid provides those services.
But we are actually doing legal aid, but it is not appointed through legal aid.
Yes, Madam. That is right.
I do not submit.
Why did you say he's coming only? You have stated also here legal aid.
No, I do not state it.
Yes, it is stated
It is
somewhere.
not stated.
Appearing through legal aid কোথাও একটা বলেছি। Through pro bono representation করে দাও। আমি পরে দেখে নেব। Pro bono representation। করে দিও। Thank you.
Manoj, your lordship has earlier directed the execution case to be finished within 2 months.
That will be a direction for the execution of the litigant, not the case. Yes.
I am appearing on behalf of the alleged contemner.
What was the nature of the contempt alleged?
There was a direction for interim maintenance, payment of interim maintenance. I defaulted. There was some default. My client has come only to attend this proceeding.
We sent an invitation to him. That's why he has
Yes.
come.
Yes. He has come from, he stays abroad, he has come, he is present in.
Yes.
He has also affirmed an affidavit, but in the affidavit, I think some computation ought to have done, which is not there. I personally feel that computation should have been there. My learned advocate on records.
I have the computation.
And I have the computation also. It's some other computation I'm talking of. Now
You paid some amounts.
Yes. Most of it I have paid. I just indicate I'm sure with regard to computation there will be no dispute.
Did you direct it to file a show cause to the rule?
No.
There was a rule issued.
Rule
It
has
was
been
only
issued.
issued. All
There
right.
was a
Yes.
rule
What is your stand?
Yes, I tell you, Lordship.
With calculation.
No. 3 lakh per month was what was directed.
Why didn't you comply?
I complied partly. I could not because of my dearth of money. My lord, I just indicate 2-3 things. My lord, I can put, my lord, I should have said that on oath. My lord, the order was passed, my lord, on a basis that, my lord, I earn 13.5 lakh, my lord, in United States. My lord, after.
Can we go behind the order?
No, my lord, I am not. My lord, I will pay. I need some time. I just indicate what I have paid, and my lord, what is more, my lord, to be paid. 17 lakh is in due, my lord, in arrear as of today.
2120. No.
August 2120. My lord, you are supposed to pay by 15th
No,
of
no,
every month.
no.
Yes, yes. My lord, I
9th
just talk
August.
to my learned
Yeah, I'll just
We'll give you that liberty. Yes.
yeah. My lord, 3 lakh every month. So, my lord, for 7 lakhs there were arrear, comes to 21 lakh, and my lord,
When do you propose to pay the entire arrears?
my lord, I need, my lord, as my client says, 3 more months. My lord, 5 lakh here and now.
Mr. Banerjee,
I
we
can
otherwise
understand.
would not have any difficulty in that. But we have lost the confidence on you because you are on contempt. Initially, if you had paid for that, we would have granted that installment.
True.
Now you are on contempt.
No doubt of it.
And
But, my lord, we can give an
what
undertaking on oath.
sort of job do you do abroad?
My lord, I am a software engineer.
Software engineer.
Mechanical engineer.
You are represented for the time being.
I'm sorry, my lord, I stand
Mechanical
corrected.
engineer.
Mechanical engineer.
Can you do it online? Because we
He
won't
can.
let him leave India unless he pays the amount. You choose your timeline.
My lord,
His job will be affected. It may go also.
and he is already, my lord, exposed to a threat of, my lord, a layoff. My lord, that's a difficulty.
Definitely.
My lord, because,
He
my
will
lord, there is-
suffer further consequences if he does not pay.
True.
We might sound very cruel. The law might sound
So
very
there
cruel
is an
to him.
order I have to carry.
But there's an order.
Absolutely.
He's on contempt.
I
We are
have
not
to carry
deciding
it
the alimony
I just
application now.
indicate 17 lakh is in area.
He's a software or mechanical engineer. He's sufficiently educated to understand that method.
Absolutely, my lord, no doubt of it, and he has understood. Today, my lord,
So unless you prefer a challenge against the
my lord, there
alimony
is
order.
an SLP pending, where, my lord, an order.
In the SLP, they've said that we filed this SLP only because we want time.
My lord, there is an order passed
No,
by the
that's a fair
My lord, I am
approach.
not, my
Otherwise,
lord, I have not taken that ground. My lord, there.
we are
the
not
order-
very keen on sending people to jail, Mr.
I
Banerjee.
know, my lord, I know.
The money has to be paid.
But, my lord, I have talked to him. What I, my lord,
But what
he has
assurance do we have as a
But
court?
he can
Because it's between you and us now.
correct. My lord, he can give, my lord, an written undertaking on oath saying that, my lord, this is the timeline within which, of course, my lord, subject to
If he does not
permission, my
comply
lord,
with an order of court,
yes.
then how can
My
you
lord,
rely on the oath of
out
that
of-
person?
Out of, my lord, 33, my lord, he has paid 21. Apart from litigation costs. So, my lord, he is in arrear for 12 lakh towards, my lord, this maintenance.
Have a talk towards the arrears. Just resolve it between Mr.
Very well.
Chatterjee and you.
Very,
Come back tomorrow. We'll put it under the same heading tomorrow. He'll have to come
Very.
tomorrow also.
very good.
Day after,
he will
if
come.
it comes to that.
After?
Day after, my lord.
Day after, yes. Have you prepared a show cause?
Yes, my lord, we have prepared an affidavit. Kindly allow us, my lord, to just
File it day after tomorrow if necessary.
I will do that.
And give a copy to them.
Yes, definitely.
Whatever show cause you actually want to use. If you want to make amendments to that,
Yes,
give that amended copy to Mr. Chatterjee.
Yes, my lord, we will do that. We will reaffirm this after amendment and we will supply a copy to my learned senior friend.
Do that. Then we'll put today or
We can do it by today.
by today you can do it.
Yes.
Because your client, you have to release your client also because he
That's
has to go abroad.
We will just insert
But
one
we'll
paragraph.
keep him. We'll put some embargo on him till he pays up the amount.
It's very well, my lord, we
What
can
embargo we can work that out.
Very well, my lord, I'll talk to Mr. Chatterjee also.
But he has to be present in court till it is done.
He will.
The rule remains.
He'll be there. He'll be there.
Learned counsel appearing for the alleged contemnor submits that due to dearth of funds, the alimony order of this court could not be complied with. Full stop. It is submitted that the alleged contemnor does not have any intention to flout the order of the court. Full stop.
Has paid
Although
most of the amount. Most of the amount he has paid. 17 lakh.
so it is further contended that most of the amount of alimony as per direction of court has already been paid. Full stop. Regarding the rest of the amount, the alleged contemnor seeks some time to clear off such amount. Next para, learned counsel for the petitioner, learned senior advocate appearing for the petitioner submits that although a special leave petition has been filed against the parent order of this court granting alimony, in the same it was expressed on behalf of the alleged contemnor that the same was filed primarily to get some time to clear off the alimony amount. First up, do you agree to that?
Or this is recorded in my lord's order.
It's
on their
recorded,
submission.
my lord, it's recorded in
Very
my
well.
lord's order. My instruction is otherwise.
We'll deliberately be vague on that
Yes.
for the time being.
Yes.
Be that
Fine.
as it may, since the alleged contemnor seeks to pay off the arrear amount of alimony to purge the contempt, but there is some debate among the parties as to the actual amount due, comma, learned counsel appearing for the parties are requested to squeeze out any such differences, for which purpose we are adjourning the matter till August 13, 2025, when it will be listed under the same heading. Push up, the alleged contender shall be personally present in court on the returnable date as well. Full stop. The matter will be taken up on August 13, 2025 at 10:30 a.m.
So just one.
No, sorry, not 10:30, 2 p.m. Because that's the original said first day.
Very
Yes.
But just one statement of fact which my lord has recorded, that he's paid off the entire, almost the entire. That's not true, my lord.
Most of it, I have said,
Most
you know,
of
lion-
it.
We have put it as
It's
his
not even a lion's share. It is his submission.
Yes.
My lord, he has today, my lord, 21.2 lakhs still pending out of the
This will be the lioness's share.
lioness's share.
So come back.
Go by that, I have paid
We have
most
put
of
it as
it.
his submission.
Yes,
Chatterjee.
yes.
So if you have any,
That's disputed, if your lordship.
acha, arekta line add kore, the time to file show cause to the contempt rule is extended till August 13, 2025.
Great.
So prepare your show cause, give a copy and
Yes,
file
please.
that if necessary on that date,
Yes.
and we'll consider about your reply.
My lord.
Absolutely.
Great. And Mr. Chatterjee, because it's his offer, you can have a talk with your client and
We
just
have
resolve
already, my lord, while
regarding
your
the
lordship was-
timeline.
Yes, my lord.
Regarding the timeline, we
While
have
your lordship was, my lord, interacting.
obviously you
I
people are
have-
there.
I have already.
Right.
But let Mr. Banerjee come up with a reasonable timeline, my lord. I will.
And Mr. Banerjee, we expect some sort of embargo to be suggested by you, which will not put on record as your
Well,
submission.
I'll give it a
You
thought.
have a talk with your client also.
Yes, well,
What embargo can be there to ensure that
to
this is
ascertain,
complied
yes,
with?
yes, yes.
Maybe a
He-
post-dated check
Yeah,
or
but I
something.
was
Because
also thinking of
if he ensured that he loses his job, Mr. Chatterjee,
No.
you won't get your
No,
money.
no, no, I'm the last person.
And that is the last thing we want to do.
Absolutely. Not at all.
So let us resolve the
The
issue.
problem is, my lord, I can say a lot of things that he has money.
Understood.
I have
Understood. You have restrained yourself very well.
going to get into
I am
that.
not getting
Let
into
Mr.
that.
Banerjee is here, my lord. He's
Yeah.
fair in more ways than one. So in whatever fair timeline comes in, my lord, we'll accept it.
The best part of this was in more ways than one. So come back day after tomorrow. Talk among yourselves, and there'll always be a threat looming on you. We'll send this to mediation. So whenever we feel
That's fail.
now we can do it, even if you don't agree so much. And
It's
during the
fail. It
period
was
of
sent.
mediation, your client has to be present in India.
Well, it was sent, my lord. It's failed.
It has already been sent. Anyway, we cannot dwell on that. That's the party's
That's the
autonomy.
worst thing that's ever happened, but
Adult people cannot be convinced. They have their own right to have their opinion, but we
In
can try
about
to just negotiate whether it's possible.
20,000 cases being sent to the mediation, probably
We know
one.
everything, Mr. Chatterjee. But even then, our mindset is also probably not till now. But these are
And-
trained mediators. If they have failed, we don't know
The
what.
trained mediators are also amongst us.
Yes. I think theatre. Yes, you are for the
Responding.
respondent. Who is for you are for the appellant.
For the appellant.
Acha, what is the matter arising out of? What is this?
The divorce decree was granted to the husband, that is the respondent. Against that order, the appellant's
Wife has
wife appeared. My lord, earlier the matter was sent for mediation. On the first day, both of them appeared. In the second date, only the husband appeared, but the wife didn't appear. My lord, I do not know whether any report has been given by the learned mediator or not.
But that mediation is still kept pending.
My lord, I do
Not
not know.
formally.
I don't know. No
Not informed
communication.
you?
No, my lord. Second date,
Let us check. There probably is a final report. Let's check it. Should have been given a copy. Should have been given to both of you. Your client did not go to the mediation. When your lawyer, her lawyer, that is you, probably was contacted, you had conveyed, or any other lawyer, that she's not interested to proceed any further with the mediation proceeding. Why is this?
My lord, actually, we do not have contact with her also.
So why did you indicate that she is not interested to proceed with? We'll just dismiss the appeal for default then.
My lord,
Please take the microphone a bit closer to you.
My lord, my senior holds the brief, and today I am just praying for not this weekend.
No question of not this week.
Then short Passover is prayed, my lord.
Short Passover for, say, up to the to be mentioned matters are over. Up to item 30, short Passover. This will be over very soon.
Grateful, my
We are passing it over. Please remain, keep somebody so that we pass over. এটা হচ্ছে এই হেডিং শেষ হলে আবার ডাকবে 30 এর পর।
My lord, in this matter, we are for the opposite party. The
You are,
matter,
what is the texture of the matter? What is the matter arising?
the matter suddenly appeared in list.
No, it is against what? Then appeal against?
Uh,
Because certain matters have been identified by our committee, there's a national drive for mediation going on. That's by the direction of the Supreme Court. It's a mediation for the nation. That's the caption. So we have not done it. The mediation committee has identified certain cases which maybe can be resolved. Section 7 of the Mediation Act is there. Section 7 of the Mediation Act gives us liberty to send to mediation also, courts. Not so strictly dependent on the consent of the parties now. But we don't want to force the parties because it's a futile exercise otherwise. What is the matter about? Tell us that.
The main problem is AOR is out of station. If learned court directs mediation, we have no objection.
No, tell us what is the matter against? Matrimonial or what? What is the nature of the
Matrimonial matter.
You got a decree of divorce.
I don't have proper instruction.
You are for the respondent.
Yes, madam. We have no objection if my lord please to direct for mediation.
No, your no objection won't do. The other side has to be there. Let's just check up. You are the husband or the wife? The wife. Divorce stage should dismiss. Divorce decree, they sought a divorce decree, the husband sought, that was dismissed against which they have come up. Can you give a notice to the advocate for the appellant? Tanmaya Basu. Take the address from the file. Tanmaya Basu, care of Qaede-Azam Firoz. Take the address from the back sheet and give a notice to them. We'll put it on next Monday under the same heading. At the time of call, learned counsel for the respondent submits that the respondent does not have any objection if the matter is sent to mediation. So, next para, however, since none appears on behalf of the appellant, the learned advocate on record for the respondent is requested to give a notice to the learned advocate on record for the appellant, indicating that the matter shall be listed under the same heading on August 18, 2025 for the purpose of consideration as to whether the dispute may be sent for mediation. Which of next para, let the matter be listed on August 18, 2025 as directed above.
Deeply obliged.
Thank you. ওনাকে একবার এই ঠিকানাটা দেখিয়ে দিই। You have the address of the other side? ওনাকে একবার দিও ওই ইয়েটা দেখে নেবেন। ব্যাকশিটটা একটু দেখে। Do it immediately, just take down. And just immediately hand it over. After taking down from the back sheet, you will get the, yes, next.
My appeal from
I'm for the my respondent wife.
What is the appeal against?
From a decree dismissing my suit for divorce ex parte dismissal of my suit for divorce.
Before my learned statement start, my lord, may I humbly beseech your lordship one thing. Earlier occasion, my lord, mediation was granted. Now, my lord, that mediation process was failed. Now, my lord, I am praying another time for mediation, my lord. There is a, my lord, enormous chance, my lord.
This.
At least I want to, my lord, resolve the dispute in an amicable.
Why don't you agree?
Because, my lord, the relationship is that acrimonious.
Your divorce suit has been dismissed.
Dismiss
Now, this is one thing we want to make it very clear today.
Yes, my lord.
This is for all.
Yes, my lord.
Mediation is not only for the purpose of keeping the marriage alive. In mediation, you can also agree to part ways. You can also agree to a divorce.
We made that effort. We failed.
There are trained mediators, Mr. Banerjee. You are probably one of the trained mediators.
No.
There are trained mediators who are very qualified. let them have a
No, my
try.
lord.
Let them have a try.
When, my lord,
There is another difficulty, my lord. There is
Because we'll make it clear that we are making it clear. Mediation does not necessarily mean that you will be forced to live in the same stable. You may part ways also. The other side may be convinced by the mediator, or they may convince themselves. It's between you.
my
Ultimately,
client,
both of you have to agree. Otherwise, there'll be no mediation. Let us try these matters because these are unnecessarily kept pending for long years.
my lord, my client feels, the husband feels that it's only, my lord, the facade of marriage, my lord, which is, my lord,
We will
unnecessarily
record
kept
that, and we'll also say that we'll keep it open for the parties to agree either way.
my lord, I am, my lord, passing my days in a hardship. There is a maintenance proceeding pending since 2020.
See, these generally boil down to the quantum of maintenance. These mediations, generally, we are not expressing any preconceived notions. Maybe you will part ways, both of you will agree to part ways, but you have to be satisfied on the quantum of maintenance. Because it's a dead marriage, if you also feel that, then the quantum of maintenance, it boils down to that. There'll be a mediation on that, and then you can agree to part ways if
It's, my
necessary.
lord, just a half-page degree. I need not say that today, but my lord, it's just a half-page degree which says that, my lord, whatever allegations I have made are, my lord, natural.
So,
law
Banerjee,
and
we are
fair.
not hearing it on merit. We are making it very clear. Even if you are confident on the outcome of the appeal, even if you win the appeal will take you time. You will have to be tied with this person for so long in your own notion.
That's true. That's true.
So till the appeal is heard out, you will have to be tied.
That's true.
So therefore, why wait for that? I mean, let us have an attempt. Learned counsel appearing for the respondent, comma, in his usual fairness, comma, submits that although a previous attempt at mediation had failed, comma, the respondent is fully agreeable to have another go at mediation. For sub next para, it is further contended that the respondent is not getting appropriate alimony from the appellant. For sub next para, learned counsel for the appellant submits that by a half-page judgment, comma, an ex parte, the divorce suit of the appellant was dismissed, although the marriage between the parties is dead. Push up next para. Be that as it may, comma, since we are not hearing the appeal on merits, comma, nor the allegation of the non-payment of alimony at this stage, comma, upon hearing learned counsel for the parties, comma, it appears that the parties are agreeable to have another attempt at mediation. Full stop. Next para. In view of the apprehension expressed by the appellant husband, comma, we make it abundantly clear that the outcome of the mediation need not be restricted to constricted choice of only sustaining the marriage, but also may explore possibilities either of sustaining the marriage or of dissolving the same upon adequate amount of permanent alimony being paid to the respondent wife. Full stop. We are not expressing any views on that matter, comma, since the matter is required to be reconciled by trained mediators. Full stop. However, comma, in view of the above, comma, we are of the opinion that there is every possibility of the matter reaching a logical culmination by way of mediation between the parties. Full stop. Accordingly, we refer the matter to the High Court Mediation Committee in order to in order to have a mediation between the parties on their dispute involved in the appeal. Full stop. Let the file be sent to the committee at the earliest for such purpose. Full stop. It is made clear that in the event the mediation does not fructify, comma, the parties will be at liberty to mention the appeal for being included in the list.
Instead of half page, it should be 1.5 page.
যেখানে হাফ পেজ বলেছিলাম, হাফ পেজ কথাটা কেটে দিয়ে শর্ট কথা লিখে।
Grateful.
Yes.
I am.
Appellant respondent.
Yes, ma'am. Husband, decree holder, respondent.
By virtue of your legacy, Ms. Bishwas, you must be for the wife. Legacy derived from your senior. So, you are for the respondent
I am
husband.
for the respondent husband.
So, what happened? Her suit dismissed or your suit
My
decreased?
suit allowed.
The-
was granted.
Divorce granted.
Thereafter, I contracted the second marriage. Thereafter, my lord, they moved the application. That's why they have not.
So, Ms. Vishwas, this seems to be a fit case for
Yes,
mediation.
my lord.
Alimony amount has to be probably. Upon hearing learned counsel for the parties, comma, we find that the parties are, comma, in principle, comma, we are recording that in principle, agreeable to an attempt at mediation, comma, particularly in the circumstances of the case, comma, since the respondent husband submits that pursuant to the impugned divorce decree, the respondent husband has already remarried and is having a family from such marriage. Full stop. Next para. Definitely, comma, the appellate wife's challenge to the appeal, challenge to the impugned decree cannot be scuttled at this stage, comma, just as her claim for permanent alimony cannot be. Full stop. Be that as it may, comma, it will be open to the parties to resolve the disputes by mediation. Full stop. Accordingly, the matter be sent to the High Court Mediation Committee for the purpose of exploring the options of mediation. Full stop. The parties will be at liberty to mention the appeal for inclusion in the list if and only if the attempt at mediation fails.
Well, may I submit one thing? Well, last order, when the application for alimony order was passed, your lordship's direction was paragraph 12, my lord.
What was that?
There was some confusion there. That's why confusion arises regarding the payment of alimony.
No, you will. Acha, line add kore, it will be open to the parties to clarify all issues regarding payment of alimony in the mediation process.
Yes.
It's absolutely open. You can agree to anything.
Referral.
The appeal arises out of a divorce decree obtained by the respondent husband. Full stop. At the time of call, comma, none appears for either of the parties. Full stop. The matter has been earmarked for exploration of possibilities of mediation under the mediation for the nation within double inverted scheme initiated by the Honorable Supreme Court. Full stop. Next para. Let a notice be issued. Let notice be issued. Let the matter stand adjourned for the day in order to enable the parties to be represented before this court. Just not to record. আচ্ছা কারো যদি ফোন নাম্বার থেকে বোথ সাইডে দেখে একটুখানি ফোনে যদি পারো বলে দিও, এটা আমি অর্ডারে রেকর্ড করছি না। সমীরণ মণ্ডলের ফোন নাম্বার নেই, দিয়ে রয়েছে। যদি কারোর ফোন নাম্বার থেকে কোনো পার্টির কোনো করেসপন্ডেন্স থেকে তাহলে জানিয়ে দিই যে ম্যাটারটা অ্যাপিয়ার করছে, আপনি আদার সাইডকেও নিয়ে আসুন কালকে তাহলে। একটু নোট করে রাখুন। নেক্সট। Appellant?
My lord, I beg to appear on behalf of the appellant, my lord.
Is this your first appearance?
No.
Who taught you this? Very well. It's good manners, but don't do it again in our court. Anyway, you are the appellant.
My lord, I beg.
What is the decree?
My lord, the decree is that, my lord, I had preferred, the suit was preferred against on the grounds of cruelty, my lord. I prayed for on the divorce. Under
That was
27.
dismissed.
That was dismissed, my lord.
You are the husband or the wife?
I am the wife, my lord.
Somebody is appearing for the other side.
My lord, somebody should be appearing because the service was complete, my lord.
Service. So you have got some letter correspondence by the other side's advocate must be.
My lord, as per the last orders that are there, my lord, it shows that the service upon the other side has been complete, my lord. I believe this matter was lying before the Lozima court, my lord, and this matter had come up, my lord, as my lord was saying that under the national mediation campaign.
Yes, yes. So let us see whether the name of anybody for the other side was recorded anywhere. It's none of you, all along you, Mr. Bhattacharya and you. Notice to dite hobe কানাডা মুশকিল। You are Mr. Diwan?
No, my lord. There is a change in the Vakalatnama, my lord.
What is your name?
My name is Shoujanno Patnaik, my lord.
Shoujanno Patnaik.
My lord.
Mr. Patnaik appears on behalf of the appellant. Appellant wife who has challenged a divorce decree obtained by the respondent husband. So next para. Are you agreeable to mediation?
My lord, I am agreeing.
Mr. Patnaik, comma on instruction, comma submits. Wife challenge করেছে divorce decree obtained by the husband. Oh, sorry. Husband's suit is your suit was dismissed.
My suit was dismissed, my lord.
Sorry. প্রথম লাইনটা প্রথম থেকে কেটে দাও। Mr. Patnaik, comma appearing on behalf of the appellant, comma submits that the present appeal has been preferred by the wife against the dismissal of her divorce suit. Full stop next para. At the time of call, comma none appears for the respondent husband. Full stop Mr. Patnaik, comma on instruction, comma submits that his client is agreeable for the matter to be sent to mediation. Full stop next para. Mr. Patnaik is requested to serve a notice on the respondent, comma either directly or through the learned advocate, comma if any appearing for the respondent in this court, indicating that the matter shall be posted under the same heading on August 18, 2025. Full stop, an affidavit of service stroke receipt shall be filed on the next day by the appellant in that regard. Please don't give the name of Mr. Bhattacharya in this matter. Only give your name only, because we have referred to you by name.
Yes, my lord.
At least for today.
Yes, my lord. Yes. Grateful to your lordship.
Nothing.
My lord, I'm appearing for the appellant. my lord.
Appellant, right. What is the matter about?
Appellant husband, my lord. My lord, it was my suit. She had
Dismissed.
prayed for divorce.
You are otherwise agreeable to
My lord,
mediation,
I'm agreeable for mediation, though initially this was sent for mediation.
but failed.
Mediation failed. At that point of time, wife had come up with the prayer that she is not requiring any maintenance or alimony and she wants to reconcile. But what had happened is initially I had prayed for restitution of conjugal rights, my suit. Thereafter, while the matter was being reconciled and heard, she had stated that she does not want to return to consortium.
That's why you converted.
Thereafter, understanding the futility, I again, that was dismissed for non-prosecution. I had filed suit for divorce. Thereafter, she filed written statement. At a much later stage, she came up with amendment and had a counterclaim for restitution. Both restitution and the divorce, both were dismissed. And thereafter, in mediation, here, the matter failed when she stated she wants to return. Now she has come up with an application praying for maintenance. And here we again want that the matter
Apparently,
may...
maintenance would be the main issue.
Yes, my
So,
lord.
Miss Ruksha Srimani,
She
that
was
is,
appearing
she
on
was
the
appearing
last
for the sole
occasion.
respondent.
There was a direction to serve the...
Can you give a
acquisition of
notice to her,
assets.
please? Because they're represented through advocate. Give a notice, we'll put it day after tomorrow. Give a notice that this is appearing. Can be done. Very good. Learned counsel for the appellant husband submits that initially the appellant had filed a suit for restitution of conjugal rights, but since the respondent wife took a stand in the reconciliation proceedings that she is not willing to come back, comma, the appellant husband was compelled to drop the said suit, which was dismissed for non-prosecution, and subsequently filed the present litigation for a divorce. For sub next para, the respondent wife filed her written statement and thereafter filed a counterclaim seeking counter restitution of conjugal rights in the said suit. For sub next para, learned counsel for the appellant submits that although it transpires from the stand taken by the respondent wife that she is not willing to come back to resume the conjugal life, comma, she has been resisting the claim for divorce. Full stop. In fact, comma, by the impugned judgment and decree, comma, both the divorce decree and both the divorce suit and the suit of the respondent wife for restitution of conjugal rights have been dismissed, comma, thereby creating an impasse to the effect that neither the parties can live together nor can they part ways. Full stop. Next para. From upon hearing learned counsel for the appellant, comma, it is evident that this may be a fit case for mediation, full stop. However, comma, since none appears for the sole respondent today, comma, the learned advocate on record for the appellant is requested to give a notice to her counterpart appearing for the respondent, indicating that the matter shall be listed under the same heading. We'll put it on Thursday. Thursday is August 14. On August 14, 2025, when a receipt in that regard shall be filed by the appellant. Give a notice to her. This was appearing. This will be appearing next on 14th. If they don't appear, we'll consider sending it to mediation all the same.
Miles. Great.
My lord, I am appearing for the appeal.
Appellant, Mr. Mitra, what is the appeal against?
The appeal by the husband dismissing his suit for divorce ex-party.
Who is appealing for the other side, Mr. Mitra?
Perhaps this none appeared.
Who will you mediate with then?
That is
Mr. Mitra will direct you to serve your client to appellant to serve a notice to the respondent directly, or if any advocate is appearing, your junior can take a search. Either way, we'll keep it next Monday for this limited purpose for the time being. If they don't appear, then we can consider putting it on the.
May I serve to the other side directly?
We'll give both options to you. Both options. And or. Other side directly and or advocate. Or is also there. So either of the two will do.
There is a postal department defect, my lord. Some little bit time be extra. Because, my lord, the posting. Otherwise, I can serve.
Mr. we are being very candid to you. This mediation for the nation, this drive has a time bound these schedules. So we are a bit hard pressed on that. We are at least trying to ascertain whether it can be sent to mediation. So this is this bench got the matters later. These were identified much earlier. So the moment we are having it, we are trying to hold it either way, either to send it to mediation, or if not possible, then we'll put it for hearing. So we'll give you 1 week for the time being. If you're in difficulty, then we can consider that. None appears for the respondent at the time of call. First of learned counsel for the appellant submits that this is the husband's appeal against the dismissal of his suit for divorce. First of next para. Although otherwise it transpires that there is fair scope of mediation, comma, due to non-appearance of the respondent at this stage, comma, no order in that regard is being passed now. First of the learned advocate on record for the appellant shall serve a notice on the respondent directly and or through her learned advocate appearing in this court, comma, if any, comma, indicating that the matter shall be listed next on August 18, 2025 under the same heading, when an affidavit of service shall be filed to that effect by the appellant.
In this matter, even though is appearing, he's on leg courtroom number.
So what is your instruction? What is the appeal against?
My lord, I am appearing for the appellant wife. Husband filed a restitution of conjugal right.
Decreed.
No, without liberty to file fresh. Thereafter, again file, and that has been decreed. Thereafter, we prefer an appeal along with the maintenance application. And that thereafter, my lord, please to direct the opposite party to file an opposition and serve.
It is at that stage.
Yes, my lord.
So are you agreeable to mediation otherwise?
My lord, please to send the matter to the mediation, my lord.
But you have to serve a notice to the other side. Arijit Gupta is appearing for the sole respondent. There is an advocate appearing.
Yes.
He must have been appearing on previous stages also.
Yes, ma'am.
So please give a notice to him. We'll put it day after tomorrow.
Yes,
in the list. Thank you. Learned counsel for the appellant submits that initially the respondent husband had preferred a suit for restitution of conjugal rights, which was dismissed for default.
No, ma'am, that is withdrawn without.
Which was withdrawn without leave to sue afresh on the self-same cause of action. So, however, comma, subsequently a fresh suit was filed for the same relief, which was granted, comma, against which the present appeal has been preferred. Fusab, learned counsel, what is your name, please? Your name?
Devangshu Bondhu.
Devangshu
Bondhu.
Bondhu.
Yes, ma'am.
Mr. Bondhu, comma, learned counsel appearing for the appellant submits that the matter is at the stage of hearing an alimony application made by the appellant. Fusab, next para, the learned advocate, you are the advocate on record?
No, my lord.
The learned advocate on record for the appellant shall serve a notice on the learned advocate on record appearing for the respondent, indicating that the matter shall be placed under the same heading in the list dated August 13, 2025, when a receipt in that regard shall be filed by the appellant. Give your name only today.
Yes.
On the next day, we'll consider the giving. Yes.
Well, my lord, I am appearing for the appellant.
Similar.
This is, my lord, on contest, the suit was dismissed, filed by the husband.
Your suit for divorce.
Parties are laughing, my lord, separately since 90.
Obviously, for that only you are exploring. Chanchal Kumar, they appeared for the sole respondent. Please give
My
a
lord, I do not know. He is perhaps, my lord, from other court. In such way, my lord,
Mr. Mitro, his address is given here, care of someone. Please take it down from the Wakalat. We'll just give the file to you. We'll ask you to serve a notice on him. We'll keep it day after tomorrow on the advocate. 11 Old Post Office Street address is there, care of some people. So please take this down from the Wakalatnam itself. None appears for the respondent at the time of call. Full stop. Learned counsel for the appellant husband who has challenged decree. Your suit has been dismissed.
my suit has been dismissed.
Who has challenged a judgment dismissing the husband's suit for divorce. Full stop. Next para. The learned advocate on record for the appellant is requested to serve a notice on his counterpart appearing for the respondent, Mr. Chanchal Kumar De, advocate, comma, indicating that the matter shall be listed under the same heading on August 13, 2025. Full stop. The appellant shall file a receipt in that regard on the returnable date. Eta Wakalat নামাটা ওনাকে মিস্টার মিত্রকে একবার সাইড দিয়ে দেখে উনি টুকে নেবেন এটা এই ঠিকানাটা অ্যাডভোকেট at the bottom it's there Mr. Mitra.
Yes.
The present appeal has been filed by the husband against a dismissal of his suit for divorce. Full stop. None appears at the time of call. Full stop. Let the matter stand over for the day. কালকে একই হেডিং আসবে When the matter is called on for hearing, comma, neither Ms. Monidipa, bracketed Paul, bracket close, Roy, comma, learned advocate, naam kore dicchi ইচ্ছে করে learned advocate appearing for the appellant, comma, nor Mr. Supriyo Das, comma, learned advocate for the respondent who lodged a caveat, comma, appear before this court. Full stop. Next para. The appeal arises out of a divorce decree obtained by the respondent husband. Full stop. Next para. It prima facie appears that this is a fit case which can be resolved by mediation. Full stop. However, comma, due to absence of the learned advocates for the parties, no order is being passed today. Full stop. Let the matter stand adjourned till tomorrow. যেগুলো অ্যাড্রেস দিচ্ছে না যদি পারো ফোন নাম্বার নিয়ে ফোন করে দিও যদি টাইম পাও তিনটে এর আগেরটা আর এটা আর প্রথম তিনটে হয়েছে এর আগেরটা এটা নাম্বারগুলো নোট করে রাখো পরে একবার দেখে এক সাইডকে দীপঙ্কর এক সাইডকে যদি রিচ করতে পারো বলবে অন্য সাইডকে ইনফর্ম করে দিতে কোড বলেছেন বলে
In this matter,
yes,
I was for the petitioner, my lord, appellant, my lord.
You have challenged what? Divorce degree granted?
My lord, I give my no objections in this matter. Probably Mr. Roy is appearing in this
Which Mr. Roy?
Mr. Chandrodoy Roy is appearing in this matter. For
Can
the
you
appellant.
inform him? We'll keep it day after tomorrow.
Okay.
Inform him, Mr. Sarkar, please inform him to intimate the other side's advocate also.
Okay.
Mr. Sarkar, learned advocate, the learned erstwhile advocate for the appellant submits that he has since given a no objection to the appellant. So we appreciate such gesture of the appellant, gesture of learned advocate in apprising the court of the same. Full stop. Next para. Mr. Sarkar is requested to intimate Mr. Chandrodaya Roy, the learned advocate appearing for the appellant regarding pendency of the matter, if possible. Full stop. Mr. Sarkar shall also, if possible, intimate Mr. Chandrodaya Roy so that the latter informs the learned advocate for the respondent that the matter shall be listed under the same heading on August 14, 2025.
Great.
14th August, Mr. Sarkar, please. You are not required to be present on the next day. We have just requested you. If you can inform Mr. Roy.
Great.
Thank you.
16, my lord, I am for the appeal.
Yes, please. What is the appeal against?
Husband preferred file a suit for divorce.
Your suit dismissed.
Yes,
Who is appealing for the other side?
it's not known to me. Whether both parties are living apart last 27 years.
So this is a fit case for mediation. If you can part ways, yes.
Absolutely.
Now, we'll just give one chance to the other side. I mean,
Parties are from Dakshin Dinajpur.
Dakshin Dinajpur. This is at the very inception stage. I mean, therefore, nobody has appeared. We'll request you to send a notice on the respondent directly that it is appearing under this heading. We'll keep it next Monday.
But that my fear is it is to be extended at least 2 weeks as to serve upon at the.
No, what we're doing this, as we told the other previous learned advocate, we have a timeline to meet. We'll put it next Monday. If you say that you haven't been able to serve, we'll consider. None appears for the respondent. Full stop. The matter arises out of the dismissal of the appellant husband's suit for divorce. Full stop. This otherwise transpires to be a fit case for being referred to mediation. Full stop. Next para. The learned advocate on record for the appellant is requested to serve a notice on the respondent directly by post, indicating that the same shall be listed under the same heading on August 18, 2025, when an affidavit of service to that effect shall be filed by the appellant. If not possible, intimate us, we'll give you for that. But send it quickly, please, so that there's a chance of them getting it.
I'll try to do today.
Yes. Thank you. 17. appear করছে দেখি নামগুলো অর্ডারে ঠিক করে we find from the records that Mr. Sanjeev Mitra is appearing on behalf of the appellant, on behalf of the respondent, whereas Ms. Priyanka Chunari is appearing on behalf of the appellant. Full stop. The appeal has been filed against a divorce decree by the wife. Full stop. Next para. This transpires to be a fit case for mediation. Full stop. However, in view of the absence of the learned advocates, we are not passing any orders today. Full stop. Let the matter stand over for the day. Dipankar. Same. Doctrine of intimation. Next.
I'm for the appellant, my lord. Appeal against, my lord, dismissal of the suit for divorce, my lord, under this Hindu Marriage Act, my lord.
Anybody appearing for the other side?
It is at very initial stage, my lord. We have filed Talabana and, my lord, written notice of form.
We'll pass a similar direction, serve a notice and come back. Let us explore the possibility of. The learned advocate appearing for the appellant submits that this appeal has been preferred by the appellant dismissal of his suit.
Yes.
Husband against the dismissal of his suit for divorce. Full stop. Since none appears for the respondent at the time of call, the learned advocate for the appellant is requested to serve a notice, serve an intimation on the respondent through post indicating that the matter shall be listed under the same heading on August 18, 2025, when an affidavit of service shall be filed by the appellant. Please come. Thank you.
19, my lord. Lordship, Mr. Kushal Pal is appearing on behalf of the appellant lordship. He is appellant wife lordship. Husband has been filed a suit for divorce before the learned trial court that was decreed challenging that order.
You are for the respondent husband.
Yes, my lord.
Chance of mediation?
Yes, my lord.
Yes, sir.
Matter has already been sent to mediation center, my lord, but no intimation has been received from.
Oh, let us just check up.
I am led by Mr. Saurabh Singh, my lord.
Yes, in fact, we had passed that order.
Yes, my lord. On the last occasion.
Did any sitting hold? Was any sitting held?
No,
Mediation?
no intimation has been received.
Can you please just contact the High Court Mediation Committee? Just find out where it is and just contact them. Learned counsel for the parties point out, rightly, that this matter has already been referred to mediation by our order dated July 2, 2025. For sub next para, however, no intimation has been given by the High Court Mediation Committee to the parties regarding the date of sitting of mediation. Full stop. The office shall intimate the gist of this order. The office shall intimate this order as well as the order dated July 2, 2025 to the High Court Mediation Committee at the earliest for taking steps in that regard. Full stop. The learned advocates for the parties are also requested to approach the High Court Mediation Committee and seek a date of sitting of the mediation pursuant to our orders.
Grateful.
Let the file be sent to the High Court Mediation Committee at the earliest.
My lord, in this matter, Mr. Suman Basu is appearing for the petitioner. My lord, he is not been able to present today due to the one of the death of the one of his family members. My
No
lord,
difficulty. What is the matter about? Just tell us.
my lord, I'm not.
You are his chamber junior.
Yes.
So, should be ready.
My lord, I'm praying for a accommodation of 2
Wait.
weeks.
Give us half a minute. What is your name?
Devopriya Ghosh.
Ms. Ghosh.
Yes, my lord.
Don't give the senior's name today, give only your name. Ms. Ghosh, appearing for the appellant wife, apprises the court that the present appeal has been preferred against a decree whereby the respondent husband's suit for divorce has been decreed. Full stop, we find that this is otherwise a fit case for mediation. Full stop, next para. The appellant shall serve a notice on the respondent, either directly or through the respondent's advocate in this court, if any, indicating that the matter shall be listed next on August 18, 2025, when an affidavit of service to that effect shall be filed by the appellant. Is it clear to you, Ms. Ghosh, our order? You will send a notice immediately to the respondent, either directly or if advocate, then through the advocate. It will appear next on August 18th. You will file an affidavit of service to that effect.
My lord.
আমি যখন তুমি প্রশ্ন খুব আনন্দ হচ্ছে The present appeal arises from a decree dismissing the appellant's suit for declaration that the marriage between the parties is a nullity. Full stop, none appears for the parties at the time of call. Full stop, let the matter stand adjourned for the day. অনেকগুলো হয়ে যাচ্ছে, টাইম পেলে করে আসছে।
22, my lord. I appear for the appellant, my lord.
What is the matter about?
The ex parte decree was passed, my lord, challenging which came up before your lordship's court. My lord was directed to restrain the husband from remarrying on contested hearing last occasion.
Anybody appearing for them?
Yes, Mr. Shoptangshu Basu, Mr. Shivashish Ghosh, and Mr. Devobruto.
Give a formal notice to them. We'll keep it day after tomorrow.
My lord.
Or to tomorrow. Mr. Devashish Ghosh is available every day.
Day after tomorrow.
Day after tomorrow.
Safe.
Well, learned counsel for the appellant submits that the appeal has been preferred against a divorce decree, you said.
My lord.
Against a divorce decree, full stop, next para. It transpires that the respondent is represented through counsel as well. Full stop. The learned advocate on record for the appellant shall serve a notice on the learned advocate on record for the respondent indicating that the matter shall be listed on August 13, 2025 under the same heading. Full stop. A receipt in that regard shall be filed by the appellant on the returnable date.
DP of this.
Yes. Again, after a long time, I have come, Lord. Yes.
What is the matter about?
Yes, Lord. The decree was passed in the on the 4th day of July 2024, granting divorce to the husband on non-consummation of marriage.
Anybody is appearing for the respondent?
Yes, on the previous occasion.
You are appearing. Respond.
Lordship,
Respondent should respond.
Respondents, yes.
Yes.
On the previous occasion, having been scolded by your Lordship, I served the copy in the court.
You were scolded by us.
Yes,
Now we scold them. It has to be balanced out. Now it has to be balanced. Yes. Why? Give us one reason why we shouldn't scold you.
Yes, you should scold.
I am unaware about the last occasion, Lordship.
Then that is sufficient reason for not to scold you. Yes, this is appearing before us for sending to mediation. This has been identified by the mediation committee, and this appears this has been filed against a divorce decree. You say.
Divorce decree.
So let us send it to mediation.
Lordship.
We
are of instruction to proceed with the mediation.
We shall always comply with it.
Thank you. Learned counsel for the parties submit that the matter arises out of a dismissal of a divorce suit by the appellant. First of next para.
No, divorce decree was granted to the husband.
Sorry, against a divorce decree granted to the respondent husband.
Yes, yes.
First of next para. In view of the nature of the dispute, comma, it transpires that is there any child involved?
No child is there.
Very well. It transpires that the matter is a fit case to be sent for mediation. So accordingly, we send the matter to the High Court, Calcutta High Court Mediation Committee for commencing a mediation procedure between the parties at the earliest. First up, let the file be sent to the mediation committee for such purpose. If you can, please intimate the High Court Mediation Committee office that this number has been sent so that
she mentions that they should take steps that it will be more beneficial for us.
no, this direction itself means that these matters are appearing for that purpose. Justice Shen had fixed these matters for this purpose. We have taken an information from him. These were for this purpose.
Yes.
So they were aware, but even if you can intimate, it will expedite the matter.
It is the fact. With permission, Lord.
Please, thank you.
Hello, item number 24. I am for the appellant husband, my lord, led by Mr. Dheeraj Trivedi, my lord. The suit was dismissed, my lord. It's a matrimonial.
Your divorce suit was dismissed,
my lord.
So anybody appearing for the other side?
No, my lord. Nobody appeared, my lord. Talabnama and special cost we have already.
Talabana has been. You give a notice. We are exploring the possibility of mediation here. The learned advocate on record for the appellant shall serve a notice on the respondent directly indicating that the matter shall be listed under the same heading on August 18, 2025 for the purpose of exploring the possibilities of mediation. First of next para. It appears from the conspectus of the suit that the dispute between the parties is matrimonial in nature and as such conducive to a possibility of mediation. First up, however, comma, since the respondent is unrepresented, we post the matter under the same heading in the list on August 18, 2025. File your affidavit of service on that. Affidavit direction dilam ki? Na hole bole din, the appellant shall file an affidavit. Yes.
I'm for the appellant.
Yes, Mr. Ghosh, matrimonial.
Yes, it happened in this matter. The wife is before your lords.
Wife got a dismissal suit.
Yes, no matter what happened in this matter, taking advantage of the mental illness of the wife, husband filed a mutual consent divorce. Divorce granted. After a few months, the wife driven out. She came to understand that the divorce decree has been passed. She came to the High Court Legal Aid Services. My respectful submission is a fit case for recalling before the trial court. But the High Court Legal Aid Services had directed me to file an appeal challenging the order of mutual divorce.
No, your advice was the right advice.
Yes, my lord, but It's a fit case for recalling before the trial court. This is the whole scenario.
No, you are what, mentally disturbed or something?
Mentally disturbed.
Mentally disturbed in the sense?
She is
But that would provide a ground for divorce, Mr. Ghosh, if you record that.
She is under treatment in before the National Medical College at mental health hospital.
What is the nature of the mental ailment?
It is stated. Very difficult to.
No, to take your time, just tell us. You can send it to mediation and appoint a psychiatric analyst for that also.
Yes, that will be.
The nature of the ailment, whether a psychologist or a psychiatrist, that will consider. Obsessive compulsive disorder. OCD. Obsessive compulsive disorder.
Disoriented. Panic attack.
All of us have it to some extent. OCD.
Aminous.
If you're an advocate or a judge, you have to have OCD.
Because he is having a medical degree in bachelor's in homeopathy and also LLB.
Oh,
that's why I will take his help.
Given notice to the other side, the respondent.
Then
learned counsel for the appellant submits that the appeal has been preferred against a divorce decree obtained allegedly on mutual consent, taking undue advantage of the mental illness of the appellant wife.
She has been advised, she has been referred to psychologist, psychiatrist, OPD.
For what? For what?
It's a government hospital, but I can't. It's very difficult to.
Anxiety, sleep, stressor, occasional panic, typical case of OCD. কি বললাম? Taking undue advantage of the mental, taking advantage of the taking undue advantage of the mental disorder of the appellant wife. Push up next para. From a perusal of the documents.
OCD, yes, my lord. Yes.
Documents
compulsory
produced before this court, it transpires that the nature of the mental ailment is obsessive, capital D, obsessive compulsive disorder, bracket OCD. Push up, this is a fit case where the matter may be resolved, if necessary, with the intervention of mediators, including one psychologist. Push up next para. However, since the respondent is not present before us, the learned advocate on record for the appellant shall serve a notice on the respondent indicating that the matter shall be listed under the same heading on August 18, 2025, when an affidavit of service shall be filed by the appellant. If they don't appear, we'll send it to mediation.
Much of it.
And we'll put in a, just remind us, just say OCD will recall. Because we have OCD, we'll recall. So we'll put in a psychologist. We have on our panel psychologists also. So we'll put that.
Much of it.
26, yes.
My lord, I appear for the petitioner appellant husband, my lord. An application under section 13 was dismissed.
Dismissed.
Against which this appeal has been prepared.
You are the husband. Anybody appearing for the respondent? Not yet.
Not yet.
So we'll put in a similar direction. Sir. The matter arises out of the dismissal of the appellant husband's suit for divorce. Since none appears for the respondent, the learned advocate for the appellant is requested to serve a notice on the respondent directly indicating that the matter shall be listed under the same heading on August 18, 2025. Next para, it is made clear that since the nature of the dispute is matrimonial, we are of the opinion that mediation might provide an appropriate solution to the dispute between the parties.
I'm for the appellant, lordship. I'm praying 2 weeks accommodation to prepare the paper book in this matter.
No. This is appealing for the purpose of sending to mediation. What is the appeal against?
I do not have any instructions from the learned advocate.
We'll instruct you. The present appeal has been preferred against the dismissal of the appellant husband's suit for divorce. Next para. The matter is appearing for exploring possibilities of mediation in view of the nature of the dispute. Next para. Since none appears for the respondent wife, comma, the appellant shall serve a notice on the respondent indicating that the matter shall be listed under the same heading on August 18, 2025 and file an affidavit of service to that effect on the returnable date. Give a notice to appear under the same heading, file affidavit of service. It will be best if you get the server copy of our order today and serve it along with this.
Sure. Obliged, my lord.
Your next matter. You are in the next matter.
Yes,
28, yes, you are for
my lord,
the
I'm for the respondent husband, ma'am.
wife's appeal against you obtained a decree of divorce.
Yes, ma'am.
Is there any possibility?
No, ma'am.
No possibility of
No
mediation.
possibility.
Then you'll definitely send it to mediation.
My lord, the
That's a
husband
good
is,
test.
my lord, the
Whether it's
husband-
possible.
my
If
lord,
the
my-
advocate says it's not possible, it's possible. No, you have obtained a divorce decree.
Yes.
It may be the friction point, maybe only the alimony. How
No,
do
my
you
lord.
know that? What?
Because, my lord, the husband, the petitioner, the appellant wife is working in Dubai, my lord. She is an air hostess to Emirates Airlines, and the husband is a merchant navy man. So,
So no common point.
my lord.
Unless the plane hits the sea or you. Anyway, if you're in the Bermuda Triangle, you may reach the flight.
Yes, ma'am.
Anyway, but there is no Bermuda Triangle involved here.
No, my lord.
Then there is a question of there is a possibility of resolution. Give a notice to the other side.
My lord, I'll give notice.
To explore the possibilities of mediation, comma, the matter has been placed under the heading to be mentioned. Full stop. Although the respondent is represented, comma, none appears for the appellant wife. Full stop. The learned advocate on record for the respondent is requested to serve a notice on the appellant wife. No, on the learned advocate for the appellant wife. Give a notice to him
My
or
lord.
her.
Her, my-
Her. Indicating that the matter shall be listed under the same heading on August 13, 2025 for the purpose of exploring possibilities of mediation. Full stop. And receipt in that regard shall be filed by the appellant on the returnable date.
my lord.
Give a notice.
My lord.
We'll take the receipt and we'll try to convince both of you.
My lord.
It will come back in 10 minutes. Resolution should dismiss also. Dismiss also. By the impugned judgment, comma, the appellant husband's suit for restitution of conjugal rights was dismissed. Full stop. Since the matter pertains to a matrimonial dispute, comma, we are of the opinion prima facie that the matter may be resolved by mediation. Full stop. Next para. At the time of call, comma, however, comma, Mr. Shovik Das, advocate appearing for the appellant, neither Mr. Shovik Das, comma, advocate appearing for the appellant, nor Miss Indrani Nundi, comma, advocate appearing on behalf of the respondent appear before us. First up, let the matter be listed tomorrow under the same heading. আচ্ছা ইন্দ্রাণী নন্দী যিনি অ্যাপিয়ার করছেন এনার ফোন নাম্বার আছে, এনাকে ফোন করে সৌভিক দাসকেও খবর দিয়ে কালকে লিস্টে যান, কাল। Yes, Mr. Bhattacharya.
Other side is not here, then I have.
This is the wife's appeal.
But,
Matrimonial. Wife's appeal
wife's.
against degree of divorce. So who is appealing for the other side? If there is something on record.
Shivaji Kumar.
Very well. Mr. Bhattacharya, comma, learned advocate for the appellant wife appears in court. Full stop. However, comma, although we are apprised that Mr. Shivaji Kumar Das is appearing for the respondent, comma, the respondent remains unrepresented today at the time of call. Full stop. Next para. The matter has been posted in the list for ascertaining the scope of mediation, comma, since the same arises out of a matrimonial dispute. Full stop. The learned advocate on record for the appellant shall serve a notice on Mr. Das, comma, learned advocate for the respondent, indicating that the matter shall be listed day after on August 13, 2025 under the same heading, when a receipt in that regard shall be filed by the appellant. Please just give a notice. Day after tomorrow. Pass out today. Item 3, pass over. Yes, yes. Yes, you are there.
I lost contact. The last 1 month back, he told me that what happened in my matter. That I told that if the matter is appearing, I will pause. Give me 1 week time so that I.
Very well. Learned counsel
My
for
lord, one thing, my lord, earlier there was a direction to make payment upon the husband. My lord, he has made that payment of rupees 70,000.
learned counsel for the respondent, comma, in her usual fairness, comma, submits that. Oh, you have made the payment.
Yes, my lord.
Then not in your usual fairness, in your unusual fairness. Learned counsel appealing for the respondent husband submits that the payments in terms of previous directions have been made in respect of alimony. Be that as it may, comma, learned counsel for the appellant wife seeks a week apostrophe adjournment for establishing contact with his client. The matter has been posted before us, comma, being a matrimonial dispute, comma, to explore the options of mediation, resolutions through mediation. Hence, comma, in order to enable the appellant to be represented properly, let the matter stand adjourned till August 18, 2025, when it will be listed next under the same heading. Please take instruction, whichever way we are, either way, divorce or staying together, whichever way. If alimony is the crux of the matter, that can also be resolved by mediation.
Think, my lord, can it be on 19th?
19th, very well. তাহলে returnable date 18th না করে 19th এটার ক্ষেত্রে হবে। 19th. এবার 31 who is the yes
31 minute victory for Mr.
Yes.
For the petition of the
Yes, what is the matter?
My lord, challenging the order of the tribunal, wherein, my lord, the tribunal allegedly held that the BLLRO has complied with the judgment and decree passed in a suit which was filed by the predecessor in the interest of the petitioners. But, my lord, actually it was not done. My lord, initially what happened, your lordship, predecessors in the interest of the petitioners had purchased certain land from one person, from the vendor. But the name of the vendor and his heirs were wrongly recorded in respect of those transferred land. So a suit was filed. It was specifically found that yes, wrong. The recording has been wrongly made, and there's a direction accordingly.
You filed, your predecessor filed a suit?
Yes.
For declaration of your title?
Yes.
What was found?
It was decreased in my favor. It was in favor of my predecessor.
Your title was declared, and
Yes.
what ancillary relief? Injunction.
Yes, Your Lordship. Well, subsequently, Your Lordship, since recording was not made pursuant to the said judgment and decree of the learned
So
civil
the
court.
decree also directed the records to be changed in your name?
My lord, that
Or merely declared title?
Declared
title.
Declared title, Your
That's
Lordship.
very well.
That is
On the
the
basis of
26
that, your predecessor applied for changing the names?
Yes, it was not done.
Acha.
Subsequently, we made application for recording the name as per the said judgment and decree, but that was also not done. Subsequently, we are being told that part of the said land was vested in the state. As will be evident, my lord, from the information slip, wherefrom it would be evident that the state has alleged that part of the land was vested. Lord, again, we filed, Your Lordship, an application wherein we had stated that if a part of the land has been vested, will kindly record my name in respect of the balance portions of land. My lord, subsequent thereto, Your Lordship, the learned tribunal, Your Lordship, directed to file a report. The BLLRO came forward with a report, and in the report it was found that initially the recording, the vesting that was allegedly made, it was wrongly done, and they subsequently deleted from the list of vesting the said
So
portion.
the entire land is now yours?
Now is mine. My lord, then Your Lordship.
How did the tribunal proceed?
My lord, tribunal held that since the BLLRO has complied with the order of the civil court, so there's nothing remains. The application
No,
is
but your
disposed.
grievance remains.
My lord.
Grievance remains that your names are not recorded.
Yes, Your Lordship.
Yes,
Well, a very simple prayer of my learned friend. I made a representation of correction or record of rights in terms of the decree, judgment.
Did
and
that be
decree.
done?
Not done. It has been done. It has been done. May I show you, Lord? It has been done. This report, yes, which was filed before the tribunal is bogus report. I am also not satisfied. But today I am with the current finally published record of rights where this Foreman Mondol, who is the petitioner before Lordship as well as before the tribunal, his name appears. But Foreman Mondol is not the only heir of Amena Bibi.
And others is there.
And others are not. Foreman
You have to
Mondol-
correct that, make that correction.
So yes, we have done it. Because he is claiming through Amina Bibi, his mother, kindly sees the plaint.
Yes.
Kindly sees the plaint. Prior to that, my lord, kindly sees.
Predecessor in interest was Amina Bibi. She had purchased.
Yes. His
mother had purchased.
Yes. And kindly sees, my lord, kindly sees page 13, that is the, my lord, OA. What does he want? This is what the schedule he is referring to. Lordship got 113, page 13. He is referring to DAG 4154.
He says, Mr. Gali, applicant along with his other family members.
No, but he is the only applicant.
Maybe.
Foreman Mondol, and it has been done. And kindly see now the plaint. 22. Just 3 pages I'll be showing. Page 22 is the plaint.
Yes.
Kindly see the plain Miller 22. Who is the body? Kindly see Amina Bibi Mito. Tar Warish Hocche Foreman Mondol, Farhad, Lokman, Rajak. These are all the heirs to Melotson.
And where is your correction?
What is the decree? And this is the correction. They kindly ignore the report which was filed by the BLO before the tribunal. This is the Milord finally published record of rights. Today in the morning I have collected, Milord. Lordship, sorry, Milord.
And you have to give a copy to them also, Mr. Gali.
Yes. Kindly sees the reflection in their respective share. Farhad Mondol.
Please circulate a copy to him, Mr.
I've already.
Mr. Take instruction, come back tomorrow.
Yes.
Lordship.
Thank you.
Lordship.
Hope people like you were there in every case for this time. Learned counsel for the petitioner submits that despite the predecessor in interest of the petitioner and her other heirs having obtained a decree from a civil court declaring her right, title and interest in respect of the disputed property, a subsequent application for the by the petitioner for recording the names of the heirs of the predecessor stroke purchaser was refused, full stop. The matter came up ultimately before the tribunal, full stop. In the process, a BLLRO report was submitted which indicated in the process, a stand was taken by the state initially that a part of the property had been vested in the state, comma, which was subsequently altered by a BL and LRO report, which indicated that the vesting was withdrawn. First up, the tribunal disposed of the matter on the premise that the decree of the that the BL and LRO had complied with the decree of the civil court, comma, without redressing the relief sought by the petitioner to record the property in the name of the petitioner and the other heirs of his deceased mother, comma, the original purchaser. For the next para, at the time of call, comma, learned counsel appearing for the respondent state hands over a copy of the current records of right, where apparently the names of all the heirs of the deceased mother of the petitioner, that is the present co-owners, comma, have been recorded with regard to the concerned property. For sub next para, a copy thereof handed over in court today is kept on record, as well as a copy is given to the learned advocate for the petitioner. For sub, the learned advocate for the petitioner shall take instructions as to the correctness of the same and apprise the court regarding the stand of the petitioner in view of such changed circumstances. For sub next para, let the matter be placed in the list under the same heading on August 13, 2025. Day after tomorrow. Affidavit of service filed today be kept. Thank you.
Obliged, Lordship.
Day after tomorrow, please take instruction today and come back. Yeah.
I am for the
Yes, Mr. Ghosh. What is the matter?
Against the rejection of my section 5 application, I came up before my lords. Before going to the impugned order, kindly take up, kindly comes to page 17. I have prepared a chart where form it will appear that in the impugned proceeding before the authority below I is not a party. That order I have challenged why I came to know learned tribunal, the delay is more than the long delay is there. The learned
means how long?
1377 days.
Translates to how many years?
Translates to about
same in maths.
3 years, 3 years and not.
4 years.
But the private respondent preferred the appeal before the appellate authority after 5 years. Kindly comes to page 17.
17.
17.
We are there.
The Topon Bej and Sonji Bej is the petitioner before my law.
No, their appeal was entertained. After 5 years?
After
that
5
section
years,
5 was
yes.
allowed.
The Topon Bej and Sonji Bej was purchased the land from Kaushik in the year 2015.
Kaushik was a party to the proceeding.
Yes, yes.
The proceeding was for what?
Proceedings was for mutation and equal quantum has been carved out from the land acquisition case. So due to technical rules, whoever the co-sharers, they get the excess amount of land.
This is only against section 5.
This is only against section 5. I am not taking my lords to the merit of the case.
So section 5, what is the tribunal's order? Let us see.
Kindly come to straight away to the last, after 279. That is the impugned order.
COVID was applicable for some of the period.
Yes. Not between.
No, my case, I am not the paying for benefit of the COVID period, which was declared by the Honorable Supreme Court. I say, due to that COVID, my pending OA application, I could not contact my learned advocate. For the reason, kindly comes to page 17. In brief, I have wanted to say, kindly comes to page 17. What happened, why that was not within my knowledge. I purchased the subject land from Kaushik. Now, serial number 2015 purchase. Serial number 3, 122 title suit is there. That was they felt lost. Now, miss case for mutation filed by one Sadin Nayak was allowed on father of the respondent number 6, that was allowed on May 2007. Against that, appeal was filed by Kaushik Nayak, my vendor. That appellate authority remand this matter for fresh hearing. In terms of that order, the BLRO.
These are on merits.
No, what I am
Chronology, why he's
why I approach. In terms of the
No,
remand.
Shadhin Nayak was your vendor's father.
Private respondent's father.
Private respondent's father. Achha, very well.
Now,
You are for the private respondent.
Yes.
Who is for the state? Mr. Galib is there.
I beg to represent the state.
For who are they?
My vendor. They are my
Your vendor. Achha, very well. What is their name? Your vendor's name?
Kaushik.
Kaushik Nayak.
Kaushik Nayak.
What was Sadhin Nayak? Kaushik related to Kaushik?
The chart is there.
Uncle.
Chart is there. The original Pulin Krishna Nayak was the owner. Now, I have made the chart.
Yes.
From Kaushik part, I am coming.
Right.
Now, the Kaushik Nayak preferred an appeal before the appellate authority under 54. The appellate authority direct the prescribe authority.
Kaushik Nayak filed appeal, Sukhendu.
Yes, the against the Sadhin Nayak prayer was allowed.
Sadhin Nayak's application was allowed for mutation.
That was challenged by Kaushik, my vendor. Now my vendor challenged by preferring an appeal.
Then he had not sold in your favor.
Transferred in the year 2015.
At that point of time, it was not transferred.
At that time, not transferred.
Then during pendency of the appeal, the transfer was effected.
No. After disposal of this, he got the order from the BL and LRO. The next page.
What order means setting aside that mutation in the name of Sadhin?
That order is set aside.
Right,
and
then?
the appellate authority directed to BLRO to file a fresh hearing. In that fresh hearing, I have stated in the my prayer was allowed.
Tell us what you have stated.
My prayer was allowed.
Your prayer means when did you come in?
Kaushik prayer was allowed.
Say that.
Yes, that is.
Kaushik's prayer was allowed, mutation in his name.
Yes. Now, challenging that, the private respondent preferred an appeal after 5 years.
5 years, 6 years.
Now, kindly see this right side. The Kaushik prayer was allowed. That was not complied with. So, the right side column, miscase was initiated. Against that, Kaushik preferred an original application against the inaction before the landed tribunal. Now, the next page, the contempt file, tribunal set aside the order of the BLRO, direct for fresh hearing, another miscase file. Now, that proceeding.
Directed, set aside the order of the BLRO means
in the compliance proceeding.
Sukhendu's appeal was allowed, that therefore.
No. Yes. No. Initially, Sadhin filed an application for
Sadhin filed application, mutated in Sadhin's name. Kaushik challenged. Kaushik's appeal was allowed, remanded to the BLRO. BLRO was directed to give a fresh hearing. After fresh hearing, what happened?
After fresh hearing, that is favored in the Kaushik.
Favor of Kaushik. Sukhendu challenged that after 5 years.
After 5 years, that is another part.
He won that appeal.
Yes. Yes.
And it was sent back to the BLRO or outright set aside.
Against that order, I preferred the present original application, that is with section 5, that is impugned before my lord. Now,
saying that he was not party to the proceedings.
Yes.
He was not aware. He got to know in September 2021. That is his explanation.
Yes,
under section 5 application, even in this writ petition.
Another 2 original application on the
fully
file.
suppressed the fact that in party, they made an application for addition of party before the authority, and addition of party was allowed.
No.
We are getting afraid of your.
No.
You are shivering at your attitude.
No, I'm sorry.
In the original addition of party, in my original application, that is pending. अरे बाबा ही तो तपन बेज the
Ghosh, don't confuse us thoroughly. We are confused, but we'll be confused thoroughly if you continue like this. Shukhendu's appeal was allowed. It was BLO order was set aside. BLO order by which it was mutated in the name of Kaushik. That was set aside. You have challenged that now after a delay before the tribunal. You were never a party in any of these trial court, the tribunal or anywhere.
No.
Nowhere.
Left side in that appeal, prior to transfer, I was not the party.
Where were you a party then?
Now,
In the application for implementation filed by Kaushik, you were a party.
in the implementation, the original application filed against the order passed.
You,
by the
you were implicated there in place of Kaushik.
That is, as an applicant, I have filed.
You have filed an application for implementation of a particular order.
That is, originated from the Kaushik's.
Yes, you filed for implementation of the order passed by the BLLO in favor of Kaushik.
Yes.
So you sought for implementation of that.
Yes.
But that same order has been challenged in appeal by Shukhendu.
Yes.
And he was successful in that appeal ultimately.
No, that in the appeal, before the appellate authority succeed. Against that appeal, the two appeal is there, two LR appeal is there. Against that appeal, I preferred another original application with section 5. My contention is that in that LR appeal, I was not the party. In my appeal,
We are repeating what we said. Kaushik's BLLO, after a point of time, recorded in the name of Kaushik after the first round of litigation. You sought for an implementation of that in favor of Kaushik. Let it be mutated in favor of Kaushik, and you got yourself substituted there, or you filed the original application?
original application fresh.
Fresh. Now you ask for substitution, mutation in your name now, because you have purchased.
My lord.
In the meantime, Sukhen had filed an appeal against that order in favor of Kaushik, where they succeeded, against which you have preferred this appeal after a delay.
Yes.
But since you had filed that OA, in that OA it was never disclosed that this has happened and appeal has been preferred against that.
That was not known to me. I am not that party.
You were the applicant in the implementation order.
Yes.
In the implementation application. In the implementation application, they never disclosed that I have filed an appeal that has
They
been
were
set
not
as.
party. In the subsequent original application, they prepared an application for addition of party. From where I come to know, my lord, that the appellate authority passed an order wherein that order was set aside.
Then they challenged that.
That is appellate authority's order in their favor.
You are confusing between pronouns. Your you is they and they is you.
Mr. Dhod's client,
Let us call him Shukhendu.
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 Shukhendu was not a party in your way.
No.
In your other way.
In the other way. Shukhendu filed an application.
See, your instruction is going against you.
Three original application is pending before the learned tribunal. One is 3020 of 2018 filed by the present petitioner.
For what relief?
For the
implementation.
For the against the inaction for not implementing mutation.
That is not implementation.
Yes.
Then why did you start with no? Your way is for implementation.
Yes.
What are the two other ways pending?
Another is 2300 of 2020.
We were not interested in numbers. At whose behest, for what relief?
That is also behest on behest of the present petitioner.
For what relief?
For the implementation which was sought for by the Kaushik, that was rejected by the BL and LRO subsequent stage. So
why rejected?
Another way proceeding initiated. That proceeding I have challenged before the that one kindly comes to page 18.
We won't come to any page, Mr. Ghosh, unless you clarify your stand. You said there are three ways pending. Kaushik's order was there, subsisting in favor of Kaushik. BLR order in favor of Kaushik was still then there. You had filed an way for implementation. Kaushik also filed an way for implementation.
Initially, Kaushik filed this way. At that time,
what happened to that? That was dismissed.
That was the
dismissed or not?
Dismissed, my lord.
Why?
The appellate authority dismissed. That was not challenged.
That is the answer to why it was dismissed. On what ground? Apart from the list of dates, have you gone through anything? Or should you do that exercise for you, Mr. Ghosh?
I shall bring all the three ways.
You won't bring anything. We will dismiss your application if you are not satisfied right now. you won't be able to bring anything else unless you are ready in your matter. You have wasted sufficient time of the court. Now, no going back.
No, my lord. Sorry.
3 OAs pending, one by Kaushik, dismissed.
3 OAs by the my lord,
Answer us yes or no. 3 OAs pending, yes or no?
pending.
Yes or no? 3 OAs were pending. One was by Kaushik, which was dismissed, yes or no?
Kaushik not preferred 3 OAs. Upon the
One OA was papered by Kaushik for implementation of that order of the PLRO, yes or no?
yes,
What happened to that? That was dismissed, yes or no?
that was dismissed.
Yes. What was the second OA now? By you.
2018,
You had filed also another way for implementation of the self-same order.
my lord.
That is still pending.
Yes, pending.
What was the third OA?
Third OA, my lord, the pending 12 in the
What was the third OA for and who
third OA
filed?
for my in the Kaushik matter, appellate authority passed an order. That order challenged by me since I have
The
purchased.
third OA is this way, which has been now dismissed on the ground of
This is the second. The third. 20.
third, not as per chronology, as per our discussion.
Yes, yes. Well, this is a
Sure, Mr. Shahu, come forward. Mr. Shahu, please come forward. We invite you to. Up to Kaushik, we are clear. Mutation directive. At that point of time, one implementation application was filed by Kaushik. That was dismissed. Kaushik's application for implementation of BLR order, was that dismissed?
Yes. Against which the Topon preferred appeal.
You preferred appeal.
Yes, my
Acha.
and that was keep events against which we preferred original application.
Acha. So your application was first challenge was against Kaushik's application's dismissal.
No, yes, madam.
Kaushik had applied for implementation of BLR order, right?
Yes.
Which was dismissed. Against that, you preferred an appeal.
Yes.
You preferred an appeal. That was dismissed.
That was dismissed.
Against which you have filed this present OA. No.
Madam, we filed an application for we filed an application for mutation. Topon.
Oh, you independently filed an application
for mutation. That was not considered. Topon preferred an original application. That is pending as yet before the tribunal.
Right.
In the said application,
yes,
my learned friend client filed an addition of party.
Acha, there they disclosed that they had had that order set aside.
Yes.
Very good. So therefore, you did not have any knowledge in that of that appeal before that.
Yes.
You were independently proceeding for your mutation that was rejected against that OA that was pending. There, Tapon filed and this person filed, Sukhandu filed an application for addition of party and disclosed that I have already obtained this order. So that was the source of your knowledge.
Yes.
Let us see why it was dismissed by the tribunal. I fully appreciate the tribunal's predicament. The reason given is that explanation is not cogent, consistent, and unimpeachable. That apart, explanation put forward by applicant is marred by lack of clarity. Fully appreciate. Fully appreciate it. And we should affirm this for this only. Yes, what do you say? How could he have knowledge? Don't be so dramatic. What are these?
This is an application under Order 1, Rule 10, filed by them seeking implement in that appeal. Now, kindly come.
This was not discussed by the tribunal.
No. Kindly come to the tribunal has overlooked it. Kindly come to.
Was this before the tribunal?
Page 274. Kindly come to page 274. They have annexed. They have annexed everything. Now kindly come. First come page 271. Page 271.
First decide which page we should come to.
I'm sorry. Page first 271.
271.
9th April 2018 on the right hand side. My lord has got it.
Got it.
3, 4, 5 Topon Bej, Sanjeev Bej. My lord has got it.
Then, my lord, notice for hearing of appeal case number 320T of 2017, my lord has got it. So these are
This was your appeal. That
yes. Now, my lord, kindly.
so they were also parties.
Yes, my lord, kindly come to the page 274.
Yes.
Page 274, my lord, notices duly served, SR filed with the CR. Both parties are present by filing Hajira. Kindly excuse that both parties hard at length.
That's why did you implead Topon as a party? By then he had purchased.
They came and they filed this.
This was the
application.
no. This application is for addition of party to that appeal. But these are contradictory. Then this notice of the appeal was given on the respondent. Why?
Kindly come to page 2, my lord, which I have handed up. My lord, kindly see.
No, we are asking. This application for addition of party was filed by them on 22nd of February 2018. This was allowed. They were added.
It was allowed.
They were added. That's why.
Notice. No.
That's why on 9th of April this notice was given to them.
Yes. 9th of April, then 30th May. My lord, kindly come to 30th May's order.
No. 30th May, yes. File Hajira had that link.
On the previous date, their February application got allowed in the month of April. Only they want to take the advantage. Why authority has written both parties.
No, 1 minute. Which order allows that application?
24th April 2013, order number 2.
2018. 24th April 2018, not 30.
Yes.
So on 24th April, if that's 24th April, if that application is allowed, thereby adding them, how could they be given notice on 9th of April?
February they had filed the application before the authority.
But before that application is allowed, they're not a party. Why should a notice of the appeal? You have shown them as respondents.
That's how they work, because they whatever application being received, all the parties will get the notice, so that everybody can come and whatever.
Just because you don't know how they work, you are taking advantage of it.
No, not that. My lord, kindly see that.
Yes, Mr. Galip, they work like that. If you file an application for addition, if they're not parties, they're shown as respondents. Who works like that? Nobody. There's some discrepancy somewhere. Either they were originally respondents, because on 9th of April, they had filed an application. How do you describe them as respondents?
22nd February.
Anyway, they were added on their application.
Yes.
So in 2018 itself.
Aware.
And the OA was filed when?
In 2021, kindly come to their.
And they said they were never aware of this appeal.
They were never aware. Kindly come to their averment. Kindly come to page 3 onwards. Para 3 till para 5. What they say.
And 4th of June order records the added parties are also present. Yes.
Only they got to know on 23rd September 2021. Whereas I could show that notice was served of 2018 and their application were entertained, they were added, they were hard.
No, but this application which you handed up, Dorkhasto, Sudhanshu Shekhar Jana and others.
And Shukhen and the Kaushik Nayak, their vendor.
Their vendor was a party, not
Yes,
them.
they filed that application bringing this fact that the Nayak
is their. Oh, Topon Bej has signed here.
Yes. Well, all of them have signed. Bringing the fact that these are the new purchasers, let them.
But he did not point this out before the tribunal. Tribunal does not. Lack of clarity. Tribunal was in a similar predicament as us. For justified reasons. Yes, what do you say to this? Sorry.
My lord,
what is your stand?
I am, in addition to what my learned senior friend Mr. Dhor has argued, my lord, laying the blame on the advocate. My lord, cannot be, my lord, ground for condonation. My lord, my lord, kindly sees the, my lord, section 5 application, my lord, at page, my lord, 205, my lord, of the petition, my lord. Kindly sees 3 paragraphs. 4, 5 and 8. Kindly seize.
Page 6 is missing in our page, in our copy.
6 is, they are,
No.
6 will be
Page, no.
211.
Para 2,
Yeah,
internal page 5.
in my page also same situation. So may I read out para 4 first?
Which is
Page
not there
2
in there, not there in there.
Page 211, Lordship has page 211.
Oh, acha, acha. The
Kindly
pages have,
seize.
those have been interchanged.
Yes.
Yes.
So kindly see that there are communication gaps between the learned.
Not blaming, communication gap.
One minute, Lordship, therefore. And the learned worker were unable to inform anything to them, so and so. Now 5. Para 5 is at page 210.
Yes, yes.
Backward. On so and so, the applicant made their advocates and requested him to inform the date of hearing their case. And that time, the learned advocate told to the applicant that one so and so an application for day and their vendor lost his case as a document enclosed in the application. Applicants came to know the above facts for first time. This one. Now, para 8, kindly see. Below page 210, para 8 is
yes,
there.
yes.
On so and so date, the applicant number 1 went to the chamber of learned advocate collecting papers with no objection, and the learned advocate made no objection and also handed over documents.
Not a serious challenge.
One minute, sir. Lordship.
No.
Kindly now 212. This continuation of para 8 is 212.
Yes, yes.
The applicant found that said learned advocate failed to appear several dates in their case and also in the cases of their vendor in WPLRT. Sometimes another advocate appeared. So many, it's a laying blame on the advocate, non-appearance, this, that. Well, this almost Supreme Court has deprecated.
You are for whom?
This one, Lordship, kindly check once this.
You have to add or subtract something from that. You can only subtract from
Kindly
something which is a
see-
ghost said. Otherwise, it's against.
Lordship, kindly check this.
You are the vendor. You have also suffered similar fate. You don't have a direct interest as such, apart from answering to them. Says what? Sees what?
That blame on advocate cannot be a ground, my lord, for condonation.
Oh, judgment.
The proposition, this judgment of 25th November, 21st November 2024.
Yes.
Reportable. Kindly seize, my lord, the issue. Para 5 is the issue. The first appellate court condoned the delay of so and so days in preferring appeal essentially on the ground that the litigant should not suffer an account negligence on the part of the advocate, and the court should adopt a liberal approach in condoning the delay. Para 6 next. Responding hearing being dissatisfied with the order, the first appellate court condoning the delay, challenged this before the High Court. The High Court allowed the civil division application, but the order passed by the appellate court condoning came to be quashed. Then against that, before
This
the
has been reported, Mr. Agbale. You should have
Lordship.
cited the reported judgment.
Now, para 10, Lordship.
This, para 10, this judgment, Justice Belatividi's judgment, these are being circulated.
Para 10.
You have seen this.
No, Lordship.
Careless litigant cannot get the advantage. Answer.
And only one thing, my lord, that was not known to me that in that proceedings, for the reasons I make a submission.
Your client suppressed to you also.
Yes, my lord, only my lord, the two my lord get justice. What I am praying, my lord, since in the similar issues and similar plots of land, other two ways are pending. So, my lord, in that event, kindly direct the tribunal to hear this application on merit also. Otherwise, this.
You will not direct anybody anything. Sorry, that is beyond the scope of this. The present challenge has been preferred against the dismissal of an original application filed by the petitioners, challenging the dismissal of the petitioner's vendor's application for implementation of an order passed by the concerned PL and LRO, directing mutation to be effected in the name of such vendor by virtue of a purchase. For some next para, in the meantime, the said order of the BL and LRO had been challenged by the private respondents, successfully, thereby setting aside the order of the, thereby having the order of the BL and LRO set aside. For some next para, the petitioners, the present writ petitioners, according to them, learned of the said proceeding much subsequently and immediately thereafter preferred a challenge to the order whereby the order of the BL and LRO had been set aside. The said challenge having been dismissed on the ground of limitation upon dismissal of the condonation of delay application accompanying the same, the present writ petition has been preferred, challenging such order. For next para, learned counsel for the petitioner submits that the petitioners were not aware of the appeal having been preferred by Shukhendu, what was your surname? Jana. Shukhendu Nayak and others, the private respondents, Full stop. Immediately upon coming to know of the same, comma, they had preferred the appeal. Full stop. Importantly, comma, it is submitted that in connection with the self-same proceedings, comma, the appeal filed by Sukhendu Nayak himself, comma, against the order of the BL and LRO, after lapse of about almost 6 years, was entertained and allowed. Full stop. To draw a parity, comma, it is submitted, comma, the delay of about more than 3 years occasioned by the petitioners against in respect of preferring their challenge should also be allowed. Full stop. Next para. Learned counsel for the private respondents seriously opposes the application and submits that the writ petitioners had suppressed that they had made an application for being added as parties to the appeal filed at the behest of Sukhendu Nayak. Full stop. In fact, comma, the petitioners had been added as parties thereto as long back as in the year 2018 and thereafter had appeared in the matter, comma, having full knowledge thereof at least since the year 2018. Whereas the challenge was filed before the tribunal in 2021, feigning ignorance of the earlier knowledge. Full stop. Next para. A copy of the addition of party application is handed over to us as well as to the learned advocate appearing for the writ petitioners. Full stop. Learned counsel for the state, comma, in principle, comma, supports the contention of the appellant of the private respondents on the merits of the case, on the merits of the present challenge. Full stop. Next para. Learned counsel for the private respondents, comma, in support of his contention. Sorry, you have cited this judgment. State,
yes.
Learned counsel for the state, comma, in support of his contentions, comma, cites Rajnish Kumar and another versus Ved Prakash, where the Supreme Court reiterated that over a period of time, a tendency on the part of litigants to blame their lawyers of negligence and careless in attending proceedings before the court has been growing. Full stop. Even if it is assumed for a moment that the concerned lawyer was careless or negligent, comma, this by itself cannot be a ground, comma, the Supreme Court held, comma, to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own rights and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. Full stop. The litigant, comma, it was held, comma, should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. Full stop. In the present case, comma, although certain aspersions have been cast on the then advocate of the writ petitioners due to the alleged non-appearance of the said advocate in the connected proceedings, comma, the more basic malady in the case sought to be made out by the writ petitioners is the gross suppression of the fact before the tribunal in their application for condonation of delay, comma, of their having consciously filed an application for addition of party in the appeal filed by the private respondent Sukhendu Nayak, comma, against the verdict of which the challenge was preferred before the tribunal. Full stop. Next para. From the order sheet, comma, we find that from the order sheet annexed to the writ petition itself, comma, we find that as long back as on April 24, 2018, comma, the writ petitioners were added as parties to the appeal itself and therefore had full knowledge of the pendency of the appeal and had also participated therein. Full stop. From the application for addition of party filed therein, comma, which is handed over to us, comma, we find that the present writ petitioners had also signed the said application, comma, thereby having full knowledge of the pendency of the proceedings and having participated in the said proceedings, comma, whereafter it did not lie in the mouth of the petitioners to feign ignorance of the appeal and come up with a challenge against the order passed in the appeal after 3 years. Full stop. The very premise of the application for condonation of delay was mala fide, comma, inasmuch as the petitioners having full knowledge of the pendency of the appeal at the relevant juncture and having added themselves as parties, comma, could not take a plea that they learnt of the appeal of the decision in the appeal for the first time much later. Full stop. Thus, comma, although the learned tribunal attributes the dismissal of the condonation application primarily to the inconsistency and lack of coherence in the case made out by the writ petitioners, comma, we are of the opinion that in view of the additional grounds supplemented by us above, comma, the conclusion of the tribunal in rejecting the condonation application of the writ petitioners was perfectly justified and need not be interfered with. Full stop. Accordingly, WPLRT 118 of 2025 is dismissed on contest, comma, thereby affirming the judgment and order dated April 21, 2025, passed by the West Bengal Land Reforms and Tenancy Tribunal in MA 792 of 2021 within bracket OA 2300 stroke 2021 bracket closed LRTT. Full stop. No orders to cause urgent certificate. Thank you. Next.
For the private response.
You are for the?
I'm assisting, Mr. Yeah, I beg to represent the state respondent.
I'm for the petition.
Yes,
the matter. Is the order against petition against the order of land tribunal.
You do these matters also, Mr. Mitra? I have no idea what.
Is the order of reversal of the order district settlement officer.
Since it's a family matter, Mr. Mitra, you should refer it to conciliation.
Yes.
From your
Now,
side.
These all relates to a record of rights of a plot number 104. And the point is whether my name should be recorded, my predecessor name should remain there or their name.
Before my learned senior friend starts, there are few documents which have not been annexed to this, which are very important. Our CSROR, our RSROR has not been. Entire CSROR, entire RSROR.
If you want to rely on those documents, you exchange and come back then.
আচ্ছা তোমার লাগানো আছে লাগানো আছে পেজটা দেখিয়ে দাও পেজ দেখিয়ে দাও all referred to in the petition but
only referred in the pleading but not in entirety, not at least 50 CSROs in my name, 50 RSROs.
সব না নেই সবগুলো নেই it's not entire is not there.
Not there. State also says so. You are for the private response.
Even state has
The state also
a letter in the year 19.
So, Mitra, both the state and the private respondent say that some documents
because
are not there.
state has
Not
one
related.
way by itself. State filed one.
So we can do this. You can exchange copies.
they show the copy. I don't mind. I have got an annex, but they show the copy.
During hearing, but you will be taken by surprise then. They say 50 CSR are in their favor.
There.
But in case they say it's not there, let them give.
That is what we are proposing. So
May I shortly tell you?
We'll formally commence the arguments. We have commenced the arguments. We'll record that, but we'll direct them to exchange copies of this.
But I was telling you how when the Estate Acquisition Act came to operation 1st of August 1954, the name of Kashi Prasad Singh.
Thank you, Mr. Bhattacharya. Yes.
Singh was recorded as a riot in respect of his plot number 104. Very good. That continued. And ultimately, that continued. And then in 1998, you are having Bardjut too. They produced another Khotiyan number of regulating same plot, recording their name. So there are two conflicting Khotiyans. Matter came to our High Court.
That was at the CS stage. CS Khotiyan.
Yes.
RS.
No, that was CS.
Which year?
No. That was the later one. RS. Yes, that. But first, initial CS, in the name of that our predecessor, KP Singh.
Your predecessor.
Who was the original owner, who sold the property to us ultimately.
Right. CS in your predecessor's name, then RS came.
It's a 6-3 property. It's a 6-3 property.
Was in our name. They do not have any CS. They only have RSR1.
I'll just reverse it in my mind. We'll just reverse it in our minds.
Allow it to of incorrect হতে পারে কখনো।
CS in their name, RS in your name. We have reversed, already reversed. Now don't re-reverse.
The Khatiyan they produced, they make up two Khatiyans.
Right.
Contradictory, like same plot of land. Matter came to our High Court.
Yes.
Our High Court, by an order of 1998, directed BLRO to decide which one.
Sorry, please, to
decide.
To decide.
Which one to say. BLRO passed an order, which is at page 165, volume 1, volume 2, volume 2. And normally we wouldn't have gone to delay, but detail যেহেতু না তোমাদের attitude থেকে হবে. Volume 2.
Yes.
Short order 165. It is on record. Acha. Good. This is on record of board. Seen all papers, examined all available office record, 2 contradictory certified copies and connected with number 72 to 42 have been submitted by both. Hence, I have to rely upon the official record. Reconstructed Khatiyan, which have been prepared on 8/4/85 in the name of Sri Kashi Prasad Singh, son of Sachin Sat, is taken into account. Mutation made by JLRO Khadda appears to be genuine, but as LR work of the said Mauja has not been taken up, petitioners may appear before the KB, come attestation table, recording their name. Matter is disposed of. This is our Khatiyan found to be genuine. Our number. Yes.
Kashi Prasad Singh was your predecessor.
Kashi Prasad Singh, his name was recorded. Kashi Prasad Singh died. His heirs applied for mutation. That's why I'm omitting those facts. And
but it keeps his open-ended. It says, but as allied work of the said Mosa has not been taken up and all this.
Yeah, this is all the said.
Anyway, this is there. Then what happens?
The order, this is order.
Yeah, yes.
Then in 2016, this continued. In 2016, Bardu wrote 2 letters to the BLRO. Asked 2016. It is
they wrote letters.
Without intimation to us. Then BLRO on that letter started proceeding on a particular date, cancelling our recording, our creating a new Khatiyan in favor
without giving any notice to you.
No. This is bad. Interesting thing happened. On a particular day, BLRO on his own, but on this letter, corrected the cancel our Khatiyan, our ROR, started a new ROR, recording Barjut as the recorded one, and on the same day issued certified copy. Remarkable thing. Matter came out to the High Court. High Court set aside. Obviously. And said a fresh thing. Then fresh.
On giving you hearing.
And upon hearing us, this is the order of BLRO. BLRO passed an order.
Is it annexed, Mr.?
Yes. Can you see?
Just give us the page number.
Yes, give the page number. This is this. I've got a list of 242. The High Court cancel for final order.
Which page?
Page 200.
242. Volume 2. Volume 2, 242, Lordship.
Volume 2.
Volume 2, page 242.
Volume 2 কোথায় গেল?
Understood.
Sorry.
242. The page number I can't remember.
No. Difficulty. Obviously, they will assist you. Yes.
This is the order which became the ground. Case is taken up for disposal, etc. Thus we got page 242. After perusal of the documents submitted by BJEL and Rotatum is our client. Rotatum contained by BJEL means the Barjut. A BGEL and Rotatron is our client, and taking their submissions in course of hearing in consideration and carefully going to the RS ROR number 72 as available in office records, I find the following. Please, can you see? As per copies of CS Khotian number 41 of Muja Goladhata, jail number 27, respect of plot number 104, and also RS Khotian is respect of suit plot of the said Muja by Bart Jute. The said Khotian were in the name of Lansdowne Jute Company. Yes. As per reconstituted RS Khotian 72, a Mouja Golagata available in Mouja, volumes of Mouja Golagata, I must a mistake, and Mouja Golagata. In this office, same is found recorded in the name of Kashi Prasad Singh. But no reference Khatian is noted in the said Khatian, which may disclose the origin of the said RS Khatian number 72. It only appears on the noting made in the Khatian that said RS Khatian 72 was reconstructed by case number 22T of dated 8/4/1985. The successor in interest of Kashi Prasad filed a writ petition. Number is given to the Honorable High Court. Due to non-submission of copy of the writ petition by Rotatron, that is, to this end, the cause of action of the writ petition cannot be perceived. But it appears that Honorable Justice Sengupta disposed of the matter on 24/9/25, which I am referring to, with the following direction to the BLRO. To take up the application of the petition, they may accept for consideration, and the time of consideration dispose of the matter as the 5 shall be served the order ex notice and shall be heard upon fight in accordance with law. Now, my lord, the matter came before him and order is recorded from the copy also. Now, in paragraph 4, it starts with finding. It appears from the document submitted by Rotatron that a proceeding such and such was initiated by BLRO, Barakpur, which was disposed of on 13/11/1988. From the photocopy of the order as produced, it appears that the BLRO, Barakpur, has observed that the reconstructed Khatian, which has been prepared on 8/4/85 in the name of Sri Kashipata Singh, is taken into account. The mutation made by JLRO appears to be genuine. About is found to be genuine. One SP Mukherjee on behalf of Bart Jute filed 2 letters dated 15/15, where the application bears allegation that not providing information in respect of writ plot number 104, as well as Khatian respect of said plot, etc., Golgolagata in the said application, it was also stated that land was allowed to be retained by Lansdowne Jute under section 6(3) of the West Bengal Acquisition Act. Then it comes to 6(3). This is important, the core of the matter. And the illegal case of mutation on the subject was held and recorded in favor of the third party, in a third party. On the basis of the letter stated above, BLRO initiated proceedings over a miscellaneous case under section 47, not Suomoto, which was disposed of, and the same Kashipata Singh was declared cancelled. I told you the entire history of I've told you also that. Then, meanwhile, success interest of Kashipata Singh transferred the land to the BP Poddar Foundation by means of several registered deeds. Salient relevant portion of the oral and written argument are limited as follows. Written arguments, etc., noted below. Now let's come to the conclusion part. Can we come to page 253? Arguments noted and conclusion part can we come? 251 onwards. 251. Yes, 251. You're right. You are 251 middle. Now it appears that the record submitted by Rotatron that the such interest of Kashipata filed a writ petition before the High Court, Calcutta, Honorable Single Judge, to consider the matter in accordance with law, if any is allegation of forged and fabricated documents being used, then the said authority shall not decide the matter and shall leave the matter for proper adjudication by appropriate forum. A proceeding before Miss case was initiated by the Barakpur and this forum, etc. Which is clear that the two contradictory, these are not facts. I was coming to the main part. You prevented me. এগুলো তো জজকে বলা হয়ে গেছে এগুলো back to even a production of contrary documents. বাজে বাজে সমস্ত কল that 252 and please come to page 2. This is the relevant part I wanted to place. This is the order portion.
253 or
252.
250. Mr. Mitra will recommence after the recess.
Yes, take the fine.
Will recommence after the recess. Come here.
Instead of
No, instead of. Come back.
my learned junior has. Should I have
No, let Mr. Mitra, let us see how long he continues.
tomorrow?
No, first is lack of document.
You can exchange your papers in the meantime, during recess.
You want adjournment, what you tell clearly and properly. Why take
No, we'll continue with the matter.
I'll continue.
Your junior will not come back today or some other court.
Matter in NCLT, so it will.
That will be over before Mr. Mitra finishes.
No, you could get time to
My lord, item number 15, my lord, possibly asked me to appear on 14th, my lord. My lord, I may be out of station on 14th, my lord. In that matter, my lord, I have found from the records
Mr.
that
Let us not disturb the current matter. If you're there, ask some of your friends, any of your friends to ask.
I'm not there in that.
Some of your friends here, ask any of them to prefer an adjournment on your behalf on that date. You have directed it to appear, it will appear. Ask somebody to ask for adjournment for a day and inform the other side in the meantime. Yes.
Very please, Lord Miller. Where is page 252?
What happened to that matter?
It is there. I will not be able to appear because I chose to assist my senior in this.
You know,
Yes.
Before my learned
Right
senior
now.
friend starts.
He has almost ended. Sir. Yes.
In the second half, we got to know that our
May I, Lordship. After passing judgment was delivered, the judgment under challenge was, my lord, delivered in the month of May. My lord, this application comes in the month of August. In July, my lord, we have already, my lord, in compliance with the, my lord, judgment. We have already
Just
changed
you
the
speak
record.
into the microphone.
My lord, in compliance with the order under challenge, we have already changed the record. As on date, my lord, the record stands in the name of Lansdowne.
That will be subject to the outcome.
Yes, so scope of interim.
That with you for the
On 3rd July, it was changed.
Government is total complicity with this private party.
It is
Which is by filing an affidavit showing
Our-
that, I show that. And he's saying so, can you take instruction? We have taken this certified copy
6th of August.
on 6th of August.
Still shown in our.
And when you were corrected, my dear friend, this is the order. Taken on 6th of August. And not yet affected.
According to you, when did you correct? 3rd.
3rd July, my lord, 2025.
that is
What is it?
that is RSROR. That is
Does not disturb the hearing.
Will this make my petition not mentionable?
No, does not.
Why are these things? Is it relevant for the question of interim orders? Let me get rid of this main meeting. That's page 252. That I go on my own. I'll not read the relevant. I'll come only relevant part. We are moving at a motion. We are not hearing the. Now please come to 253. I have read that. Kindly please come to 254. Here's the finding. 252.
Yes.
See them regarding 2 Khatyan. What the finding? Regarding keeping in conformity framing records from CS stage in the RS operation, name of Lansdowne Duke should have been recorded in response to RS record of right against suit plot number 72 as the intermediary under the state coming under Badview second 6.3 should have been recorded. 6.3. But recorded as a what they put. No such document has ever been produced from any corner which can corroborate the recording of the plot in the name of Kashi Prasad Singh in the reconstructed P.S. Khatyan with royalty status over subject land. This is settled law. The record of rights has presumptive value. Then, reconstructed RS number 72 present in the Mauza volume in the name of Kashi Prasad Singh is seemingly erroneous. It is genuine, but erroneous. Why? Because without any base, erroneous without any basis. Because another ROR that produced by Lansdowne Duke is also incorrect in respect with the status of riot as recorded against Lansdowne. No, SR 72 produced by Lansdowne Duke is also not taken into consideration, as no such Khatyan is found in the Mauja volume. Kindly mark that. Non-existent thing that they produced. Ours was found on the record, but according to incorrect. Why incorrect? I'll come to see that. The 72, again. I keep this view that RSR number 41 should stand after due quantification recommendation. Why? See the order. Hence, order that RS number 72 containing name of Kashi Prasad Singh is found as found in Mauja volume, be cancelled. And RS Khatyan number 41 be prepared with modification in the name of Lansdowne with due noting of retention order 6563 of the Wood Act. Because the retention order, he is now saying that this is a new Khatian should be started. Because in the Khatian they produced, they mentioned as riot, not as intermediate. There is contradiction against 60. So the basis of this order is under section 6.3 retention order under the Act. Now here comes the more core of the thing is this order of retention, which I'm going to say. What is the retention? No original retention order has ever been produced, even by the state or by anybody else. Nothing. And this retention order, which are produced, they are relying on an alleged photocopy, which is here. I'll come to that later on. Immediately go to your lordship and show what is happening. From this order, prefer an appeal to DS, District Settlement Office. Please come to Millard, page 341, volume. And I did the relevant portion, Millard. And please don't request me to read other pages, which I don't consider relevant. The time is short. He has to come here as a motion today. Yes. Now, Millard, can you come to page 346? Hard both parties. Argument relies on judgment, omitting that.
Yes.
Yes. Comely after page 347. First, this court has no jurisdiction to decide the title over the suit land, correct? Record of rights, correct? This court, I can tell you incidentally here, a title suit has been filed by them, this bar suit. And it is pending. Pending. And it was filed before this. This court can only deliberate on the correctness of the revenue records, and possession is very vital to frame the ROR in law and correct. This court ordered SDLRO, Barakpur, to submit an inquiry report over the suit land. Accordingly, he has submitted the same on due inquiry. It is not necessary to give opportunity of being heard during field inquiry as the field inspection. As per report submitted, it is observed that there is or was no existence of factory on the said plot of land, and the jute mill and the said plot are different mozas. The appellant has possession, that's my client's possession of the suit land, is admitted by them in a title suit. They're asking for recovery of possession, prairies. And the same was admitted by respondent number 2 during the course of hearing. That is admitted. Then, apart from that report, forget about report below. It appears respondent number 2 by TS number 42 of prayed to appropriate court in law for recovery of possession. This matter is pending. This is to be reiterated. The title of the suit land will be decided by the appropriate court. But it supports to come to this conclusion that respondent number 2 is not in possession. The approved building plan and the holding number issued by the municipality. Our case is premises number of Golaghata Main Road, and their mill premises is number 200 Dokindari Road. All have municipal number. See also support the possession of the appellant over the suit plot. On the point of this is important. On the point of 6.3 of the said act, it is argued that the respondent number 2 got the retention order from a department. However, respondent 2 has failed to produce original and annexure the said order, despite being given ample opportunity. Also, the copy of annexed land schedule of the detention order produced does not bear any signature of appropriate government authority, and the calculation of total area mentioned therein is erroneous. It doesn't tell you the main order, different case. Hence, this court is not satisfied over the retention order submitted as number 2. This is the reason he has given. Apart from this, reply of the RTI petition goes against their claim. Although this order was submitted by BLRO as part of affidavit before the LRTT, but which disposing of the LRTT, Honorable High Court is given every liberty to the Revenue Authority to re-verify every document before coming to its conclusion. The most vital point is that RS Khaitian number 72 is present in the official Muza, BLRO has administered volume, and BLRO White proceeding of Bhai Boniti affirmed the Khaitian. This order was not challenged. It was 1998 order, not challenged. Also, as per annexure of the memo of appeal in the paragraph 9.3, filed by the respondent number 3 and 2, that the assets of the respondent number 2 was taken over by Bharat Process and Medical Engineering Limited. That's another government took over, which subsequently went into liquidation. This is important. But official liquidator High Court, upon inquiry held, the suit land is not a part of assets of the company under liquidation. Now, on the basis of this above observation, impugned order is set aside. Appeal is admitted. BLRO Barakpur is directed to restore RS Khaitian 72 as it was before institution of the miss case number 7 charge. Certified copy of order may be given. From this order, appeal was prepared to LRT by Barjut. After about delay of 400 years, about delay of 400 days, state government filed another appeal, same appeal, language same. Now, Barjut had applied for interim order. Now, at that time, interim order refused by the then LRT. Because there are already orders against, in the title suit, there is an order. In the High Court also passed an order that my client would not alienate transfer of this property. I should place the order. And this party, Barjut, have been constantly trying to prevent construction. That injunction restraining construction has been refused. Order is there. High Court said, where you let them construct, they construct their own risk. If it is now held that title belongs to not you, and they will suffer the consequence. That order is there. Now this order of SSDS has been set aside by the LRTT without dealing with the merits of the argument, that for this reason, I hold that retention order is not reliable. You should know how they deal with the matter. Nobody before the settlement officer took the point that the appeal before settlement officer was not maintainable. Nobody took the point. See that? Now, LRTT on their own took the point that this appeal before district settlement officer was not maintainable. Therefore, order is set aside, thereby avoiding dealing with the matter of notice. This is the position.
Did the settlement officer have jurisdiction? Otherwise it hits at the root of the jurisdiction.
Nobody disputed, nobody disputed the jurisdiction.
Mr. Mitra, a point of law, pure question of jurisdiction hitting at the root may not be taken.
Yes, correct. But if it is purely point of law, it can be taken later on. But question of maintainability of appeal, which you did not take before the appellate court, then from there you pay for an appeal, and before that appellate court, we also don't take the point. But tribunal on its own raised the point of maintainability. I tell you why. And we deal with the point, and when the matter is hard, I shall satisfy that appeal was not maintainable. Yes. Now, kindly bear in mind another factor. When Bardwood applied for interim order, and they took the point in that before in the application that appeal before SD, this settlement officer was not maintainable. That point was not held in their favor. Interim order refused on another ground, that's the ground. From that, that order remains. That is, one may say, that is the interlocutory order, but must have should be the point that decided finally. For the lawsuit has to peruse the order. And there can be procedural res judicata. If a point is decided finally at the one stage of the proceeding, then that becomes binding in the other second stage or later stage of proceeding. But I shall meet this point on merit. Merit that it was appealable. Why? It was not an order under section 47 of the Act, because it's order based on section 6(3) of retention order, which is not part of 47. Number 2, 47 application lies for intermediary character, determination intermediary character. That can be cancelled under section 47. But here Miller rights is cancelled under 47, which cannot be done. I mean, just give you briefly my points. We should decide that point at appropriate time. If we have to final hearing, we shall do it finally now. Whatever my Lord pleases. Now, the main question therefore is, has there been, see the everything, any order under section 6(3) retention order in respect of this plot of land, 104, which now bears a municipal number of Golagata Road, number 115 Golagata Road. And in the municipal records, the names of Kashipurja Singh, these heirs, then the trust who purchased, their names are recorded, municipal records. In the municipal record, their name is not recorded, but due. Now let's see the order. My humble submission, suppose appeal was not maintainable. But the then question arises, was the order of BLRO correct or not? Will it be sustained? For that, we have to see the reasons given by a quasi-judicial officer why the order of BLRO is not correct. Namely, why 6(3) cannot be relied upon. That this LFT has avoided by holding the order is supported by government, but no original order put. Now, kindly see that order. Kindly see the order which was produced by Bardgut, page, volume 6. Can you go to volume 6, page 820. Now, BLO order in reliance upon this 6(3).
800?
824. Now, he has supported accepted BLO order without deciding whether this 6(3) order can be at all be satisfactory, relied upon.
824 is the entire order?
824 million. P40, 824. Is it the order a copy?
No.
Original is not seen.
This is not an LFTT order.
My lord.
So not an
Detention order, Lord.
60 order.
order.
Detention order.
60 order. 60 order, a copy of that order, certified copy is not produced, original not produced. However, this could be relied upon by BLRO. Similar, ex facie question is whether this order covers plot number 104. Similar, this order I may read, where the land measurement more or less 50 to 150 acres comprise in the mill, hereinafter called the said mill, held by Lansdowne Jute, that's for the name of Bard Jute, Limited, in the manner Golaghat, in the Muja Golagata and Ultodanga jurisdiction. The land in Golagata Mauja, mill premises Ultodanga Mauja. 27, 25, arrested should be. The police station, Dum, etc., from the incumbents under Section 8, vested in the state government from the encumbrances under Section 5 of the West Bengal Acquisition Act. And whereas, after inquiry, state government is of the opinion that 52.73 acres of land is required for the purpose of the said mill. Said mill premises given Miller, that is Mauja Ultodanga. Now, therefore, in exercise of the power conferred by subsection 3 of section 6 of the said Government Act, government is pleased to declare that 52.7 acres of land being required for the purpose of the said mill may be detained by this mill in accordance with provisions of law. Finding is that no mill has ever been located on this plot number 104. Number one. Number two, the mill premises is in Ultodanga Mauja. Plot 104 is in Golagata Mauja. Number SD. Lordship find no reference to any schedule in order. So how does one say that this 52,752 acres include or refer to plot number 104? Similar. How question is whether if this sheet was issued, even if issued, whether this is comprise plot number 104. There is no schedule to this order. This is thing. Now, my lord, a schedule is prepared by Bard Jute, bearing the rubber stamp of Bard Jute, and has been annexed by them. This rubber stamp has not come forward. Original data. You put 35 copy down. We have taken a certified copy of the records from LRT, because you also see the rubber stamp is very faint in this manner. Question is, my lord, an order which does not refer to any schedule, can it be made into the schedule not signed by the government officer, but rubber stamped by the Bard Jute and Company? Bard Jute and Company. And it is the whole basis on which order is being passed by the BLR and tribunal also on this basis. Crux of the matter is there. This is material at the time whether that we are giving to a lordship. But we find a rubber stamp in the last page, also you find that, but I'm giving you certified copy. On all pages, a rubber stamp. And rubber stamp of Bard Jute. Can you see me? The original, when it comes to court, those will see that this sample will be clear. The original, when it comes to Original comes to make it very clear. Bargood. But Lansdowne Duke, not Bargood, Lansdowne Duke. Lansdowne Duke. The name was Lansdowne.
The small round one at the bottom. Yourself can decipher, Mr. Mukherjee.
It is not disputed that is.
She can't decipher from this. Once you're saying Lansdowne one, once you're saying Bargood.
Lansdowne or bar, কার আছে? এ তৈরি করেছে কে? বার
এইটা কি?
করেছে?
একবার হচ্ছে Lansdowne, একবার হচ্ছে Bargood। আমি claim.
This original will be brought, let's see the original.
This is the photocopy of original.
Photocopy.
This is a certified copy. Original is not.
This is a certified copy by the tribunal. By the tribunal.
Tribunal is with
Now,
you. The original is with you.
Ask him.
Tribunal is obviously with you.
Ask me, learned friend, is it not disputed by them?
Is it with you now?
That is not the rubber stamp of the government.
Coming. Coming. I'll provide the originals of everything.
What does it say? Bargood. What does it say?
Does it bear the rubber stamp?
Sir, Boleni. 1993.
What does the rubber stamp say? Only this is the only question.
I don't
Rubber
know.
stamp. You are
what
saying
has
it's not Bargood. Whatever has been annexed here,
It is their annexure. It is their annexure.
I have the original from.
What does it say? The rubber
There,
stamp?
there is no rubber stamp. Perhaps this was filed before the LRTT, so company has filed it, that rubber stamp they are mentioning. Or before any authority that was used, so company has given that seal, that's why they are using it.
Just put the microphone aside. Yes.
I'm sorry.
Very good.
It is admitted the rubber stamp of the company, not of the government. This is not admitted.
Cannot be of the government.
Not of the government.
Jute we can see. Left top.
Now, Learned also says his client put the rubber stamp while making the annexure.
He says might be. Might may not be right in this case.
There now a new expression coming that Bargood has tampered with the document, put the rubber stamp and then annex it. Can you remember, can you bear this submission? They tampered with the document.
No, these might be photocopies filed by them before the tribunal. They cannot tamper with the original.
Photocopy may not. Here the government also annexed. Here the government also annexed. What they annexed? A photocopy of what Bard company had disclosed. Can you now see that? Can you please come to me, Lord? The page 505.
But does the main 6.3 order refer to these annexures? Doesn't.
No.
These are in
He
addition.
has not
They had-
dealt with this point. That's the point. He has not dealt with this point.
They want to supplement this order by these. These were filed by them.
Filed by them.
It's obvious.
Yes.
The 6.3, your contention is 6.3 order does not contain any schedule or detail.
It is annexed.
That remains. Whatever is annexed along with it is their doing. I mean,
Is
they are-
annexed to their own petition before the tribunal. Now, after 400 days, when the government filed the appeal, what they did,
This
they
is a chart prepared by the Bargood company. Probably.
but that and
Not
that's
the
the
extract
point.
of anything.
That's the
It's not
point.
the extract of anything.
No, not signed by any government officer.
These are not extracts from the records. Records are not like this. Particularly at that point of time.
Let Mr. Mitra submit one. I'll give.
Yes.
This is
So,
what today I submit. This is a highly arguable case to be considered by your court finally. Yes, that is
highly
whatever-
suspicious.
I can make final submission also.
Borrowing from Jatayu. Yes.
Quick submission. This is the point. And now see the, kindly see one paragraph of a state petition, what we have, where is summarized.
Yes.
Summarized. Kindly come to say paragraph, state petition paragraph, 33. Huh? page 43. I'll give you the page. We have summarized the cases which are made out. Please come to Milord, page 32.
Para 68.
Kindly come to last paragraph, para 68, and please turn the page. Tribunal had excess of jurisdiction and could not have relied upon the alleged photocopy of the order 6.3 on the Act on following grounds. My Lord, under Evidence Act, which is applicable, a government order is a public document, section 74. It can be proved only by certified copy or production of the original. Section 78 of Evidence Act of Civil. Neither certified copy produced nor original produced, in spite of opportunity being given to the government by DS. Please come to page 33. These are the grounds we have taken. Summarize the grounds. The document is purported to be produced by the respondent as photocopy, alleged order under section 60 was comprised of one sheet of paper containing the order, does not give any description of the land which has been allowed to be retained, and does not mention that there is any schedule or annexure thereto. Accordingly, the said photocopy of the said alleged order does not show or prove that plot number 104 was allowed to be retained. Mr. Milord, we have said in our opposition. Here, this is the statement we have made on affidavit, and I place the reply of the
The sheets of papers were not part of the section 6.3 order. The sheets of paper produced by them with the stamp of Barjut was not a part of the section 6.3 order in any event.
No, 6.3 order.
So 6.3 does not refer to it. We won't. They must have produced that to bolster, to strengthen the 6.3 proposition, their proposition. But those who we cannot treat those sheets as part of the 6.3 order. 6.3 order itself does, their copy also does not refer to any enclosure.
But my lord, I bow down to it. There may be an order on 6.3, maybe an order.
Yes, but it does not refer to any of the description, nothing.
Does not include plot number 104.
First argument, your first argument is that original not produced nor certified copy. First, it
Not
goes,
admissible.
even if that is taken to be a copy of 6.3, no description, nothing, no schedule. Thirdly, those sheets of paper cannot be treated to be a part of that because that does not refer to those even.
Any and there nobody.
And also another thing which Mr. Bhattacharya is probably trying to place at page 34, that the information you obtained shows that there is no record of that section 6.3.
And another fact, lots of area is mentioned 5.54 or something. Please come to page 34. If you add up that annexure areas, they will not tally.
The areas are more.
Areas less or more. Kindly see
Not tallying.
page 34. I have given the chart. Page 34, subparagraph E. Total area comes to 5.2129. CC 32 FE. Sheets of paper and enclosed alias copy, handling, etc., with the heading land and land was prepared by Barjut and bear the seal of Barjut. The said enclosure referred to several plot number of Mauja Ultatanga as well as Mauja Golaghat, out of which must be for Mauja Golaghat an actual calculation having aggregating total area of 5.2129 acres of land, which was alleged to be detained under the alleged order, section 6.3, whereas the order referred to the area of 8.1782 area in Golaghat. Area of land mentioned in the enclosure does not synchronize with the area of land mentioned in the alleged photocopy of the order as well as here. Then given the particulars. And
so the total measurement of land given in the 6.3 order does not tally with this.
Yes. Now, see, it refers to RS Quotation 72, which have been held to be non-existent. This is, they are given. Now, Lordship will be amazed to know how the tribunal has dealt with it. Oh, it's a calculation, human error. Ignore it. That is the answer of the tribunal. See the order? Page, order, now see the order. Volume 1. Now come to the one.
Should we come to the impugned order now, the tribunal's order?
See the tribunal's order now. I'm coming to the relevant part where dealt with it. The tribunal order is long, recording the submissions. It starts at, for convenience, a tribunal order is at page
64,
104.
64, P1.
But decision starts at page 136. And that's for my convenience. I'm giving the age for that today. Starts at 104, discussion at page 132, decision. And I am now drawing my attention to page 138.
7 last paragraph.
137 last paragraph.
137 last paragraph. We ordered the new question.
Yes. Well, can you see that? Right, you are right. 137 last paragraph. That is the decision of the appeal. The Bar Duty and Export Limited, applicant number such and such, has claimed that the state government, by an order dated 7th of April 1964, allowed Lansdowne to retain 52.528 acres of land under Mauda, Ultadaga and Golaghat for the operation of the mill. The photocopy of the said order dated 7th April of the Deputy Secretary, Government of West Bengal Land and Department, has been appended to ON, that is their appeal number. They have produced this order as Annexure C. And it is shown to your lordship, Annexure C. Annexure C discloses that the copy of the order number 6240, dated such and such, was forwarded to the Secretary, Board of Revenue, West Bengal Commission, Presidency Division, Collector, Medha Lansdowne Jute Company Limited. Original should be lying with them. Forwarded to Lansdowne Jute, is Director of Land and Land Record Survey. None of these parties, government departments, are called upon to produce what they received.
It's only written in that order itself that those are forwarded.
Forward, but therefore, the genuine copy will remain with
Actually
those
forwarded,
3 persons.
nothing is there.
With those 3 persons, including Lansdowne Jute. What is that order even? What is that order? Make the signature in original? No, can you see me? Neg. Forward, etc. With Lansdowne Jute. Was allowed to retain 5.726 acres of land for the purpose of running the mill. Now, this mill, it is apparent that order was well circulated. Circulation copy, why not produce them? With a line with them also. Annexure D is a photo. Then Annexure is an affidavit. See the last paragraph. Annexure D, I come. Arithmetical error in calculation of total quantum of land under Mauda Golagata, as pointed out by learned advocate appearing for Rotram Company, does not ipso facto lead to a conclusion. A subject lot of.
Now, Mr. Mittal, what is this Annexure E that is referred to the 3rd paragraph? State admits somewhere. State has admitted that Lansdowne
is a copy of affidavit in opposition filed on behalf of State of West Bengal in the matter of Rotram, etc. In the said in opposition, State has admitted that Lansdowne Jute Company was allowed to retain 5.78 acres of land comprised in Mauda Utadanga and jail number Golaghata, jail number 27. Similarly, State has admitted such fact in the affidavit filed on etc. in the matter of Bar Jute. Such fact has also been admitted by the State in OA number in the matter of such and such.
This is that affidavit which was shown to you, where the annexure is. That document page 29. This is the state, that is state's affidavit annexure. In OA 121 of 2000. That was the earlier of the wiki. There is handover of
got the certified copy.
This certificate copy take
Your lordship gave it back.
Oh,
Give it back.
yes, you can hand over. Have you got 2 copies now?
This is one certified.
Certificate copy you will require. Anyway, give 1 copy for the time. Oh, this is the affidavit in the way itself. This way.
No, my lord.
Different way.
Earlier round of litigation.
Earlier
The
round.
order which was passed in 1 day.
Now, even now the state is saying that they're supporting. So that's the state's version.
So, mismatching of total area become human error. Ignored it.
The stated affidavit. Techno state বলছে যে
After annexure Milord, can you see the last paragraph, page 138?
You can hand over this. Stated affidavit আর যদি কিছু প্রশ্ন
Last paragraph, can you see Milord, page 138?
Yes, 138, yes.
Arithmetical
Arithmetical.
error in
Right.
calculation of the total quantum of land under Mouda Gulagata as pointed out in the
This is the total quantum not tallying with
Yeah, admit.
that arithmetical error. That is it.
Admit it. But it's the same human error. Which human being? That's the point.
Yes, that is the point.
But there are other grounds. The mill premises of the were number 200 Disciplinary road is well butted and bounded by boundary wall. That is separated from plot number 104, that is also recorded, by one jheel, one public road, and which at a distance, not in the same place. Not the point he admits that a 60 order can be passed provided a mill is functioning on that plot of land. And there is evidence is to the contrary, the mill never existed on this plot 104, which is situated beyond the boundary of the mill premises and at a distance separated by bill and toll. These are the points noted. Official liquidator who took over Bharat said, no, this is not plot number 104.
But we cannot, if there is really a section 6.3 order, which has some legal force, we cannot go behind that at this stage probably. That cannot be reopened. If there is.
If there is
If
an
there
order.
If
That
you are
is-
challenging the if, so many challenges to the if even.
That is,
If that would be existent, actually it was there, and it was in form, proper form, and the boundary exact extent was there, then probably we could not have reopened, gone behind that at this stage.
otherwise,
But you are circumstantially pointing towards there being no such order because the elements of such order are not there in the sense that there was no mill functioning there. So
No,
this
that
is
is
also to cast a
circumstance
doubt on the
and-
existence of such an order.
And secondly, since there is no mill on the plot, there 60 order could not have
Section
been passed,
60 criteria were not met.
could not be passed in respect of plot number 104. Maybe other plots, other areas, mill within the mill premises have been allowed to be retained. It's quite natural that the Lansdowne Jew to be allowed to retain land within the mill premises, but is outside the mill premises. They are utilizing an order passed by the maybe somebody and say this is by this order with our plot number 104 is included. This is a question to be considered by Lordship. Government has supported, nakedly supported this party. What happened in this very court? The delay was condoned. We applied for under reach. Don't allow the condone.
What about jurisdiction, Mr. Mitra? You say jurisdiction was also one of the
Jurisdiction, not if the order is firstly, I'm underlying the point right now. If it was not maintainable, appeal was filed, then question would be, is the order of BLRO is to be sustained by the tribunal? And order of BLRO is based only on 6.3.
And if the appeal is not maintainable in law, the tribunal does not derive jurisdiction.
Hello?
tribunal does not derive jurisdiction if there is, because appeal is a creature of statute. If it's not there, if it is not clothed with the power, it cannot even look into or either affirm or set aside.
Very well. If that is set aside, then what happens? BL order
No,
demands.
appeal cannot do anything. The appeal has to be dismissed then.
But
your appeal had to be dismissed. The tribe.
Okay.
Oh, there was their way. No, right. Sorry, right. Get your point. We are wrong.
Huh?
So even if the understood, Mr.
No, it's not our appeal.
Understood. If the settlement officer did not have jurisdiction,
Huh.
even then the tribunal had to look into the veracity of the BLRO.
Yes, tribunal has to say BL
Absolutely.
order is
Right.
correct.
Very good.
They are
Very correct.
restoring order
Very
of BLRO. And then, now, Mr. White is not maintained. Also, lots of want to be satisfied. See the order. See the section 47, and under which provision the order was passed. I've got a copy of that. Where is my Estate Acquisition Act?
Let's
Yes, read it.
West Bengal Estate Acquisition.
Okay.
দীপঙ্কর দিকে তাকাও এই কালার এটা No, we had anticipated this because before when we got land jurisdiction we had called for certain books.
Oh, I see.
So yes, so we have the book for the time being. Yes.
Similar section 47. The record of rights
Yes.
prepared and finally
So
published.
this is under section
47.
47.
Record of rights prepared and finally published under the provisions of this chapter or deemed to have been so prepared and finally published for any district or part of district in respect of which notice under section 4 has been duly published shall, as soon as may be, after date of vesting, be modified by eliminating therefrom all the interest of the intermediaries which have been vested in the state and showing therein only the tenants who hold directly under the state as a result of vesting of such interest in the state. So, as soon as may be, in our name, record of rights were recorded with effect from 1954, 1st of August, in the name of Kashi Prasad. That is which was being nullified by this order of it. This is the one thing. And there, Milord, my name is recorded as a Rajat, not an intermediary. And what is the purpose of section 44? As soon as maybe after due date, eliminating therefrom all interest for intermediaries. It is a Rajat, I show you that thing. Intermediaries, which are vested in the state and showing therein only the tenants who hold directly under the state. One or more number to be borne on the revenue roll of the district shall be assigned by the collector in respect of areas which record of rights relates, in accordance with such rules, and state government may make it on this behalf, etc. Provide entries in record of rights, elimination of foregoing paragraph shall be deemed to be in force for the purpose of this preparation of the compensation assessment rule, etc. This order was just the other way around. Because that Khatian they produced, that their name was recorded as Rayat, Lansdowne name. That stood in the way of 60 order. 60 order can be passed only against intermediaries. But record of rights which they produced, it was Rayat, not. So that record of Rayat was changed into intermediary. Is other way around, not covered by 47. If a Rayat is there, recorded, then they are not intermediate and the 60 order can be passed. And this section 47 as
so Rayat can retain the land.
Land?
It's a Rayat who retains the land. Intermediaries are anybody above the Rayat up to the top. All in between are intermediaries.
Madhya
Madhya you know very well.
6.3, can you see only evolve applicable to intermediate? Can you see section 6.3? Only intermediate right can be allowed with him. 6.3 confined, not riot. Please come to section 6.3.
Right.
In case of land comprised in tea gardens, mill, factory, workshop.
Because it is the intermediary's rights which vest in the first place.
Yes.
So is the intermediary whose rights vest, he can cull out that part.
Allowed by the government to retain.
So they were recorded, their names were recorded as riots.
Riot. I'll show that. We are recorded as riot.
You are riots.
I am recorded as riot.
They were recorded as intermediaries.
CS,
they were recorded as intermediaries.
With the producer, yes, intermediary.
They were recorded as intermediaries.
Then others record, they are not shown as such.
So if they were shown as intermediaries, then 6.3 was applicable to them.
That was not found on the record. That was again, the parcha held to be not genuine. That was held to be not genuine. That was not held to be genuine. Ours was held to be genuine, but erroneous because of 6.3 orders. That is, they are not genuine. The conditions.
Suppose a particular portion of land is retained by them under 6.3.
Yes.
Then you don't become directly under the tenant directly under the state in respect of that.
Retained.
Because intermediary still holds the right.
I become tenant under the land.
Under him.
Condition precedent are?
Or rather you remain a tenant under him.
Under government.
No.
Right.
Regarding the land which the intermediary is permitted to retain, intermediary remains the owner of that.
And
they say that they retain that jute mill under section 6.3. If that be so, you don't become a tenant directly under the state regarding that land. If there was a proper 6.3.
Intermediate becomes allowed to retain.
Yes.
Abandoned right. As the intermediary allowed to retain.
You remain the right maybe, but they remain the intermediary. They retain the
now, Kashipura Singh name was recorded as Rayat. Rayat is heritable.
So your right is in no event. I mean, maximum you cannot become a direct tenant under the state, even if it is retained by them.
Right.
But you hit at the 6.3 itself.
6.3. The Rayat is a heritable, like ownership.
Rayat is down the line, at the base.
See the conditions imposed by section 6.3. Land must be firstly comprised in mill or factory. Land is never described as karkhana in any of these other records. Karkhana is also another category of land. It is described as danga. Danga, not karkhana. Now, next thing also can you see? Or held or based under a lease, that they say, I'm forgetting that, retained so much of land in the opinion of state is required for the tea garden. As case may be, a person holding a lease shall accept. Required for tea garden. Sorry, required for the mill in this case.
6.1G is mills, factories, etc.
Yes.
But 6.1C is also their non-agricultural land held in his khas possession. But there cannot be khas possession because you are a Rayat.
I am a Rayat.
It has to come under G.
And my parcha is genuine, but according to erroneous, when it found to be erroneous in 2014 or 16. How many years after vesting? 45 years. 45 after 45 years, which is being corrected. So when you go into greater detail, I shall hope to go there. And but this is totally totally.
What sort of interim order you are seeking here?
Interim order, but I was asking about there's already interim order.
What is that interim?
Us from because on this land with a sanctioned building plan. We
You are
have
in possession, so
possession and constructed building. But the court has injuncted.
this
two
court in
courts,
this writ petition.
our High Court and also the title suit.
No, in this writ petition is being taken up for the first time. This
Yes.
For the first time.
previous
In a different proceedings,
Yeah.
challenging the order of injunction,
Yeah.
first appeal, in the first
So
appeal.
here, Mr. Mitra, there is no probably no scope of an interim order here.
Stay.
Stay of this.
This order should not be given further effect to. Any further effect.
What is the ordering portion? I mean, does it put in anything mandatory?
If that will not prejudice them. And direction upon BLRO. Order is page 142. Order, document. Order dated passed by district settlement officer, it appeal, and the land development officer, and general.
If this order is stayed, Mr. Mitra, then the effect will be that your rights in the property which were declared by the settlement officer revive. So you'll be able to deal with the property. So we'll pass an independent order staying the operation of this, as well as restraining you from just maintain status.
Which is passed, repeat it.
We'll repeat that.
Repeat
We'll
that.
just grant status quo regarding possession and nature character of this.
Order passed, I shall also find that in the paper book itself. Please come to me, Lord, page 207, 208. And the division bench order of page 494. Similar order.
294.
494, division order. And the two orders of High Court. Two orders are there. 207, volume 1, volume 2, no? Volume 2, and this 494, volume. See the order, same order can be introduced. If suppose this read. I cannot transfer or alienate property in any manner. 207 is order of our High Court. In application directed, sir, respondent restrain my order of injunction from transferring, alienating, encumbering the property in suit. The title suit. Injunction in the High Court. Then, Milord, this order is continuing even now. And then another division bench order as at page 494.
Yes, we'll restrain both parties from altering the status quo as regards possession, third party interest, as well as encumbrance and all.
Not to create third party interest. Bullen to.
Naturally.
You want fourth party?
No.
Hard learned.
Milord, but
Yes. We'll grant an arguable case has been, we'll direct affidavits, you'll put in all your papers there.
It's a 6 volume paper book. If anything left out in the
Yes, they'll include in their
opposition.
opposition.
I'm only on this point, Lordship, since the judgment under challenge was passed in the month of May, and there was a specific direction, if your Lordship comes to page 145. Of
What was
volume
that specific text?
Let a plain copy of this order, duly countersigned by the principal officer of the tribunal, be sent to the BLLRO for information and compliance. So in compliance thereof, my lord, we have already, my lord, corrected the record of rights. This is the updated, my lord, record of rights. May I place it on 3rd July, you have complied with. And this petition comes to your lordship on August. I think 7th August, the jurat portion. So, my lord, kindly takes care of this, lordship. We have done in compliance with this.
And we are disputing that certified copy on 6th
I
August.
can send a copy to you, sir.
Record of rights remain the same.
The previous document which has been handed up to my lord, that was the RSROI. This one is
That is
LRROI. So the changes, whatever been made in the LRROI, not in the RSROI. So, my lord, that
Yes,
is
Mr. Mitra, the change has to be in the LRRO now. Because
LRRO.
LRRO has come in between.
This one
has been commenced. This exercise of this LRRO, this has started before the passing of the order by the tribunal. So it has to be reflected in the LR now.
Others Then LR has not
Yes.
started.
In the RS, you are showing that RS remains the same.
In the RS record, name of this Lansdowne dude never appeared.
No.
It is with the bullet eye.
No.
It was CS caliber.
Let us come to the finding of the
Any
time.
after whatever status
And
or record of
this
rights,
is the finding, Lordship.
that-
Page, my lord.
no further effect to be given. That's all. But
Page, my lord, kindly sees page 143 only. The order dated 4th February 2019 passed by the Assistant Settlement Officer and BLLRO in case number 20 of so and so, renumbered and so, a proceeding in compliance with the solemn order of the Honorable High Court passed on so and so is hereby affirmed. So what is this 4th February 2019? Lordship will get at page 242, volume 2.
Yes, that's a place we would love.
Affirmed. Now the miscellaneous application so and so on behalf of Rototron after completion of final hearing is rejected in view of the observation made in the body of the judgment para so and so. So Miller, this was set aside 242. So now it has to revert back Miller, to the order Miller passed by the BLLRO.
My lord will see page 254, the BLLR
We are
order.
there. We are there.
254D. The last 3-4 lines. I keep this view that RS ROR number 41 should stand after due modification. That is not there. That has not happened. So LR can't happen without this.
But I have the answer towards that.
What is that answer? RS server was directed to be corrected.
My lord.
Yes.
My lord, there were two RSRORs. One is in favor of my client's name, another one is in favor of their client's name. And my RSROR has been backed up by original deed of
favor. Whatever that's on the merit, definitely we'll hear you. But this order of the BLLRO.
So page 255 says specifically, my lord, it should come back to whose name? Kindly see 255, volume 2.
The name of Kashi Prasad will be prepared.
In the name of Lansdowne. You bring it back to this. This is what
This has not been done.
No,
RS records have not been done.
now we have done it after the
You have reflected it in the LR records. But the RS records modification has not been done.
No.
Do you get it? Because the route was sought to be hit by the BLLRO. The direction was that you will rectify the RS records to justify the LR records. Because there is a forward presumption also of RS records. So RS records have, this order does not say that reflect this in the current records. The order of the BLLRO was passed at a point of time when the LR records had, the preparation of LR records had commenced.
Yes, so Miller, the RS stands corrected now.
But you are not, RS has not been touched by you. RS records remain the same. They have taken certified copies. You have reflected that change in the LR records.
Yes, updated version. Updated version.
When the BLLRO order was passed, Mr. Galib, LR exercise had started. LR records were already being prepared. When the BLLRO order was passed, but the BLLRO consciously did not direct you to reflect this change in the LR records. LR records you have done. But the direction was the RS records going backwards. You have to modify the RS records.
But when RS Milord as on date, Milord.
LR has been changed.
RS records are there. The records
July
are there.
2025. In the month of July 2025.
But LR records change cannot be given effect to because we are staying the operation of this. Cannot render this infructuous. Arguable questions have been raised. And RS records
Abide by the result since we have acted in compliance with the tribunal's order under challenge before your lordships.
No, but they cannot act on the basis of this. Shall not be given effect to. In any event, we are restraining both parties from creating third-party interests or acting on them.
Not to raise any further construction, Malad. They have put up a advertisement by 99 acres.
But interest will create, I agree.
They are inviting purchasers.
No.
In the website.
1 minute. Yes, Mr. Mitra. What?
Construction injunction. They asked twice. Both refused. I tell you what.
What is the stage of the construction? What is the stage of the construction?
One building is construction. Photograph, we have annexed a photograph. But
no, we'll restrain you from creating third-party interests.
No,
construction, if there is third-party interest, will cover agreements for sale also.
And if I
In a government land, another government retaining
construction has already been made.
Construction
How
made.
many stories have come up?
I will not object to that. No further construction.
They have invested too much in that. The construction, they can complete the construction
Very
because it's already. How many stories have come up?
11 stories. Photograph
How
annex.
many stories have come up actually?
11.
Oh, then what remains? Then what remains? Kindly injunct them not to.
Not to do what? 15 stories they've constructed.
Because they
Not
have
to construct the 16th story.
Kindly have a look to the advertisement. Kindly.
They will not. We are restraining them from creating an income.
Dismiss.
Arguable questions have been raised in a heard learned senior counsel for the petitioner as well as the learned counsel appearing respectively for the private respondents and the state. Full stop. Upon such hearing and on a primary perusal of the materials on record annexed to the writ petition, we are of the opinion that sufficient that several questions of law and fact have been raised for hearing the appeal on merits. Full stop. The petitioners challenge the very root of the order of the learned tribunal, inasmuch as the learned tribunal observed that the settlement officer, whose order was challenged before the tribunal, did not have jurisdiction to assume appellate authority. Full stop. Next para. However, it is contended that even if the tribunal proceeded on such premise, it ought to have looked into the first order of the BL and LRO, which was, in turn, challenged before the settlement officer, on merits. Full stop. Next para. Secondly, it has been contended that there was no scope of any order being passed under section 6 within bracket 3 of the West Bengal Estates Acquisition Act, 1953, Estates Acquisition Act 1953, inasmuch as the purported copy of such order sought to be produced by the private respondents and relied on by the state does not specify the exact description of the property to correlate it to the present disputed property. Full stop. Moreover, it is submitted that the original of the said order was never produced, although the state, it is alleged, is complicit with the stand of the private respondents in supporting that there was such an order. Full stop. It is further pointed out that on a query made under the Right to Information Act, the petitioners learned that there was no record subsisting with the concerned department of the state relating to any such order under section 6 within bracket 3 of the 1953 Act. Full stop. Furthermore, certain sheets, apparently relating to quanta of land pertaining to several plots, were produced by the private respondents themselves and not a part of the records, which is apparent from the rubber stamp of the private respondents on the said documents. Also, the purported order under section 6 within bracket 3 does not refer to any such documents, apart from the fact that the total quantum of land reflected in such documents does not tally with the total area of land mentioned in the purported section 6 within bracket 3 order. Next para. Learned senior counsel for the petitioner also argues that the name of the predecessor and interest of the present petitioners still remains in the concerned records of rights from August 1, 1954. It is submitted that on obtaining a certified copy of the arrest records, it has been found out that no change in terms of the order of the BLLRO has been effected as yet by striking out the name of the predecessor of the petitioners. For the next para, the state contends that pursuant to the impugned order of the tribunal, the names of the private respondents have already been reflected in the LR records of rights.
Only one, Miller. I have handed over the wrong copy, Miller. Even RS also I find they have. This is the bunch, Lord.
First up, next para, it is submitted further by the state that even the arrest records have been corrected pursuant to the order of the tribunal, which is disputed by the petitioners, since the petitioners are in custody of a certified copy, which indicates that no such change has as yet been effected. Full stop. Since there is a disputed question as to whether the tribunal's order has been implemented as yet, comma, we, comma, at this stage, comma, do not go into such question. Full stop. Next para. As observed above, comma, in view of the arguable questions raised, comma, the writ petition is required to be heard on merits. Full stop. The respondent shall file the respective affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week, within 2 weeks thereafter, within a fortnight thereafter. The matter shall be listed for hearing on September 22, 2025. Full stop. Next para. There shall be, now the parties shall remain restrained from creating any third-party interest and or transferring, alienating and or encumbering the disputed property in respect of third parties in any manner till disposal of the writ petitions. Full stop. Next para, the respondent shall not give any effect, the parties shall not give any effect to the corrections, comma, if so affected pursuant to the orders of the tribunal during pendency of the present writ petition. Full stop. Next para. Third party interest, change of nature, character, anything in there. We have not granted change of nature, character.
And my lord, one more thing, my lord, advertisement. They should stop.
No, not create any third party interest, no encumbrance.
What happens, my lord, if advertisement is done and they
It is further clarified that the above order of status quo in respect of creating third-party interest shall also operate to restrain the parties from issuing any advertisements and or give out to the public in general the intention of the parties to create such third-party interests till disposal of the writ petition. First of the petitioner shall prepare and file the requisite number of records are required. The records shall be called for by special messenger. Yes. At the cost of the petitioner to be deposited within a week from date. The in view of the appearance of all parties, comma, service of notice of the writ petition on the respondents is dispensed with, and the writ petition is deemed to be ready as regards service. First of next para, the petitioner shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of arrival of the records. First of liberty to the parties to mention. Liberty you are not giving because you already directed.
My lord, liberty may be given to us, my lord, if there are, my lord, lack of papers in the paper book, then we can bring those papers.
We have directed affidavits. We have directed affidavits, Mr. Thor.
Intimate
You,
any paper
whatever papers you want to incorporate, you put it in the affidavit in opposition. Opposition and reply will be a part of the paper book. That is the only thing which is required. That's why informal paper books without comparing with the records. We informal paper books without comparing with the records before the returnable date. Records is wait for the need not wait for the records. Whatever papers you have annexed to your opposition. You take back these things, Mr. Gali, because
Lordship.
These may be necessary in your
Lordship.
And এটাও ওনাদের ফেরত দিই এটা ওনাদের এটা ওদিকে RS record
সবই তো চলে যাবে অপোজিশনে যাবে
in the opposition will be
অরিজিনাল দেখো চোখে দেখুন দেখো অরিজিনাল দেখি
দিয়ে দেবো স্যার দেখাবো সামনে
দেখিয়ে ফেরত দাও দেখিয়ে ফেরত
you are escaping without showing him Mr. Mitra whatever is there is
এইটা
you authorize Mr. Mukherjee to use your physical strength pitted against Mr. Dhar এটা ভেতর ঢোক চল পট we saw 2016 but we did not go into that question
2016
we saw that Mr. Galib suddenly founded and we did not want to water to his enthusiasm.
Calcutta is not creating any title but fighting about correction.
থার্টি ফোরই তো হলো আবার কি 30 এটা 34 হলো না ও আচ্ছা You are appearing, Mr. Banerjee? Yes.
Now, the main matter is pending hearing. Paper books, etc., have come up. 14T3 order, which was made, vesting certain lands.
Application, pending application.
The application is not, there was an order of status quo, an interim order of status quo passed on contest. Subsequently, the writ petition was dismissed for default. In that order, in the dismissal order, my lord, I'm instructed that there is no prayer, there is no order vacating the interim orders, if any, passed. Thereafter, it was restored. Restoration itself would have meant automatic restoration of the interim order. And then the matter was finally heard.
Applications for stay was still pending.
The application was in connection with the composite writ petition.
No, that application was pending when is still pending. What is pending? Why is it appearing under the heading application?
Yes, because a new
What is
can
scan for?
a new can had to be taken out for this purpose. After the status quo got revived, then the state authorities have, during the pendency of final hearing of these proceedings, altered the status, and by barging into a portion of my property, putting in signs and signages saying that portion belongs to the state, which has been sent to a municipality. There was
a status quo order or a stay?
A status quo order, status quo as regards possession.
So this is for violation of that, implementation.
This is for implementation of subsequent steps to ensure that this becomes effective.
Have you given a copy to the state?
Yes, we've served.
Give a notice and we'll take it up tomorrow. Give a notice to the state advocate tomorrow, day after tomorrow. Can you give a notice today?
Yes, we'll do that.
Since none appears for the state to oppose the application, comma, the learned advocate in record for the petitioners shall give a notice regarding the pendency of the matter and intimating that the matter will be listed tomorrow under the same heading. Full stop. Receipt in that regard shall be filed tomorrow when the matter is taken up for hearing. If they don't appear, we'll pass orders express. What can be done? But please serve as early as possible so that
we'll by
they have
3:30 as it
some
is.
opportunity.
So-
3:30 you cannot. You cannot even have the letter printed.
We'll hand it or something. We'll just
No, don't do it.
No, print
Give them some time.
print করে দাও।
Yes, Mr. Ghosh.
35 I am for the full respondent here.
Respond means, it's
Only
private.
one-
Oh, state is the appellant.
State is the appellant.
You appear for the state also.
He is the affidavit from opposition, my lord.
Opposition আছে. There's a previous direction.
Yes, direction is there. I am praying for the extension of time to file reply.
Very well.
And they kindly extend the interim order that was expired in 31st
June.
July.
He
No,
is
July.
expiring on June.
What was the nature of the interim order?
Nature of the
Not to give a further effect to the order passed by the
order stay of the order passed by
What was the order? Impugned order? What is the
impugned orders that by the order of the learned single judge directed the state authority to execute a gift deed as per their proposal. We have said due to
that gift deed has not yet been executed?
No.
So we'll extend this day. Reimpose this day. Impose some costs on you. You're the state. We'll have to pay. Why didn't you apply for extension within time?
Now, we have already taken steps for extension of interim order lordship. The listing of the matter. That is.
Did you mention the matter for extension within time?
That steps taken previous bench.
No step was taken. If step was taken, the court would have placed it in the list for extension. Affidavit in opposition filed today be kept on record. Full stop. Learned counsel for the state stroke appellants seeks extension of time to file the reply. Full stop. The time for filing reply is extended for a fortnight from date. Full stop. On the prayer of the state, comma, the interim order granted earlier, comma, which has expired in the meantime, comma, is reimposed and extended till September 30, 2025 or until September 26, 2025 or until further order, whichever is earlier. The matter shall next be listed on August 27, 2025.
Yes.
This is that review. Mr. Murthy, you are appearing for the review applicant?
I am appearing for the applicant, respondents. Lordship,
What is the error apparent on the face of record?
My lord, your lordship will kindly
আপনি দেখুন আপনার order.
that
না না কিছু নেই কিছু নেই 90% কিছু
what is 41? Oh, my lord, I tell you, lordship, my lord, a disciplinary proceeding was initiated, and my lord, against that, they have come before your lordship. Prior to this, a show cause notice was issued. And my lord, then also, against refusal of interim order, they came to this court. And my lord, what about is the 249. 49. Oh, sorry. At page 240. No, that's bull.
Are you referring to the impugned order, the order under review?
Yes.
You can refer to the internal pages because we are following from the memo itself. Or whatever you like. I mean, you just refer to the internal pages of the order.
আগের অর্ডারটা তো বলছে আগের অর্ডারটা বলে এই যে আগের অর্ডারটা কোথায়? My lord will give me 1 minute, my lord. One. এই যে এটা তো Yes. My lord, kindly look at page page 84. The earlier appeal, when my lord so-called notice was issued and moved this court, my lord kindly peruse my lord page 89, internal page 6.
Page 89.
89. But the order starts from page 84.
84, yes.
I am drawing your lordship's attention, my lord, at page 89.
Yes, Mr. Mitra.
Paragraph 19. The argument that the respondents had formed a preconceived notion as to the guilt of the appellant is not justified in our view. In paragraph number 5 of the memorandum of charges dated November 28, 2024, although a reference has been made to the provisions of major penalties of conduct, discipline, and appeal rules 2022 of the respondent number 1 institute, the same has to be read in proper perspective. It is stated in the said paragraph that if the appellant does not appear in person before the inquiry authority or otherwise fails or refuses to comply with the provisions of the said rules or the orders direction issued in persons of the same, the inquiring authority may hold the inquiry against him ex parte. Now, my lord, ultimately, your lordships were pleased to hold, and also this is, my lord, part of HR manual. Now, my lord, kindly, my lord, look at page, next page, page 90, concluding part, my lord, paragraph 23. Thus, in our opinion, it would be premature to admit the appeal or interfere with the learned trial judge's order, refusing ad interim order at this stage. However, we make it amply clear that we have not entered into the merits of the matter at all. And it will be, sorry.
Sorry, Mr. Mitra. Please continue.
And it will,
yes, you can continue from where you end.
It will be open to the learned trial judge while deciding any of the 3 pending suits or the connected interlocutory application at further stages to decide all questions independently and in accordance with law without being influenced in any manner unduly by any of our observation made above. So, my lord, so-called notice was issued pursuant to, my lord, HR manual. Now, my lord, they have come forward with another suit, my lord, where, my lord, declaration is there, my lord, I am giving, but that is at page 92, plaint. And in my humble submission, my lord, HR manual was never challenged. In other 3 suits, this is the 4th suit. And I will place my lord appointment later on. My lord, kindly page 92 of the plane. 92. 92 starts.
Mr. Metro.
Yes, my lord, 92.
Mr. Metro, actually, interim order was before us, and we had only considered the interim order.
My lord.
Didn't went into the merit of the
my lord.
Whether HR manual is correct or not correct, this aspect has not been considered.
My lord, may I?
That's why that a trial court was directed to consider on all aspects during the trial. This is the.
My lord, kindly, my lord, I am drawing your lordship's attention. We, my lord, paragraph 35 of your lordship, and that is your lordship's judgment is annexed to the review petition. Review. Memorandum of review. The lordship will find easily.
Yes. Internal page?
Well, internal page 20. 20. Paragraph 34.
Yes, Mr. Mitra.
35. We also observe clear indications of violation of natural justice and a reasonable apprehension of bias in the disciplinary proceedings. This includes our prima facie finding of bias against the initial inquiry officer, the appointment of his successor, and the withholding of critical documents. The actions of respondent number 3, DG also indicate a predetermined outcome and unfair targeting, demonstrably denying the appellant a fair hearing and access to essential documents. The right to a fair hearing, including access to relevant documents, has been demonstrably denied. And this was your lordship's finding. Well, my humble submission. Yeah. Lordship will give me 1 minute. And my lord, he was, firstly, my lord, he was not governed by SAIL rules from the very beginning. Which, my lord, 25.
SAIL rules were adopted by you initially.
My lord?
SAIL regulations were adopted by you initially.
My lord, for a particular
period.
Thereafter, my lord, we have prepared our own rules.
Manual. Yeah. No, your rules also adopted the SAIL regulations, probably.
No. मतलब stay application এইখানটা দাও নি তুমি এইখানটা দাও মানে para 17 we have stated clearly in stay application. May I read it, my lord?
Yes.
Page 10. I am reading from the beginning. The appellant applicant's petitioners state that the Institute Society was formed in the year 1996, and since 1996, Institute has time and again adopted different rules for service condition of its employee, as well as an order and as well as on other issues. In the year 2000, the society has agreed to follow its own rule for service conditions, and such was also approved by the Executive Council, who are the governing body of the Institute. Thereafter, in 2001, the society resolved and approved by the Executive Council that the society will follow rules of Joint Planned Committee for its personal and administrative matters. Thereafter, in 2008 and 2009, it was decided by the society that the same rules will be followed for administrative matters of the society. Thereafter, in 2022, the new rule HR manual came into force, when disciplinary proceeding actually started. A copy of the new rule has been, and that's why I don't place it. Now, your lordship, kindly look at his
These are
appointment
new
letter.
arguments you are making on merits, Mr. Moitra.
Well,
These are not error apparent on the face of the court.
Madam, why I am submitting this?
Yes.
Well, it has been held
You,
in this,
because you were represented when the matter was heard. And these points were not taken for the first time. You are taking these points, and even if these are correct,
my lord,
it's an error of law. It would be an error of law which is amenable to appeal. But in review, how can you say this is an error apparent on the face of the
well,
court?
I am, because of this reason I am submitting, my lord,
Yes.
that
Even if it's an
these-
error, I mean, these matters were not, is not reflected in our arguments.
No, my
And
lord,
these that you were governed by different rules from,
no,
this is
this
a new.
was not because I tell your lordship, because no affidavit was filed.
No, but arguments were extended at length.
That is, but
So, because it was not that we closed you from.
no, no, no,
well, if it
no,
is-
no, no, this-
Arguments were extended, and we also looked into
Yeah,
documents,
this
various
is all-
documents
all
produced
have
by
been
both
recorded,
parties.
all have been recorded. No, my
Mr.
lord,
Muthu, all documents were produced by both parties. We looked into those documents. We never shut out any party from showing any documents.
only, my lord, I am praying, my lord, humbly praying.
Now, these things are new things which are new arguments in
My lord,
a review, Mr. Muthu.
no, my lord, my lord, only, my lord, I am praying to your lordship, my lord, the appointment letter, if your lordship can have a look.
Very well. Yes.
Page 249 of the
Application, yes.
250. And a relevant paragraph at page 250, 1.7.
Yes.
You,
This is his appointment letter.
yes,
Right.
yes, yes. With it. You shall be subject to the service rules and regulations, including the conduct rules, as well as administrative orders of the institute in force from time to time, and shall obey all such orders and directions as you may receive from your ends. Next page. Hmm. যদি এরপর ছেড়ে দিতে ছেড়ে দাও।
Mr. Moitra, in our order,
My lord.
observations were apparently, if you remember it correctly, that this HR manual, this whether it's binding or not, whether it received executive council's approval, these were questions which were not
My lord,
dealt
my
with by the learned trial.
Your lordship recorded also, it was noted.
Noted, but we did not close the chapter. Obviously, that's why it was directed to be considered by the trial court at the time of subsequent times.
And also, my lord, there is one of that one of bias.
The evidence and all that.
All the point of bias.
These findings, bias
Lost.
findings and not all are prima facie findings. If you want, we can, in this review application, we can say, what will be passing that these are questions which are raised by you, but these questions are arguments on law and on certain components of fact. That's why we will not entertain the review, while clarifying that your apprehension that our observations regarding bias and on certain other aspects, all are tentative for the purpose of that stage only, and will have no effect whatsoever at the final hearing of the suit. We'll do that.
My lord, my
Subject to what Mr. Ali says.
That is the law, my lord.
So we
Cannot
but
be binding.
yes, you may have a point there, Mr. Muthu. Those bias and those
My lord.
may play in the mind of the learned trial.
But only one thing, my lord. Lordship has
Talbot
given
may
an
be biased
opportunity.
on those. Yes.
Lordship has given an opportunity to them to use an affidavit, but they have not used it.
Huh?
It was not recorded in an
So
order.
that, Mr. Muthu quickly deviated from that. So very well.
And my lord, we have cleared all his dues.
His dues.
We have not been allowed to join, my lord.
All
Even after
which are
this order.
total dues, I am
They have not disputed that you have given the dues. They are not even disputing now.
My lord.
The present review application has been filed on the ground of certain purported errors apparent on the face of the order dated July 10, 2025, passed by this court in FMAT 59 of 2025, heard along with Can 1 of 2025 and Can 2 of 2025. Full stop, next para. Learned senior counsel appearing for the review applicants argues that in the letter of appointment, Mr. Moita, please take your seat. We'll just pass out. Please take your seat. In the letter of appointment of the respondent, comma, that is the writ petitioner, comma, it was categorically stated, sorry, not the writ petitioner, the respondents. No, you are the writ petitioners.
They are petition appellant before this appellant before your lordship. Not before your lordship.
Oh, right.
Appellant.
In the letter of appointment of the appellants, Sri Oshim Kumar Shamanto, comma, it was categorically mentioned in clause 1.7 that the appellant shall be subject to the service rules and regulations, comma, including the conduct rules as well as the administrative orders of the institute in force from time to time, and shall obey all such orders and directions as he may receive from his superiors. Next para, learned senior counsel seeks to take the court through the averments made in the review application, comma, particularly in paragraph 17 thereof, where a narrative of the developments with regard to the rules of service followed by the review applicant has been given. Full stop. It is argued that although the institute stroke society stroke review applicant was formed in the year 1996, comma, since when it has time and again adopted different rules. First up, in the year 2000, comma, the society had agreed to follow its own rule for service conditions, and such was also approved by the Executive Council, EC Capital, comma, who are the governing body of the institute, GBI Capital. Thereafter, in 2001, the society resolved and approved by the Executive Council that it would follow the rules of JPC Capital, Joint Plant Committee within bracket JPC, for its personnel, NNEL, and administrative matters. Thereafter, in 2008 and 2009, comma, it was decided by the society that the SAIL caps rules shall be followed for administrative matters of the society. And in 2022, the new rule R capital bracket HR manual came into force. Next para, learned senior counsel also places reliance on an earlier order of this court dated December 23, 2024, passed in FMAT 485 of 2024, along with IA number CAN 1 of 2024, where it had been observed, comma, inter alia, that in the memorandum of charges dated November 28, 2024, comma, although a reference had been made to the provisions of the CAPSE, major penalties of the conduct, comma, discipline and appeal rules, comma, 2022 of the respondent number 1-institute, comma, the same has to be read in proper perspective. Next para. That apart, comma, learned senior counsel for the review applicant expresses apprehension that the observations as to perceived bias of the review applicants might be held against the review applicants at subsequent stages of the suit and connected applications. Next para, learned counsel for the respondents opposes the arguments of the review applicant. However, comma, at the stage of admission of the review, comma, we find that no clear case of error apparent on the face of the records have been made out by the appellants, by the review applicants, comma, inasmuch as the order under review was passed upon hearing both sides and all due considerations to the matters at hand were given. The arguments now sought to be advanced are in respect of certain developments and rules which were within the knowledge of the review applicants at the time when the order under review was passed, but no specific arguments were made or at least reflected in the order under review. Next para, thus, comma, even if for argument's sake it was to be assumed that there was an error in the order under review, comma, the same would at best be a legal error which would be amenable to appellate jurisdiction and would not come within the limited scope of Order 47 of the Code of Civil Procedure, comma, not being an error which is apparent on the face of the order under review or the records. Next para, in any event, comma, the apprehension of the review applicants that the observations of this court in the order under review regarding the perceived bias or scope of bias of the review applicants would affect adversely the review applicant at subsequent stages of the suit is misplaced. Full stop. Needless to say, comma, the observations made in the order under review were strictly for the limited purpose of deciding the legality of the order impugned in the said appeal and do not traverse beyond the adjudication of the appeal. Full stop. Such observations, comma, such observations were tentative, comma, only for the purpose of deciding the appeal and the connected applications and shall not be binding on the learned trial judge and or be prejudicial to either of the parties to the suit at any subsequent stage of the suit or interlocutory applications, comma, if any, comma, pending before the learned trial judge. Full stop. With the above observations, comma, RVW 241 of 2025 is dismissed. Full stop. Consequentially, can 1 of 2025 is also dismissed without an order as to cost. In the light of the
My lord,
observations made above.
May I point out one thing, my lord? Because, my lord, we have terminated and we have paid all dues. Now, my lord,
We have said that those that will not that will be kept in abeyance.
no, that is my lord stayed. So, my lord, he will be allowed to join. So, my lord, what I am submitting, my lord, his emoluments will be kept in a suspense account till
And Samohito, for that take the leave of the learned trial judge or seek appropriate orders before the
my
trial.
lord, kindly, my lord, because other paragraph 40.
But we have not been allowed to join, my lord.
My lord, that's why they
Even
will
after
file
this order.
You have been allowed to join by
Not allowed to join.
they will file, my lord, contempt.
I thought that
But I
perhaps
have-
because of
I have
this
filed my
review,
review
but
application.
now nothing should.
In the event the appellant has been terminated in the meantime as a result of the disciplinary proceeding being decided against him, such order of termination shall remain stayed till disposal of the suit and shall also be subject to the. Yes,
My lord,
he has to
stay.
be allowed to join.
My lord, he has taken, my lord, all retirement benefit, my lord. But sorry, terminal benefit, everything.
These questions will be left before the trial court. If he wants to join, then you can resist on that.
My lord, may I submit, my lord? We will keep it in a suspense account. My lord,
I will be discharging
Will not
duties and
pass
he
any
keeps my.
further orders on this. Whatever order we have passed, it remains.
my lord.
There is no scope of clarification of this. I mean, we have stayed it.
At
If he has
least
taken emoluments
Lordship may
for return,
No, my lord,
only record that I may be allowed to join, my lord.
if you are allowed to join, you have already taken benefits of your family.
But they have credited in my account, my lord. It's not like.
So then we'll have to pass
I
a
have-
different set of directions, directing those to be adjusted till your current till it is set off with your current.
Let them direct, my lord. We should put it in. They should not.
After line add code,
They want me to work.
leave is granted to both sides to seek appropriate orders from the learned trial court in respect of the joining of the respondent in the review applicant in his service and comma if so comma whether such joining shall be subject to reversal of the benefits already given to the respondent in the review application by the review applicant, keeping in view the purported termination of the respondent. Full stop. If such applications are filed before the learned trial judge, comma, the learned trial judge shall decide the same in accordance with law. Whatever.
Original
কোনটাই? No, order.
Respondent in the review application.
Responded in the review application. ঠিকই আছে. My lord, grateful.
I'm grateful.
Daniel.
Meeting. Yes.
I'm for the state in this matter. For the
State.
petitioner respondent.
Who is for the petition?
I'm for the read petitioner respondent.
Well, as for the appellant, Miller, your lordship would kindly take this matter in the next week because, well, in the meantime, we have prepared an application, Miller, disclosing certain facts which inadvertently has been missed in the Millard appeal, Millard. Kindly, Millard, we take this matter on the next week.
What application is now pending?
No, we have prepared an application, Millard, which is
No, an application is appearing under the heading application for
stay.
stay is still pending. What application have you prepared?
It's disclosing certain facts, Millard. That was
What is the prayer in that application?
Millard, I need to seek instructions from my advocate and record, Millard. That. Let me ask you a question.
You're the senior, you're not the advocate on record.
Well, I'm sorry, Millard. I'm not sure yet. Okay? I'm sorry, Millard. It is my, I am the advocate on record in this matter, Millard. I need to check.
You seek instructions from yourself.
Well, I'm so sorry, Millard.
Introspection is required.
Millard, I need to take Millard instructions from my senior, Millard, who is leading me,
Stay
Millard.
senior. Why do you say from advocate on record?
No, Millard,
You're
I'm
not so senior.
Millard, I'm sorry, Millard. I'm you kindly take this matter next week, Millard.
Take instruction from your senior, we'll grant you an adjournment for that. Why next week? Tomorrow.
Millard, tomorrow.
On the prayer of the petitioner, let the matter stand adjourned for the day. Come back tomorrow. You prepare yourself in the meantime, take your senior's advice and prepare yourself.
Millard.
If he is unable, then you will have to move the matter.
Millard, I shall. 37.
The item number 38.
You also want instruction from your.
No, my lord. There's a issue in this matter, your lordship. What has happened?
Yes, otherwise, why should you come before us?
Well, my lord, I am responding in this matter.
What is your issue?
My lord, in REIT application, I was in advocate record. They have served me the appeal application. I tried to contact the, but he's not.
This is a real issue.
I beg to appear
Let
for
them
the,
serve to petitioner directly. I have no.
I beg to appear for the writ petitioner in the trial before the honorable single judge. I am the respondent number 1 and 2.
I don't know 39. I'm 38.
Item 38. This item 38. Oh, 30, 39 related.
It's related. In both of them, my lord, I am the respondent number 1 and 2.
You are the writ petitioner, the writ
In one of the matters there.
In the other, they were.
I am.
Yes.
You are appearing also.
My lord, I am appearing on behalf of the National Highways Authority, my lord.
Let them serve to the petitioner, petitioner directly. I don't know 38. I have no issues.
You are for which? What is the name of your client? Your
Faisal Hussain.
Ah, acha. They were the writ petitioner in another matter.
Yes. And I was.
You are for the authorities.
My lord, I am for the authorities.
And I was for the writ petitioner in
So
another.
first, serve directly on the writ petitioner respondent. Faisal Hussain.
No. I mean,
What are you appearing for?
For one of the writ petitioners, Nane Khan and Alam Khan.
Faisal Hussain then has to be served.
Yes, Faisal Hussain is one of the writ petitioners in another matter, not this matter.
Item
There are
38.
two writ petitioners. I tell your lordship.
We find the name of Faisal Hussain. In Can 1 FMA 939/2025, he is the first respondent.
And Nane Khan and Alam Khan are the writ petitioner in MAT 743.
What was the matter about? Faisal Khan is necessary, obviously.
Yes, he's very much necessary.
Serve a copy on.
I need not serve because
I am the appellant.
You serve.
Yes.
What happened to you? Why the sling?
I dislocated my shoulder.
Very good. The good that you are coming at least to court. So when should you keep it? How soon can you serve on
I
Faisal?
takes it next week, my lord.
No, he has to say. You will have to serve.
I will serve and come back, my lord. Yeah.
It transpires that although the respondent authorities are represented through counsel along with the appellants, the respondent number 1 in FMA 939 of 2025, namely Faisal Hussain, has not been served. Full stop. Accordingly, the appellant shall serve copies of the memoranda of appeal and the connected applications on Faisal Hussain directly and file an affidavit of service to that effect on the returnable date. Full stop. You have got copies of the memorandum of appeal.
My lord, I have only received, my lord.
Copies of the memorandum of appeal shall. There are two appeals. Listen. Copy of the memorandum of appeal shall also be served on the learned advocate for the respondent authorities in the meantime. Full stop. The matter shall next be listed on August. When? 1 week or 2 weeks service?
1 week is sufficient.
August 18, 2025, when an affidavit of service shall be filed by the appellants.
Wait for the lordship.
Next. Mr. Sahu was yes.
Lord, kindly see the order. I have
So
got,
bad.
I have
So good.
nothing to make.
You're for the
Yes,
respondent.
so for the state, I have got nothing to say. Kindly see it.
My
Lord, judgment.
Your Lordship, before that, Your Lordship
He
kindly.
has got nothing to submit because there is nothing in the order, or because of the.
I have something to say. Your Lordship kindly see the order dated 10th July 2025. My order passed by the Justice Bossard. Your Lordship kindly pass.
10 July, yes.
Yes. Your Lordship kindly see.
Let us see.
In this matter, I am led by Mr. Mitra, my Lord. Your Lordship.
Yes.
Order এটা দিয়েছেন আরে এটা অর্ডার তো ওর মধ্যেই আছে
What was the prayer in the writ petition?
Prayer of the writ petition was, my lord, for cancellation of the acquisition proceeding. The land, actually, it has not been acquired. In spite of that, my lord, they have treated that land has been acquired. That is why we have, my lord, the assault in the writ petition by saying that the provisions of the Land Acquisition Act, which has been, my lord, started from section 4 to onwards, that has not been complied with. In spite of that, they are treating the land as if the land has been acquired to the state of West Bengal.
And what was the order of the learned single judge? Let us see that. We start from there.
Before that, Your Lordship, kindly just bear me, short fact.
Absolutely, yes.
My lord, the land, my lord, my lord, in the CS record of right, it has been recorded as 655.
6. Please use the microphone, Mr. Sahu. Just come closer. Yes.
Yes.
Recorded as?
In the CS record of right, the plot number was 155. And in the LR, I'm, my lord, stating this very short fact of this case, it will be clear.
Plot number 155.
155.
In CS.
CS. And LR, my lord, the 611. Total area about 1.72 acres of land.
No, plot number 155 became 611.
No. In the CS record of right.
In the CS, plot number 155.
55 and LR, it is 611.
The same plot.
Same plot. Plot is same.
What about RS?
RS is, my lord, the revisional record of right. Which
Yes, we know that.
Under the provision of
What
estate
was the
acquisition.
number given in the RS record?
RS, my lord, prepared in the stage of the estate acquisition. LR is under the land reform.
The plot number remained the same in the RS and the CS?
No, it will be changed. In this,
it was changed.
It
LRs
was
will be.
changed. But the
Very well. The RS were not then bothered about.
now at present, you say kindly say 611. Area about, my lord,
1.72 acres.
Yes. Originally, my lord, the land belongs to the original owner. We have purchased this property in the year of 2019. Before that, before selling the property, the owner of the land, my lord, ascertained from the Land Acquisition Authority by submitting application under the RTI Act with a view to know whether land is, my lord, under the in any acquisition proceeding or not. The Land Acquisition Authority, in reply to that, my lord, the RTI application, stated that yes, land has not been acquired.
Those are all annexed here.
That, all documents.
Very well. Then what happened?
Thereafter, my lord, or in the LR record of right, it is found that in the, my lord, the Montobbo column, that is a recommendation column, remarks column, the name of the, the PWD roads has been recorded in
name of
the PWD, Public Works Department.
PWD, yes.
Yes. In respect of small portion of land, it has been recorded in the, my lord, the remarks column. As soon as, my lord, I got the, my lord, the reply from the Land Acquisition Authority, I made an application to the BLLRO concern by saying that yes, you delete the same. My lord, after query, my lord, they have issued the letter by saying that yes, wrongly it has been, my lord, recorded, you make an application for deletion of the same. Accordingly, my lord, we have made an application, my lord, to the BLLRO for correction of this. Thereafter, what happens? Subsequently, it is found that at the instance of the Jela Parishad, there is a, my lord, the hotel in respect of only 3 or 4 decimals of land in the name and style of the, my lord, the Pather Sati. Immediately thereafter, we made an application to the Jela Parishad. Jela Parishad referred the matter to the PWD department. Now the PWD department, my lord, requested the district land and land Reform officer for inquiry and submitted the report. The district land and land officer, my lord, directed the revenue inspector attached to the office of the BLLRO for, my lord, the submission of the report. He submitted report by saying that yes, land belongs to the Rayati land. So he advised the BLLRO,
That means you.
yes, advise you to make an application for correction of the record of right. That is, this matter, this thing has been, my lord, the
So you had already made an application for deleting the name. That is the correction of record of right.
record of right. In pursuance of the, my lord, the direction issued by the DLLRO, we also made an application to the BLLRO for correction of this.
Another application, the previous
Yes,
application was.
my lord, my lord,
Anyway, what happened to that?
Thereafter, my lord,
Thereafter, Mr. Mitra came in
no, thereafter, your lord,
at this stage. This is how you can at least complete the,
yes.
this.
Thereafter, my lord, the district land and land officer, ADM district land officer, on the basis of the application made to the executive, my lord,
No, made the application before the BLLRO.
I have done it, but they have not done anything. Thereafter, my lord, at the instance of the, my lord, the ADMLR, a notice was issued to the Public Works Department, Jela Parishad, as well as to ourselves for protection of the record and to decide the issue. The ADMLR proceeded with this matter, wherein the Public Works Department, my lord, failed to produce any document showing
DLLRO.
DLLRO has, my lord, all document that is there. I will show you.
Now, how does he come in? BLLRO had to do it.
No, my lord, as the Public Works Department, name of the Public Works Department has been recorded in the remarks column.
Yes.
That is why we made an application
before the BLLRO.
BLLRO. Thereafter, my lord, we make an application to the Jela Parishad. Jela Parishad referred the matter to the Public Works Department. Next, Public Works Department requested the ADMLR to decide the issue. Now, for deciding the issue, the DLLRO, my lord, made an inspection through the BLLRO by the revenue inspector. Revenue inspector, my lord, submitted a report in our favor. This is the, my lord, the whole catch.
Ultimately, you will be asked to decide your own.
Thereafter, my lord, we have
It's totally circular now.
Yes. Now I have been asked to make an application for correction of the record. We have done this.
What is your grievance in the writ petition?
Now, my lord, also, my lord, without considering our case, now the Public Works Department make an application to the BLLRO for, in the meantime, my lord, our name has been recorded in the record of right. We have also paid rent.
How was it recorded?
Our name.
Records were not corrected. PWD, regarding a small portion, PWD name is there.
Our name has been recorded in the record of right as a riot.
Huh.
But in the remarks column only, it has been recorded that yes, PWD.
So where you are paying your whatever.
Our name has been recorded. We have also paid rent. Everything is.
No, still, we have not come to the grievance in the writ petition.
Now the grievance is, in the meantime, my lord, the Public Works Department came to the plot and tried to disturb. We, my lord, made an inspection before the BLLRO. What happened? Now the BLLRO has said that a proceeding was initiated under section 51A4 of the Land Reforms Act at the instance of the Public Works Department. Accordingly, we made an application for obtaining the certified copy of the order, and they supplied the certified copy of the order. And in the
Land Reforms Act. Yes.
In the order, my lord, we have supplied the certified copy of the order. In the certified copy of the order, we have seen that a proceeding was initiated under section 51A4, a suo motu proceeding at the instance of the BLLR. PWD.
PWD.
Yes. Thereafter, my lord, it has been said that they made an application. That is why suo motu proceeding is initiated. That was, my lord, initiated on 10th January 2025. And next date was fixed on 20th January 2025, when no notice, nothing of the sort to us. They proceeded, at that point of time, the Public Works Department, my lord, they produced the notification of 3rd July 1946 notification. It has been recorded in the, my lord, the order by saying that the land has been, my lord, the requisition, my lord, say under section 4 of the Act of 91, and thereafter, after 3 years, 1884, Act 1, 1894. Thereafter, my lord, after expiry of 3 years, they said that section 6, my lord, the notification has been issued. For the first time, we came to know that this has been done. Now, assailing that, my lord, we made a writ petition before this honorable court, assailing, my lord, challenging.
Assailing what?
My lord, assailing that the, my lord, the proceeding, acquisition proceeding, which has been, my lord, the disclosed for the first time in the year of 2005, that neither the earlier owner has been received to notice, no, my lord, the
Acquisition had already occurred.
Well, it is for the first time it has been disclosed.
Disclosed, but it had occurred much back.
That is in the year of 1946.
It was acquired and given to the PWD.
That is, my lord, that is why, my lord, our dispute was that let the entire records to be produced for
whatever has been produced. What have you come
my
to?
lord, they before the learned single judge, my lord, they produce a report.
What was the writ petition for? Quashing the acquisition proceeding?
Yes, I have made a prayer was made for quashing of the acquisition proceeding and not to treat the land as if it is a.
You had to then challenge the acquisition order, the acquisition decision.
But no decision is there. We made an application under the RTI Act. The collector says that no, it has been not been acquired. That has not been.
What was the relief sought in the writ petition? Where have you annexed that?
Yes, well, kindly see the prayer.
Where is the prayer page?
Yes, Lord.
Give us the page.
Yes.
You can give us the page.
Yes, yes.
Page of the prayer.
Yes, yes. Your Lordship, kindly come page 78.
Page
78. 78.
70.
78.
78. 78. Sir, आपने बोलो.
Kindly see their prayer, and my lord, whatever submission he is making, I think, my lord, it is out of the sync.
Say so.
Sync.
What is this prayer, Mr. Shahu? I think better let Mr. Mitra take over before.
But to my lord.
No,
we are telling you, you have made a prayer. No, please let him finish. You have made a prayer that writ of mandamus in the nature commanding respondents not to treat the land situated at Moses such and such as acquired land. What sort of relief is this? Either you challenge a specific acquisition.
No, thereafter, my lord, I have prayed for.
Or you pray for, seek a declaration of title before a regular civil court.
No, because your lordship.
Or your rights, not title, maybe your rights in respect of that property.
No, your lordship.
Seek a regular declaration before a civil court. What is this prayer? Commanding them not to treat the land as acquired land.
Yes.
Either it's an acquired land, then they have to treat it as acquired land.
Yes.
If there is an acquisition, then they have to treat it as an acquired land. Or there is no acquisition, then in any event there is no question arising out for this. It's a vague cause of action, non-disclosure of cause of action.
Your lordship, kindly see. Now your lordship kindly allow me to.
Either it's acquired, then you have to challenge the acquisition, or it's not acquired. Then you have to file a civil suit seeking declaration and injunction.
For that purpose, my lord, we made an application under the RTI Act with a view to know whether it has been acquired.
They say no, not acquired.
No, it has not been acquired. Whether compensation has been
then
paid
it's not acquired.
Nothing has been. Your lordship,
So,
kindly.
what is your cause of action? How are you affected?
Because my lord, now my lord, our name was recorded in the record of right.
It's still there.
No, they have deleted our name. As soon as the order has been passed by the BLLRO, immediately our name has been deleted, and the entire, with regard to entire plot of land, the name, the name of the Public Works Department has been
Deleted under which provision? 51A.
51A.
No appeal is maintainable against that. You challenge that order before the writ court.
Yes, your lordship, kindly.
But this writ petition does not challenge that order also. Then you challenge that order, 51A order before any.
No, I have challenged the, my lord, the acquisition proceeding because, my lord, unless and
until. Not challenge the acquisition proceeding. You have stated that they may not treat this as an
Yes,
acquired land.
my lord, your lordship kindly say in the read application.
Kindly goes through the, my lord,
No, no,
the,
your lordship kindly.
impugned order.
No, your lordship kindly, my lord, I have stated in the writ petition by saying that when, my lord, I have purchased the land from the erstwhile owner.
Let us come to the impugned order once.
Yes, your lordship kindly. And before that, your lordship kindly.
No, first the impugned order.
Yes.
Then everything else.
Yes.
Sir, आपने बोला? Impugned order passed by the land single judge, my lord.
স্যার মিষ্টিও পাই না আপনার বাড়িতে এবার মিষ্টি খেতাম আর মিষ্টিও পাই না
That's how perfectly justified order.
By the land single judge. Well, I will show your lordship, but your lordship can allow me.
Your grievance is absolutely right. Your grievance is against that order of the BL and LRO.
No, your lordship kindly see. The
Because your names have been changed.
name have been changed on the strength of the your lordship kindly see on
If
the
you
base-
have a grievance against that order, prefer an appeal before the tribunal.
your lordship kindly see. If my lord, if I prefer the appeal before the tribunal, tribunal will say as the land has been acquired, the tribunal has got no jurisdiction. It is not under the specified act. It is not specified act.
No, land acquisition is not specified.
No.
Let Mr. Mitra come, then we can deal with one blow at a time. Mr. Mitra, please come forward.
Thank you.
Mr. Mitra, you are not challenging that acquisition because you obtained information asking and they said that there is no acquisition.
I must frankly confess that it has not been, the prayer has not been drafted in the way perhaps I would have liked to have drafted. But then again, my lord, the crux of the matter is there. I tell you, lordship, how it happened. But will your lordship, my lord, kindly allow me to just place a few of the documents to show.
Mr. Mitra will look into that, but just tell us,
Yeah.
have you challenged any acquisition proceeding in your petition?
Yes, I tell you, lordship, how I have challenged it. They say, my lord, at the last moment, they disclosed a document purporting to show that there had been an acquisition in 1947. And a notification that a notice under section 4 was given. My lord, your lordship knows for the purpose of completing acquisition, section 4, section 6, section 7, possession, section 9, section 10.
That has lapsed.
But they have not done anything of the sort. They did not, so to say, complete the acquisition proceedings in the way, if there had been any
Sir,
acquisition.
Mitra, either you could challenge a notice under section 4, which you could have understood,
Yes.
or you could have sought for a direction from a civil court that The acquisition proceeding has lapsed.
But we did not know even of section.
Now you know.
Now
Because you have, before filing the writ petition, you know that there is something.
Meantime, I have been dispossessed. Well, kindly see.
No, but in the writ petition, when you file the writ petition, Mr. Mitru, you are aware that there is a section 4 notice which has not culminated in an acquisition proceeding.
Yes, that was.
If that be so, you could have sought for a relief in the writ petition itself, challenging that section 4. It has lapsed.
No, but then what happened was this. There was no authentication with regard to that. That is why in the last order passed by this honorable court, it directed the state of West Bengal to come out with the fact. And a report was directed to be filed by this court.
That has not been filed.
I do not know whether we have not been given.
Whether regarding whether there has been an acquisition or
See
not.
the last order.
Justice Boshak's order, yes.
Justice Boshak's order. Kindly see, man, because we were all in a state of.
So either you have to challenge acquisition order if there is any.
Perhaps I will.
Or that BLLR.
I will
but
have
these operator, but BLLR order is again dependent on that acquisition.
Yes.
Because that is the premise of the BLLR order.
Yes, correct. At the time when BLLR passed the order, we did not know of any acquisition. Because
have you annexed the BLLR order itself anywhere?
Yes, of course.
Let us just see that for once.
Your Lordship kindly comes to page 255. It's handwritten order. Taito?
Yes, yes.
Hearing was done ex parte, 20th January 2025.
It was a requisition. Oh, later on acquired, right?
And we did not know what's all this. I tell you, Lordship, why? Kindly come to a few of the documents I shall show to you, Lordship. Kindly come to page 197.
So we have to just first ascertain the scope of the challenge. What you can challenge and what you have challenged.
No, of course I shall come. I mean, definitely I shall come to it.
But let us just complete this order for once.
Yes,
Just the BLLR.
Yes, complete.
Sheet of the delivery, so that premises and acquisition.
Yes. Kindly note that 1.72 acres is recorded in various khatyans classified as badi, that is homestead land.
256 first paragraph says that there was an later on in notification number such and such, dated 18 January 1949, the plot was acquired in full.
That is what it says.
That is the premise.
That is the premise.
So then you have to challenge that.
Well, we have challenged this order, but then again, my lord, when we did challenge it, we did not have the notification. We did not know what it was all about. Then, my lord, the court directed the state government to come out with this report.
So let us ascertain from them first before you proceed further.
Yes,
whether
I don't know what report they have filed, my lord.
What is the report you have filed?
And we should have been given a copy of this.
My lord, I think, my lord, it was taken into account. My lord, it was there. My lord, I think, my lord, may I just make a humble submission, my lord, before the going through that?
Humility is appreciated, but the submission is not.
My lord, kindly consider one thing. First of all, my lord,
it is key. So you have to circulate copies among them, sir.
My lord, it is, I think, my lord, it was served upon them.
Who served when? Do not say, I think it was served upon.
Your thought has to be substantiated by some receipt.
বেলেরও দিয়েছে
কাকে দিয়েছো? জজ সাহেবকে দিয়েছো না আমাকে দাওনি?
My lord,
Then served on us.
no, my lord, I think, my lord, subject to my lord's kind approval, my lord, I am making one submission. My lord, I could have understood they were not present.
When?
At the time, the BLR was ordered, my lord, that is 22.
BLR order is based on an acquisition,
yes,
which they cannot find any document.
Now, my lord, kindly see, preferred, my lord, appeal. Appeal is pending.
Against BLR order, an appeal has been prepared.
Yes. My lord, kindly see the order.
No.
My lord, kindly see the order.
That is the remedy available to them.
No. Kindly see the order, kindly. My lord, kindly see the order. My lord, the relevant portion, my lord, kindly come to page 2, paragraph 6 from bottom three lines.
Which two of what?
Read, whereas the present writ petitioner are advised to
Appeal was
approach the
preferred.
jurisdiction BLRO. Kindly see. BLRO, that is respondent number 7 for correction of record of rights. My lord, kindly come to page 2. It is submitted pursuant to such advice, writ petitioner approach the jurisdiction respondent authority herein who under cover of this order dated 21st, my lord, actually is going through that. 21st January 2020 as passed in miscase number came to a contrary finding that the aforementioned plot of land was acquired in full for public purpose. It is thus submitted by Mr. Banerjee that on account of such contrary stand as second by the respondent authorities in absence of material to substantiate the aforesaid plot has at all been acquired. There cannot be any difficulty to issue appropriate as straightforward. It is thus submitted that the appropriate writ may be issued against the respondent for removal
Para
of
16
structure.
says they have already
Now-
preferred an appeal against under
Yes,
section 50.
now, my lord, yes.
What
my lord,
happened to that appeal?
my lord, whether it's pending. My lord, kindly consider I am taking into consideration of the learned judge, honorable single judge. Kindly consider that. Mr. Submission, my lord, my lord, kindly see. An appeal was preferred. My lord, kindly see. That is page 3 of the impugned order.
We only ask for a report. We are not asking for his submissions now. Let us hear Mr. Mitra.
This is the report.
And give a copy of this to him.
My lord, may I submit one another report, special land acquisition officer?
You three submit between yourselves. And one of you submit to us.
এটাই আরেকটা কপি আছে জিনিস কি একটু
তিনটে রিপোর্ট এসেছে তিনটে ডিপার্টমেন্ট থেকে এটা ল্যান্ড অ্যাকুইজিশনের দিয়ে দাও
আর এটা দুটো করে তো কপি লাগবে
Affairs of the state are worse than state of affairs.
একটা
Is it
এই ওটা দি
Please check up whether you have served on the other side.
দেখি কি দিয়েছে
Sir,
সেট অফ
please check up. আবার ফেরত দিন।
কপিটা তোমরা কি দেখাচ্ছি জজকে তাই বুঝতে পারছি
এটা হচ্ছে একটা
What are you relying on? You first yourself verify what you are handing over.
তুমি নিজে পড়েছো
আমি স্যার পড়ার দরকার নেই পড়ে সব ইয়ে হয়ে গেছে এটা আপনাদের দেওয়া
স্পেশাল সেক্রেটারি এই তিনটে
এই নিন স্যার তিনটে রিপোর্ট আছে
Well, 3 documents have been handed over to me. I don't know whether your lordship has got copies of this.
No, we have returned everything.
Oh, I see. There is one brief status
You don't know what is being, something else is being given to and something other is being given to us.
I think, my lord, perhaps these
They don't have 3 copies of any of the
given
documents.
one document, I am told.
They have not taken anything.
যশোরের কাছে দুটো কপি আছে
I think এগুলো ফাইল করো এগুলো formally file করো
একটা দিচ্ছে একটা সেট দিচ্ছে
Well, I don't know whether something has been handed over to me, whether I should accept it or not.
may I make one humble submission my lord this
They have
is
made several humble submissions.
this is my lord after all this is an appeal My
Is
lord,
it? We thought it was a civil divisional application.
My lord, kindly consider one thing. My lord, kindly consider one thing. My lord, kindly consider. Just give me 5 minutes time. My lord, what is this grievance? I just put that question to myself. The grievance, I could have understood they have challenged the acquisition process.
We are telling you the grievance.
They did not.
We are telling you. You don't have to ask yourself, we are telling you.
Yes.
2 components.
Yes.
DLLRO order has relied on a purported acquisition proceeding and refused their pair of correction.
Yes.
Saying that no, you don't have a right.
Yes.
Against that, they have preferred an appeal under 51A6, which is pending. The scope of that appeal is whether BLLRO was correct or not.
Correct or not.
If there was actually an acquisition proceeding, then BLLRO would be correct, that appeal would fail. So therefore, now they want details of that acquisition proceeding so that independently they can challenge that acquisition proceeding, which was the premise of the BLLRO order. So there are 2 branches of challenge. One is DLLRO. Before the DLLRO, they have challenged the BLLRO order, which is subsisting. They want to independently challenge that acquisition proceeding. If they succeed in that challenge, the premise of the BLLRO will go and they will win this appeal, and vice versa. So therefore, just furnish the details of that acquisition proceeding so that they can, we'll give them liberty to challenge that.
My lord, kindly consider one thing.
No, we'll not consider anything. Just give us the details of the
Yes.
acquisition. No, give us also.
No, 3 copies are there.
Please take out uniformly 3 similar copies
Yes, yes,
containing same documents. We'll take it up tomorrow. Please do that and come back.
একটা কপি দিয়েছে একটা কপি দাও তুমি আর
Please don't do it like this. Don't do it like this. This is becoming a, I mean,
yes,
don't make a mess of it. Please check whether there are 3 exact similar sets. Then circulate among them. Please give to them one such set. They'll go through it.
আমাকে একটা পুরো সেট করে দাও যেটা
Mr. Sahu will let us speak with you. So they'll give a copy of the entire set to you. They'll give file on the next day before us. And we'll give you 1 day's time to consider this, whatever is handed.
Absolutely.
We'll take it up day after tomorrow. Order now.
If necessary, we will make an exception. If necessary, we will make an exception to the report also.
আগে দেখো কি
No, you cannot make an exception to the report. Those disclosed facts regarding the accusation, we are not taking them as pleadings.
But theoretically, they are saying that we have preferred an appeal. For the appeal court, we have specifically stated before the learned single judge that we have not preferred an appeal.
51(6), there is no appeal.
We have not preferred the appeal. At least that is my instruction. We have not preferred the appeal.
You are challenging the accusation proceeding.
Yes, yes. I don't know who has preferred appeal and whose appeal my learned friend is referring. Well, may I?
The learned single judge referred to an appeal.
No, your lordship kindly sees, yes, this is what has been submitted. And then when we controverted that, then the learned judge was pleased to direct you,
Then we'll direct them to file a short affidavit and bring everything.
Yes, I think, my lord, otherwise.
There is no scope of an interim order here, but because court has.
No, but I don't know. There is no scope for passing an interim order. Already, my lord, they have sought to correct, my lord, the record of rights.
Abide by the result, usual. Whatever.
Well, yes, kindly, my lord, give a short date so that, my lord, your lordship can look into.
You have all the documents. Please file your affidavit in opposition within a week. Since most of the documents sought to be relied on by the state are available to learned counsel for the state, as is apparent during the hearing, full stop, comma, the respondents are directed to file their affidavit in opposition to Can 1 of 2025 within a week from date. Reply, if any, shall be filed within a week thereafter. The application bearing Can 1 of 2025 shall be listed for hearing next on August 26, 2025. Any action taken in the meantime shall abide by the result of the appeal.
Lordship. My lord, may I submit one thing? Subject
One
to-
brief history is there on record.
Yes, yes,
You had previously given it probably.
Yes, my lord.
We find it on record, a brief history.
We have
Of time, no, not of time, of this matter.
not been served.
Well, in fact, my lord, on the last occasion before the honorable division bench, my lord, the state could not come forward with any facts. That is why the court directed that, look, you file a report stating exactly what has happened.
And
that
now,
report,
my lord,
my lord,
the
has been
chapter
filed.
is why
One
it
month
is-
has been filed.
This
No
is
comment
report
yet.
has been merged with the, my lord, the final judgment. My lord, only one thing, my lord, kindly consider. My lord, before the
Section
ballot has,
order,
my lord, kindly come to page 4 of the, my lord, impugned order. My lord, paragraph 12.
Read out.
My lord, I am reading out. It appears to this court that the writ petitioner practically aggrieved with the finding of the jurisdictional BLRO, that is the respondent's hearing, in as much as in his order dated 21st January 2025, in miscase number such and such, as passed in a proceeding under section 51A of the said act. And the said respondent authority declined to revise the record of rights in respect of the aforementioned right. So now question remains, my lord, there is right to the appeal. Now, my lord, another thing, my lord, kindly consider. My lord, whatever, my lord, statement or contention has been made in the writ petition, he cannot.
We are again repeating what you said. Because you are busy in discussions, we are repeating. DLLR has passed an order.
Yes.
In respect of revision of record of right.
Yes.
That order was passed on the premise of a purported acquisition proceeding which took place already.
Correct.
On the basis of that, the BLRO passed its order. There is a provision of challenge under section 51A(6) against that. They say they have not preferred such challenge, but learned single judge says that they have preferred a challenge. First, we'll have to ascertain whether there is any such challenge. If there is any such challenge, the scope of it is limited to the legality of the order of the PLLR.
Absolutely.
The attention span is very small.
Yes.
We'll try to prolong it. We'll succeed after the hearing is over.
Say respondent authority.
No, it's very short. Please increase your attention span when the court is speaking. Now, this order is passed on by the BLRO. Even the scope of an appeal against that order would be whether the order is legal. The order would be legal if there is actual an acquisition.
Right.
Therefore, we want to know whether there is actual an acquisition proceeding.
This is exactly what.
The second prong of challenge by them will be that acquisition proceeding they are challenging, because they say section 4 was never culminated in an acquisition. So please disclose the details in your affidavit of that acquisition which you are now trying to do.
My lord, may I
Do that.
Yes.
If you do that, they'll
Yes,
have
I will do that. But may I give a reply to some extent? my
no.
lord?
When we take up the matter.
Yes.
Next matter.
This is what has fallen from your lordship was exactly what my lord, my learned friend was not there. They could not answer. That is why court said
They could not answer because they could not understand. Because Mr. You have to understand that, Mr. Mitra. They could not understand. That's why they could not answer.
My lord,
We hope now they have understood so that they can answer on the next occasion.
very clear.
And if they've yet not understood, you will win this appeal. Yes, Mr. Kormakar, you have to say something.
Next matter.
Yes, call on the next matter. Yes.
That contempt will not matter.
Which content matter? We are regularly not past the direction. That content. So we'll pass that order.
Lord, with respect to disconnection of the electricity line.
Asha is 4:30, so we have heard, but due to positive, we cannot give your names.
Lord,
You have to file affidavit.
This is affidavit of compliance. Lord,
Compliance. You agree? Complied.
Lord, I have no.
Get so disappointed. If it's complied, then
Lord, the direction, it has been challenged to, my lord's order was assailed before the Honorable Supreme Court. Your Lordship wanted, Lord, all the contemners should come up with an affidavit. Lord, the Honorable Supreme Court, at their instance, the Honorable Supreme Court, Lord.
That order was challenged, that directing everyone to.
Only, Lord, restricted to everybody because, Lord, their directors.
So
Lord,
that has been allowed,
that has been allowed. Your Lordships may kindly see page 7. This is the modified part of the order. Page 8, sorry. 8 or 9. 8.
I mean, why? Because he's the person who.
He's the main person who was in charge of the hotel here. Lord, this related to that repairs of the hotel, Lord.
So you are that person, so you are saying that it has been complied with.
Yes, Lord, I have filed an affidavit in terms of your Lordship's order.
Yes,
Lord,
as modified by
as modified by the Honorable Supreme Court. Modification is only, Lord, a single person.
So that you have done now.
Everything remains same. Your Lordships will find from paragraph.
Have they complied?
Lord, I have the connection for the time being, and they have undertaking that they will not be issuing any further notice.
Undertaking in content here.
Yes, paragraph 8 onwards, your Lordships will find. Or rather 9 onwards, sorry. Paragraph 39 of your Lordship's order is paragraph 9. But rather paragraph 11 is the paragraph 11. Correction, Lord. Paragraph 11 is 12. And 12, Lord, be paid.
Oh, that matter. That content. Oh, you are directing them to vacate.
But,
very unfortunate.
So we learn a lot of things. No, not only that, but here
No, Mr.
they
God
have
save
learned,
the day.
they have learned a lesson. They have learned a lesson. So I'm sure, Lord, next time there'll be more.
We'll accept the apology and it is pointed out to us that a challenge was prepared by the alleged contemners to an order passed by this court, whereby you had directed all the alleged contemners individually to file affidavits, comma, limiting the scope of filing affidavits to the alleged contemner number 11. Fullstop. Pursuant to such order, comma, an affidavit of compliance filed by the alleged contemner number 1 is placed before this court by the learned senior counsel, appearing for the alleged contemners. Fullstop. Next para. We find from the said affidavit, comma, that the alleged contemner number 11 has expressed unqualified apology for having issued a vacating notice dated August 27, 2024, comma, in contravention of the order of this court not to disturb the peaceful possession of the petitioner. Full stop. Next para. However, comma, it has further been stated that the said alleged contender undertakes not to issue any such further notice to vacate, asking the petitioner to vacate the suit premises and or make any other attempt to disturb the peaceful possession of the petitioner in respect of the suit premises. Full stop. Next para. It is also undertaken in paragraph 12 of the said affidavit of compliance that the electricity supply being provided to the present to the petitioner at the suit premises shall be sustained subject to any leave or order passed by the court granting permission to the alleged contemners or the respondent in the appeal to do so. Full stop. Next para. In view of such unqualified apology and the express undertaking of the alleged contender number 11 to comply with the order of this court and not to disturb the peaceful possession of the petitioner in any manner, and explaining the circumstances of how the notice dated August 27, 2024 was issued erroneously, comma, we accept such apology, and particularly, comma, in view of the contumacious act having been purged. Full stop. Next para. We decide to drop the contempt proceedings. Full stop. Accordingly, have you given any further letter withdrawing that vacating notice? No.
Not yet, but this is the undertaking that your lordship wanted us to give in terms of
This
your
is
lordship's order.
well. Drop the contempt proceedings. Full stop. Accordingly, CPN 345 of 2025 is disposed of as infructuous without any orders to cost.
Much obliged.